low key. Niggas hating cause they don't want no beef. State gang, true sippers, bitch, I bet we don't eat.
Please be seated. Your Honor, the jury is all present and accounted for.
Good morning, everyone. We are back on the record. C-377-C-39, State Violation for the Deputy District Attorney on behalf of the state, we both parties stipulate to the presence of our jury.
Yes, Your Honor.
All right. The state rested their case yesterday. Defense, do you have any witnesses you intend to call?
Yes, Your Honor. We're going to call Sean O'Brien.
I do. Sure. Sean O'Brien, Sean Obrien.
Good morning, Miss. I'm sorry. Good morning, Mr. O'Brien. How are you doing?
Pretty good.
How are you employed?
So I'm employed with Roll-Off to Digital Forensics.
Okay, and what's your position there?
I am a digital forensic examiner.
Okay, can you give us a description of that job? What are your duties? What do you look at? What do you do?
Sure. As a forensic examiner, I look at any type of digital devices, digital artifacts, just pretty much anything that you can connect to the internet or even standalone, not connect to the internet, but it's digital in nature.
And about how long have you worked in this field?
Over 20 years.
Okay, you want to tell us about that, previous job assignments? Give us a little bit about yourself.
Sure. So I started off, I got a little intro to it whenever I was active duty in the Army. Got out of the Army, got recalled after 9/11. From there, moved on to the Air Force Office of Special Investigations Laboratory in Lithicum, Maryland. That's where I began my forensic journey, starting at the ground up from the basic taking a device and capturing it, as you saw earlier. From there, I got lots of training. I'm a Department of Defense certified forensic examiner. I also hold certifications with Cellbrite and Magnet and various other certifications related to the field. I worked there for about 9.5 years. I started off, like I said, it's technically called the imaging and extraction section. From there, I moved on to becoming a full-fledged examiner, and in that role, I was part of a child exploitation division that combated child exploitation and just all the different digital devices associated with that. From there, I went to the counterintelligence, counterespionage section and worked there as the deputy section chief. So I had a team of people under me that I mentored and taught how to do more advanced digital forensics. From that point, I went on like a little teaching circuit around the world to teach more stuff on like sexual exploitation type material. And then after that, I spent a little bit more time there at, it was called DCFL at the time. And then I switched over to Navy NCIS. I was offered a position to go start up a digital forensic lab, or restart a digital forensic lab in Naples, Italy. I was the sole digital forensic expert for Europe and Africa and backup for the Middle East. I covered all those countries. As part of that duty, I also worked in hand and on location with essentially like the special forces of the military police for Italy, and worked in a lot of like terrorism cases and stuff like that with them. I also worked with NATO, establishing the baseline digital forensics standard operating procedures so that everybody in NATO would have a baseline, because you have a lot of different economics, like there's very wealthy countries in Europe and there's not so wealthy countries in Europe. So trying to teach them how to do forensics with the bare minimum, because a lot of the tools are extremely expensive, and just teaching them how to balance the cost versus that. I spent 8.5 years doing that. I had to return to America, and I started working for the Veterans Affairs in the Office of Inspectors General. I ran the e-discovery division. It's essentially, it's not forensics, but it is in a related field, and I managed a team of people that would pull emails and do examinations and help agents and other requesting officers or parties to do audits and things like that. From there, I left and came over to roll off digital forensics, and here I am today.
All right, so now you work for your forensic company. What are some of the programs or software that you use in your role at your current job?
So my primary tools are some of the ones that you've seen here. Cellbrite and Magnet are probably the top two that I use.
All right, and then what about any certifications on those programs? Any training on those programs specifically?
I'm certified with both Magnet and Cellbrite to be an examiner and like to extract the devices, to get the device and get the information off of it and then process it and review it.
And so when you're not just talking about cell phone like pictures and things like that, you can also look at locations and all those types of things as well that go into anything with the digital forensics, correct?
Correct. Cell phones are essentially databases, so it's looking at all the different databases, some that can be seen, some that can't be seen in particular readers, so you have to use different tools to get to it and look at the data inside of those databases.
So I'd like to turn your attention to this case. Myself and Mr. Drastovich called you to hop on to this case and help us to go through, I believe there's what, 6 terabytes of discovery on this case to go through?
There is a
Something like
plethora.
that. There's a lot. And we asked you to look at a few things. What were those?
So cell phones, the cell tower records, looked at the Barilla extraction of the infotainment center. So everything that has to do with the cell phones, the cell towers, and the vehicle.
Okay, so right now I'm gonna turn your attention to the cell phone examinations. You were tasked to look at certain things dealing with cell phones, correct?
Correct. I was primarily focused on 3 different cell phones. The cell phone of Devyn, Jonathan, and Devyn.
And did you have an opinion on the accuracy of the information that was given to you?
I mean, accuracy, it's the data that's on there. Are you asking more like, was there anything that stood out, or?
Well, was it the accuracy of the extractions? Is there anything that was missing or that you would have liked to see more?
So as previously stated, the cell phones are made up of databases, and I stated that the software doesn't always pull all the information. So the information that I was provided was a UFED reader report, which is after you do an extraction, you take that data, you put it into another piece of software, and then you can create a reader report, which is what I reviewed in this. That is only the data that is able to be interpreted by the software. So I found it problematic because over my review and looking at everything, it's only, of all of the apps that are on the phone, the average between the 3 devices was only 3% of the data was displayed and presented with the databases backing it up.
So would it be your opinion that this was incomplete as what was provided to you as a whole?
Yes. And
what's the basis for your opinion on it being incomplete?
Years of experience and knowing that one tool doesn't do it all, and that whenever you look at that and you see something as low as 3%, like, okay, well, what else is there? What am I missing? Personally, if I pull up Cellbrite, I'm looking through it, I don't work off of reader reports. It's a bad practice because, again, you don't have all the information. I typically use Cellbrite as an initial tool. It's very good, it's accurate, it's accepted all over the world. The data that it displays is great, the way that it displays it is great. But sometimes you're like, well, I want to know more about that. And if you're in a reader report, you can't go back to, say, a database that holds messages and be able to find out more information about those files and to look in the databases and see the different information. So not having that is problematic. And then I typically use other tools. So if there's a database I can't get into, I could run it against, throw it into Magnet Axiom and be able to pull that up and look at it in a different tool to try to verify information as well as see if there's any additional information that can be gleaned. If there's databases there that I can't get into, then I can pull it like DB browser or some other deconstructing tool that deconstructs the database so you can look at it in different manners.
And I believe it was yesterday, Detective Campbell came in for the state and testified about UFD, and I'd asked him some questions about UFDR. And could you kind of explain to the jury the difference between the terminology before we go any further?
Sure. So whenever you get a cell phone, if it's all right, I'd actually like to start prior to that, if that's
Of
possible.
course.
Okay, so whenever I've been to many crime scenes and was the person that collected the digital evidence and worked it all the way to trial, as you see today. The standard procedure is to get on site. What's this case? So first of all, you have to figure out what's your scope. What are you looking at? What do you have authority to look at? What type of evidence can you get? So first thing I do is I look after all the photos are taken, because that's the first thing that happens. The crime scene investigators come in, they take the pictures, and then we go in, we start doing a search. If I see anything that's digital in nature, I stop. If I don't have a camera on me or there's another person that's assigned to take pictures, that person would come up, or I would come up, take a picture in the state that it's in the location that it's at. And then from there, once that's been categorized and like logged down, then you would take that, secure it from being connected to any networks, so turning off data, put it in airplane mode as a bare minimum. From there, you would then, if you're not processing it on scene, you would put it in a bag, seal it, evidence tape, do all that, take it back to the lab, take it out, and then begin your extraction. So that, we're going to use a phone for this example. The phone that was collected, I would connect that to it's called UFED, and there is a UFED for PC, which is software that's on a laptop, and you can connect the phone up to it, and it starts extracting the data from the phone and puts it on there. There's also like mobile UFED devices that you can be in the field and on the crime scene and plug it in. So there's multiple ways to get that data through Cellbrite, and what that does is it builds a UFD. And that UFD is more like a index and some supporting information that tells you, hey, in this big package of data, which a lot of times it's in a zip file, and it's the package that the UFD is going to refer to that actually has the databases and the information. So you load that into Physical Analyzer. So Cellbrite has a product called Physical Analyzer, and Insights is their newer version. And you can put the data in there, and that gives you access to the databases. And you can actually do some database, like go through the database and break it down inside of that software as well. You can use, it's called App Genie, so it'll go in and it'll look at the app and be like, well, what can we do with this app? Like, what more information can we gather? Because, again, it's a vendor software, so they're only doing what the people in my field are saying, hey, we need this to be adjusted. We're not getting enough information for this. Can you turn your attention to there and try to get more information? So once that's all gathered, you go in, you're starting to do your examination, starting to find all your bits and pieces, finding out what databases you need to explore more, what information is important. And then the requester, which is usually an agent, a police officer, or auditor, whatever the case may be, they'll want to see everything right away. Unfortunately, digital forensics is not a right-away type field. It does take quite a bit of time. 6 terabytes is a lot of time it takes to get through that. So they'll want something right away. You create a reader report, send it out to the requester. That way they have just a first look of like, oh yeah, that's my suspect. Oh yeah, this is a message they talked about. And you can start to get little bits and pieces. It keeps them happy while you're doing the more in-depth stuff. It also allows them to say, hey, I saw a message on this day, but I can't find anything else that's around there. So they reach back to me and say, hey, this date, I need to know more. So then I can hone it in and be able to say, on this date, at this time, looking at these different databases, I was able to determine this or to provide more information. And then from there, you write up a report, you put everything together, and then it goes back to the report goes back into evidence if it's an evidentiary report. Again, you're working off a copy of the data, so the phone's already been put away. You don't mess with that anymore. If the extraction, like you drop a hard drive or whatever and it stops working and you have to re-extract, you still have that. And one of the other things to touch on that, there's a verification. So I know earlier in the trial there was talk about a hash value being a fingerprint. Same thing, whenever it does the extraction, Cellbrite does a hash of the data and you're able to just click on verify hash value to make sure that you're looking at the same data that you were previously.
So, in reviewing this and basing your opinion, what are we looking at here?
So right here, we're looking at this is the UFED reader report, and it has different data located there. So you'll see the file system, which is essentially the background of the phone, and it shows the different areas that databases are in. The one database that we'll look at in a little bit, or information that was supplied from that database, you can see I have typed out there the path that has the com.android.providers.telephony and the databases. If you look in the directory on the left-hand side, it does go in alphabetical order. So,
And Mr. O'Brien, if you
Sure.
want to use your mouse,
Oh, yeah,
don't
yeah.
click on it though, because of the
No
digital
clicking.
content, but
all right, no clicking.
but yeah, you
So,
can go ahead.
right here you see com.android Chrome, com.android vending, like wallpaper backup. So that only 3 com.androids were found, not the com.android providers. Like that whole directory structure isn't there to include the database.
So is this a complete picture of this phone?
It is not.
Okay. So did you also review the Armada infotainment system?
So I reviewed the portions of the Barilla extraction that were provided to me, which were the data locations where the vehicle traveled.
And so I'm thinking that we heard testimony about how Detective Campbell was told, or I'm sorry, it was Detective able to go through and kind of ping along how I'm sorry, Detective Spangler, all these guys with these technology and phones, I apologize. Detective Spangler was able to go and follow the infotainment system, where the car went, when it started, when it stopped. You saw that, correct?
Correct.
And I believe it was brought up that Miss Michaels was at a car wash around a certain time. I believe it was between 8:14 and 8:24, and the state phrased it as a car wash, correct?
Yes.
And we asked you to look at the points at this supposed car wash, and that's what we're looking at here.
That is correct.
Okay, and we see that the kind of the top half of it, it's the gas station, it's a convenience store, it's not just a car wash. But what did you do here?
So the first thing I did was I looked here. This is the car wash. You can tell by the structure and the wet marks. And then if you do street view, you can go in and see that as well. So I noticed there's no pings along this backside or anywhere along the car wash area. I also looked at the date and times and the start-stop time of the vehicle, which also was indicative of not really enough time to get a car wash, not in the right location for a car wash. But it did show that there was activity under this canopy, which is where the gas pumps are, and is also where all the pins happen. The locations are all in the gas station area. Coming in from this side, going around into the area here, and then come out and leave that direction.
And just as a side, you shut off your car when you get gas, right?
Typically.
Usually when you're at a car wash, you leave it on, you're sitting there listening to music.
Or having to drive forward, yeah.
Correct.
Or neutral, let it go on its own.
So turning your attention to another item, did you review video data at 6505 Taylor Creek?
I did.
And what is your opinion of what was recovered from that address?
So again, I believe it to be incomplete just based upon the type of evidence that it is and the devices that it comes from. There are, as you can see on the screen, Two of them are labeled ring video, and the other one just has what appears to be a date timestamp and a .mov. The others are .mp4s. So the two videos on the right, the washed out one and then the one that's more in color, appear to be videos that were extracted off of either the Ring app or like you can go online to the website and pull it down, download it. You can share via email. There's lots of things that you can do with Ring videos. And the one on the left appears to be a few still shots that were then combined into this video that's there. So the snapshots being put together, I'm not sure how familiar you guys are with the Ring camera, but you can set it up so that it does snapshots. So you can I don't recall the minimum amount of time, but I believe it to be like minutes, maybe even seconds, and then from there you can go into like you can turn it off completely. So the fact that there are what appears to be snapshots would indicate that snapshots were being taken. And if only one or two snapshots were taken of that area, and I believe this is the one where you can see the house up on the, or the vehicles on the top right? Yeah.
It's this one.
So in this area here is the area of interest. So if you're having a lot of snapshots in that area, you're going to be able to see things coming and going. So you would be able to refer to those snapshots. However, in this exhibit, I did not see multiple, well, there were multiple, but not a plethora, not a whole bunch of snapshots to look through. It was just, hey, we collected these 2 or 3 snapshots because we see the vehicle there, and then done. But there's so much more that could have been collected on that and more information.
And you weren't provided any document from law enforcement that they were looking for snapshots of this camera?
I was not. I didn't receive any reports or anything on this.
Are you aware that any other videos that had been provided to you, anything else that you saw that was recorded except for what we saw here?
So there were, I looked at a bunch of different videos that were collected.
And let me, from
Sure.
this address.
From this address? No.
And that's because there could have been, but from what you saw, there wasn't anything done about the snapshots or anything. There was just that one.
Correct.
Now, I'm going to turn your attention to one of the phones we asked you to look at, and off of the information that was provided from the state. It was Devyn's phone. Did you review that?
I did.
And I want to get to was it a complete capture of Devyn's phone?
No, same as it's previously shown.
There wasn't information about every single app, every single activity that was going on.
There was not.
But even though we had an incomplete picture, you were still able to access some background information, some stuff from the databases that can tell you kind of what was going on.
Correct. I was able to access the reader and what Cellbrite was able to pull out and look at those provided items.
So what are we looking at here?
So here we're looking at on 8/6/2023 at 10:36 at night, there is communications, an instant message that was outgoing from, we're looking at Devyn's phone, so the outgoing would be the from, and then to the phone number related to the device of Devyn. So from Devyn to Devyn, their devices. It says, see you when you get back, I'm going to sleep, girls. So it's part of a text message. And then there's an incoming call at 10:58, which appears to be from Devyn's device to Devyn's device. And it appears that the call was taken and was 44-second long phone call. The last item is at 2:12 in the morning on Devyn's phone. There was part of the Android messaging here. There was a icon, so whenever you save a contact, you can add a picture to it, and just so whenever you look at it, it pops up, has the picture. So this is a picture like that.
And this is a little bit more information on that
Correct.
icon.
Same one, it just different slide. Same
timestamp.
same timestamp,
date.
same messaging, same area.
And this is just a close-up of the photo of the contact.
It is.
So it shows that there may have been some activity going on at that phone around that time.
Correct.
Now, in your experience and investigation and the roles of your work, gaming systems and other devices, not just cell phones or computers, but anything with hard drives, anything that's able to be communicated over, that would be important, correct?
Correct.
You would be collecting those things as you go through and see what's at the scene.
Correct. Depending on what the crime is, depends on what you collect. In a murder case, you're going to collect pretty much everything you can. You can do some field assessments and be able to look and say, well, you know, this device is dead. It's one of the examples was a really old like Nokia bar phone from in the early days. And if you're dealing with a crime right now, there's no power to it. It's stuffed in a box in the back corner and like in a storage unit or something like that. You might not necessarily take it. I mean, you could, but it's more, all right, well, we know that's there if we ever have a need for it. But in general, if you're doing what's considered a major crime, which murder falls under, you're going to want to take as much digital evidence as you can until you start getting more information.
Because in the beginning of an investigation, you don't really know what's going on. You're trying to collect anything that may have evidentiary value to later be examined, or if something comes about the investigation, you have that preserved.
Correct. And even in this case, so there was an additional cell phone, I believe it was Devyn's cell phone that was, okay, this is too old, the activity is too old, it's not really relevant to the specific focus point of this investigation. So again, collected as it should have been, reviewed, not relevant, set it to the side. So
here's a picture. It's one of the exhibits that has been admitted for the jury to look at. Just looking at this picture, do you see anything here that of evidentiary value that would bring you to preserve some of this stuff?
So I see two items in here that could potentially hold additional information. There is a Xbox on the
And I prepared it a little bit here just for you.
So it appears to be an Xbox here and then a Nintendo Switch here. And the significance of that is that both of those devices you can chat with people. You can communicate. There's multiple ways that you can do that. One of them you'll see in a little bit, like Discord is a really big gamers app. A lot of people that use Xboxes also use Discord as a communication method if the game that they're playing or whatever doesn't have it embedded, or if they just want to save speed or data just to make things more efficient.
But even in like a Nintendo Switch where you can switch out data cards to store things and add more games, or even Xboxes with hard drives to plug in for additional space, it can be just a normal hard drive. Those are things that you'd want to look at and see if they were there.
Absolutely, and they connect to the internet and you can browse the internet as well. So potential for communications that way on top of chat applications.
So going to other things that could have been looked at here, what are we looking at on this exhibit or this slide?
So this is showing that the Discord app was purchased through the Play Store on Devyn's phone, and it looks like 4/27/2023 is whenever it was installed. So it just shows that an additional chat application was on his phone that is also found on gaming systems.
And Discord, I know you kind of briefly touched on it. I'll let you explain that because you're more well versed in that. Can we just go through again for the jury what that is?
One more time, please.
What Discord is?
So Discord, a chat application, you can have it on your phone, you can have, there's multiple places that you can hold that, and it allows you to communicate back and forth via voice or text.
And what are we looking at here?
So this is another artifact related. Nintendo Switch was also found there. So there's an application that's listed as Cellbrite flagged it as entertainment and chat application. So it's another indicator. Hey, it's a possibility that the Nintendo Switch has chat on it. The application also allows for chat.
And that would be something of significance if you're trying to determine people talking about potentially a murder or anything, that you would go and look through all these things and all these apps to see which ones could communicate to other people, at least be looked at and investigated or preserved for a later time.
If you had access to those databases, yes.
And what are we looking at here?
We are looking at one of the applications that is related to Discord. And it's at 8/7/2023, 2:31 a.m. So it was an artifact at Discord. So you can see Discord up here. So it's at that date and time on Devier's phone, the Discord chat, or well, the Discord program was accessed.
And that was at 2:31 a.m. on August 7th.
That's correct. So it says modified. Anytime the system does anything to the file, then it would modify it because it's making changes.
And briefly, you didn't look at any router logs, did you?
I did not.
You weren't provided with any router logs?
I was not.
Nothing from the Porcupine residents about a router?
No.
That would have been helpful if you would have had that at that address, correct?
Correct. So as previously testified, the router holds information of connected devices. That's really important, especially whenever you're looking at an investigation like this, because if you know what devices have been connected, then you know what devices you don't have, or you can verify the devices that you do have. So you could look at it and be like, well, 6 phones show up on here, but I only have 5. Where's the 6th?
And some of these artifacts that we've seen, this could all be indicative of activity on either the phone or gaming systems. There's something going on, but we just don't know because we don't have the full picture.
That is correct.
And now we're looking at slide 18 on our presentation for the jury. What are we looking at here? Oops.
Okay, so you'll see in the next slide, it's the same slide as previously shown with the missing database. This lays it out a little bit more. So the native message here, which is found in this MMS SMS database, which we've already shown is not located on the reader report. It has a message in it here that says headed there now. We don't have a to, a from, a date. We have no other information other than it was deleted, which let me clarify that also. So here you see like messages in white, and then you see it in red. The red indicates recovered deleted items. So if it's red or it has this little red X right here, it means that that item is deleted, but the software was able to pull that out of the database.
But does it show a time or date or to and from?
It does not. And again, I couldn't go back to the database to see if there was any more information in there or related stuff around that time, like around that message, or looking at deletion orders, or there's no way to tell more information in the presented state.
But we know it's deleted.
We do know it's deleted.
And this is the slide that we talked about earlier.
Correct.
And it's about the missing databases and the different types of files, the UFDs, UFDXs.
So UFDX, I think that's a new term. New term for here. So if you have a UFD, it's the initial one, like I had stated about having a device, and you're looking at it's the UFD with the supporting data. If you take multiple devices, so in this case, if I was to take all 3 of the devices that I looked at, I throw them all into Physical Analyzer, I could create a UFDX, which is essentially multiple extractions put into one. So I can open that up, and by doing that, it loads all of the devices, and then I can run searches. Can you go back a slide?
Of course.
Sure. So up here, I can type in a search, and then if I click on this little down here, it will display each device that's loaded in and how many hits there are, and then you can select which device. You can select all, and then you can work your way through it and see where all that search term shows up across all of the devices.
And just because we've heard all these terms and they've been thrown out between yourself and Detective Campbell, what is the most complete extraction that you would like to have had on this?
I would have liked to have the UFD with the supporting files so that I would have access to all of the data and not just the maximum 3%.
And again, you weren't provided with that.
I was not.
Now, when we asked you to review, yesterday we heard from Detective Campbell about it was Detective Good at the cell site location. It was a couple days ago. They said that they only looked until 9 a.m. at that time.
That is correct.
And we asked you to look a little bit further, give or take on both sides. And did anything stand out to you?
There was a location I was like, this looks interesting. Maybe want to take a look at it. Again, I don't have much more information other than the location at the time that was shown. And so I brought it to the attention
And just because I know it's hard for me to zoom in on this, how we have it set up, but if you could just put the mouse on the two little points that we have on there, so the jury sees what we're trying to point out here.
Sure. So here is Jonathan's home. And then here is one in the southern part of the valley, more in a remote area. And that is on 8/7/2023 at 10:25 a.m.
And that's a close-up of what you brought to our attention, correct?
Correct. So it's here, and then you have a lot of these washes, and then over in this area you have lots of open area.
So it's pinging near all these open areas.
That's correct.
And that's, the date of that is the 8/7.
8/7.
In your review of this, and I know I've hit this a bunch, but this is not complete.
It is not.
There's more out there that could have been done.
Absolutely.
And some of the things that we've brought up, these are things that we would have liked to know more about, we just couldn't get into.
Correct.
That could have helped us.
Correct.
Court's indulgence. Ask the witness.
Good morning, Mr. O'Brien.
Good morning.
We just met outside in the hallway.
We did.
Thank you for your military service, sir.
Thank you.
I have a few questions for you, not too much. I just received these items that were shown this morning. You would agree with that?
Yes.
So I'm just gonna kind of go through a couple of the slides and try to make sense of, to clarify what we're actually seeing.
Okay.
So I'm gonna start with the residential neighborhood, the slides you just put up. Mike, can I bug you to get that PowerPoint back up?
And you can click on it too if you need to just use it on here.
Yeah.
And you can click on the slides below and it goes up.
Perfect, thank you. So I'm showing the slide, that you'd agree that's a residential neighborhood, correct?
Yes.
And you looked at a whole lot of stuff in this case. Would that include text messages on Devyn's phone?
It would.
We got a bunch of text messages after 9 a.m. On August 7th of 2023 from Devyn's phone.
Correct.
And you'd agree with me, there's text where he's talking with his boss and talking about a job and going to that job?
Yes.
Okay. And you'd agree this is a residential neighborhood, a newer one, kind of out at the tip of the valley?
I would.
And the location data is that you're looking at that caused you to testify that he was in this residential neighborhood was from the CDRs, not from the device.
That is correct.
So CDRs, as a reminder, those give a general approximation. They're not like the breadcrumbs from the Burla or the Google.
It's not the GPS guys.
Got it. So you're not saying in any way to this jury that his location put him in any of these desert areas, correct?
That is correct.
Okay. You indicated earlier that you reviewed not only the DFLs, which were the actual phone extractions, but you also reviewed the CDRs and the Burla, correct?
That is correct.
Did you also review the Google,
I did.
the geofence stuff?
Yes, I
Okay.
did.
You would agree that there's nothing in any of those sources of information that shows Devier's phone going toward or at the Paladura address between 10 p.m. on the 6th and 8 a.m. on the 7th?
That is correct.
Okay. you would agree that all of those things show the defendant's device, car, and everything at the Palo Duro address until 2:04 a.m.
That is correct.
So the Google data is separate, and that was a geofence,
Yes.
right? And there, you're familiar with the steps and Google's privacy and
I am
all
the
that.
obfuscated numbers and doing
Yeah.
the 2-3 steps.
Right. So just to narrow it down and like simplify it, a geofence is actually placed on around the home, the Palo Duro home, and says, the first step says, show us what devices are at that home, but they give general numbers.
Correct.
And if I oversimplify it, you can tell me.
It's good. That
Okay.
works.
And so, in this particular case, it only showed the defendant's device at that home.
Well, it showed multiple, but once you select which one you want that's of evidentiary value, and yes, that was
Yeah.
one of them.
And that would be Yoko's, Yoshida's, and Jonathan's were actually there too.
Yes.
Yeah, and nobody else's.
Not that I recall now.
Yeah, so it's 4 devices at the Palo Duro home, not including Devier's.
Correct.
And Devier did have a Google device.
Yes. An Android that,
Yeah, Android is a Google
Yes,
device.
yes.
Okay. So we're in agreement, nothing at all that you went through suggests Devier was at the Palo Duro address between those time frames.
that is correct.
Okay. The Google data did show John's phone traveling from the Palo Duro address at around 2:04 a.m. in the same exact path as the defendant's car and phone.
Yes.
Real briefly on the car wash. That information was gleaned from the Burla.
Correct.
Burla is the one with the breadcrumbs.
Correct. It does the GPS locations, which is the most accurate.
Got it. And that shows the Nissan going to what appears to be the gas pumps, not through the car wash.
That is correct.
We're in agreement. Okay. And that would have been about, correct me if I'm wrong, I think 8:30 in the morning?
Yeah, I don't recall.
Well-
It's back a few slides.
Okay. It's after the body's discovered.
Yes.
We agree there. You would agree that people can hand wash their cars, correct?
Correct.
And there were several hours before homicide detectives made their way to the Porcupine Rim address.
Yes.
So, doesn't look like she went through the Funnies car wash?
Yes. Correct.
Fair, okay. Briefly on the ring videos. Were you here, because I've seen you a couple times, were you here when the detectives talked about those videos?
I'm not sure if I was in the courtroom or if
Okay.
I was watching from another location.
I'm not gonna try to recite what they said about the videos, but simplifying it, they basically said, we got what the homeowner gave us.
Correct.
Okay. You're not suggesting to this jury in any way the cops lied about what they got?
No.
Okay. We're in agreement there.
Correct.
They got what they got from the homeowner, and there's 3 clips, one of which looks like it's like motion picture, basically. It's like stills one after another.
Correct.
Which all video actually is,
Technically, yes.
right? And you would agree with me that homeowners or people who have Ring cameras, they can change the sensitivity settings on their device.
Yes.
If they don't want to keep getting annoyed with every time a car drives by, they can lessen the sensitivity just to kind of encapsulate their driveway.
You can set up boundaries. You can set up, there's lots of different
Yeah,
settings. that you
there's a
can
ton
change.
of different settings.
Correct.
You would agree that in the videos from that same camera at night and in the morning, it appears Devier's vehicle is in the same exact spot.
To the best of my recollection, that is
Okay.
correct.
And on top of that, there is video from the entrance, the only entrance and exit a vehicle could go at the Porcupine Rim address.
To my knowledge, that is correct.
And
Yes.
that is continuous record, that's not a motion camera.
I'm not aware of the settings.
Okay, there may have been testimony about that, fair enough. So I want to get to slide 10 and, well,
You want me to help you? You just go to the bottom a little bit.
okay. Okay.
And slide it over.
Thank you. Slide 10. So the 3 rows represent an instant message, row number 1, an instant message from Devier's device to the defendant, see you when you get back, I'm going to sleep, girls, correct?
Correct.
The second one is an incoming call at 10:58 p.m. from defendant's phone.
Correct.
And that one says 44 seconds.
That is correct.
The third one is an image that you brought up today on August 7th at 2:12 a.m.
That is correct.
And I believe the language you used was, I wrote it down somewhere. Did you say accessed? What, just tell us, what does this mean? Like, this,
So that particular picture, the PNG, was the device accessed that. I don't have more supporting information about anything else that was happening at that time, again, because I don't have that database, but something was done with that particular file at that particular time.
got it. So we understand though, when you use that terminology, are you saying the device accessed it or a person accessed it?
Unable to determine.
Okay. If a
I can say that like the device shows that there was some sort of activity on that.
Yeah, and just so we're clear, a device can do things in the background, can access, can cache, can do all these different things, correct?
Yes.
If it's the opposite, if it's a person accessing it, you would then agree with me that at 2:12 a.m. a person is with that phone using it?
You stated that a person was to show that a person would have to be there.
Yeah, absolutely. I mean,
Yes.
it seems obvious, but like, there's 2 alternative theories. It's either the device access it somewhere in the background, or a person is actually handling their phone at 2:12 a.m.
That is correct.
Okay. Go to the gaming system. So you pointed out a couple of, a Nintendo Switch and an Xbox, correct?
That is correct.
And there were, to your knowledge, no gaming systems found in the other home, the John.
I am unaware.
Okay. I guess the pictures of John's home will speak for themselves when it comes to that.
Correct.
You're not taking a position on that. Do you know if the defendant had Discord?
I do not know.
Did we get a full extract on defendant's phone?
We didn't get a full extract on any of the phones.
Okay. What is it that allows you to get a full versus a not full?
So the initial extraction that I talked about, the UFD, is the extraction. What we've been presented with was the UFDR, which is after that extraction is done, then you can either select all, or you can like handpick what you want and then create that reader report.
Okay.
But to clarify, when you're selecting all, it's all the data that piece of software at that time is able to interpret and put into a report.
Got it. And so are you suggesting to the jury that the detectives picked and chose what they took? Or are you suggesting that...
I'm not really suggesting anything other than the full set of data was not provided and I was unable to do a full examination based upon the lack of data.
Okay, and in prior cases, you have a bunch of experience. I have some experience with phones, not nearly as much as you, but there are many, many times in which you cannot get a full extract out of a phone,
Yes,
right? That's not abnormal.
correct.
And you're, again, not suggesting the detectives, like, only pick certain things out of the devices.
I have no knowledge what
Okay.
actions they took, but
Okay. So, with the... text here on slide 18,
okay.
you said this is an artifact with no other information at all.
No other information presented in this manner on the reader report.
Right. So you would agree that there are text messages, call history, all that from Devier's phone, because we've seen a bunch of them,
Correct.
right? There's also that same type of information from the defendant's phone.
Yes, all
Right.
the phones, correct.
Okay. The text history for Devier's phone goes back years, right?
It's quite far, yes.
And he has a bunch of contacts saved in his phone like we all do,
Correct.
right? I don't even know the number, but like dozens, hundreds, I don't know. Can you see it on that?
If you go back a slide, maybe. I'm not sure if it was captured on that or not. So before the bar shows up in the middle?
Let me help you. To get that animation.
Oh, gotcha.
I don't know how to pull it off though. There you go.
There we go, thank you.
No, I didn't capture the contacts on there.
Yeah, but it is captured somewhere in,
It is part of the reader, yes.
Yeah.
The reader file has that.
and so you agree with this headed there now message? That could be to any number of people, years back, 5 years ago, 4 years, whatever it is.
That is correct.
Okay. But you gotta bring it up, because, I mean, it's something. But you would agree with me, I'm showing you admitted exhibit 666, that, oops, that with,
It's not plugged because I've got the HDMI cord.
gotcha. Can I approach?
Yes.
Does this appear to be to you one of the, or the text string that the parties admitted between Devier and defendant?
That is correct, yes.
And this shows a relationship text,
8523?
8:05 at 1 a.m. already adjusted from UTC.
Yes.
This next one is from voicemail to Devier,
So voicemail being the owner of the phone.
and it says, "Where the WTF are you? You obviously ain't home, but you ain't cheating!" Exclamation points.
That is correct, I see that. And
August 5th,
2023 at 4:02 a.m.
okay. And then the next text says, "From Devier to the defendant's voicemail, see you when you get back. I'm going to sleep. Girls are in the living room," correct?
That is correct.
Okay. No other text saying, "I'm on my way," or, I'm sorry, headed there now.
No.
The CDRs are completely separate from the device. That's the phone company keeping
That is
record.
correct.
And you would agree with me that there is absolutely no record of a text message after the one where he says, "I'm going to sleep," going to the defendant's home between whenever that was, 10:36:24 p.m. and 8 a.m.
Can you repeat the initial question?
The CDRs. So
Okay,
we're-
CDRs,
Yeah,
that is
we're
correct.
away from the phone.
Yep, that is correct.
In the CDRs maintained by an outside source, the company,
Yes.
there is no incoming text to Devyn from Devier, no outgoing text from Devier to Devyn after that one at 10:36.
Based on my review, no.
So this headed there now text doesn't have anything to do with our time frame, based on the CDRs.
Based on CDRs, I believe that is correct.
Just make sure I got through all of them. Yep, that's it. Thank you very much, sir.
Sure.
Follow up with me?
Just to touch base on the picture being accessed and the gaming data of, I think it was, what's that, a core or a Discord? There was activity the morning of, or the early hours of August 7th.
That is correct.
And do you know if Devier had his phone on him?
I wasn't there. I don't know.
Yeah, we don't know either. Now, the state brings up the Funny's car wash. Let me pull this back on this slide. Now, he brought up the state, and I'm not trying to misstate, I'm just kind of summarizing, is about pulling in a potential hand wash of a car or something like that. You remember that question?
Yes.
Now, the car turns off at 8:17 and turns back on at 8:21. Does that sound about right?
It does, yes.
Nissan Armada is not a small car. It's not a Honda Civic. It's not a hatchback. It's a pretty big car. Correct? Just from your, I mean, you've seen them on the road.
Yeah.
It's a bigger SUV. It's not a small
Correct.
car.
That's correct.
So to hand wash a big SUV that they've made is super clean, that 4 minutes is pretty quick.
Correct.
To hand wash a car, not drive through a car wash, but to hand wash it at a gas station, unless there's, yeah, doesn't seem to add up.
Correct.
When he asked you about the Ring cameras at Porcupine, Mr. Giordani asked you about the cameras in and out of the development. Remember that line of questioning?
I do.
But we don't know if any person was walking around, say, hopping a back wall on a side of the house. We don't have any of that, right?
I did not see any of that, no.
There's other ways to get into a neighborhood besides just a car coming through the main gate or the main entrance
Correct.
or leave a neighborhood.
That's correct.
Now, there was a call.
Just to clear, you said car or person?
I'm sorry, there's other ways for a person to get out of a neighborhood besides a car.
That's
coming
what I
through the
thought
main
you were
gate.
saying.
Yeah.
Okay,
And thank you for clarifying.
sure.
And we do see that there was a call at 10:58, right?
That's correct.
And that was Devyn to Devier.
Yes. Well, to the devices.
Correct. Now, we went into the UFD, UFDR, like I said, I always confuse these, so I'm glad you're here. We were not provided, you were not provided with the full downloads or extractions.
That's correct.
And from Detective Campbell, yesterday he testified that he got his extraction and gave it to Detective Ozawa. It's kind of what you remember, because you've looked at the reports, you're familiar with the case.
Yes.
Do you remember seeing, or do you remember being handed any kind of information from phones that there was a follow-up from Detective Ozawa to get more information on the phones?
I did not see any more.
You were just given the initial or UFDR of the phone.
I have no idea when those, I can look up the time that it was created, but I don't know what order, if there were other extractions done. I have no further information other than I received these reader reports.
So from what you received, it is just, I have this one download, and that seems to be the only thing that was done. From
Correct.
what you've been
From
given.
what I've seen, yes, that is correct.
Now the headed now text, it was deleted, wasn't it?
It was.
And we don't have a time.
We do not.
We don't know what that's in reference to.
No.
And going back to the Ring cameras at Porcupine, or from the address, there's so many. The Taylor Creek address,
Okay.
you don't, not suggesting that the cops didn't, not that they made their own, but there was no follow-up on to subpoena or get any more information on this. You didn't see any of that.
I have no knowledge of that now.
And I'll state it this way, you weren't provided any more than that. This is what we got and we gave it to you.
Correct.
Okay. And just going back to this picture of one of the last pings on Devier's phone, the state suggested that there was this, he had this work schedule, which it's been throughout the course of the trial. There's been testimony that he had to work, that morning, and he went. But were you able to confirm that by any text message you looked at through the phone? Nothing popped out to you.
No, nothing stood out to me.
It's kind of why this popped out to you by this area at this time.
That is correct.
No further questions.
Any follow-up, Steve?
Yeah, I have to, I apologize. So, there actually is text messages where Devyn is talking to his boss and saying, I'm headed to a job out. You saw those, right?
Yes,
Okay, so those do exist.
yes.
Okay, that's not just testimony, that's in the device.
It's in the device.
And it's
There's
consistent.
multiple occasions that they talk about work. Hey, I'm headed to this side, headed to that side. I'm going to run late.
That morning, August 7th.
I don't recall specifically. No.
Well, I can show you.
Okay.
Can we agree overall that you went through these devices like with a fine-tooth comb?
No. I did the best I could in the amount of time that I was provided
Okay.
with the data that I was provided.
Okay, fair enough. When you go through this, I mean, you're presenting everything that stands out to you as like, this is fishy, or this is something I would bring up, or whatever, right?
Correct.
There's nothing you left out that was something you were like really interested in and didn't present to the jury?
No.
Okay. So,
I don't agree with that on this message.
so I'm showing you already admitted Exhibit 4. And I want to kind of show you this just in context of the timeline you just provided to the jury. So we agree that there is an incoming call to Devier's phone at 10:58 from defendant's phone.
Correct.
10:58 p.m. on the 6th.
10:58 p.m. on the 6th, 44 seconds.
And this is already admitted earlier by us. Well, let me back out so you can verify. You would agree that this appears to be stuff from the defendant's phone, correct? The Z Fold?
Based on the naming,
Yeah.
yes.
And then I'm gonna go into the call log timeline. And you can see that 10:58 p.m. outgoing call from the defendant's device to Devier, correct? Do you see that?
Yes.
And then as it goes on, there appears to be a bunch of missed calls from Michael's home.
That is correct. What's labeled as Michael's home?
Right, but it's a different device from Devier. It's a
Correct.
separate number, yeah.
Correct.
And some of those went to voicemail.
Yes, that is correct. I believe 3, maybe 4.
And you're aware we can recover those voicemails, and we in fact did.
Absolutely.
Opening the folder entitled Audio. Do these appear to be the 3 recovered voicemails?
Yes, it does.
And these are after that 10:58 p.m. call from the defendant to Devier, correct?
Correct. It appears to be about 11:13, 11:18, 11:21.
And if I click on this, is that going to play the audio?
I hope so. It doesn't have the supporting file.
Yeah, I did this before, and I think I have to open it.
Mom, you've answered I woke up in the middle of the night. Devyn was sleeping peacefully. I turned her phone to now and make her go up. Please give me a call back.
Did you hear that?
I did.
You familiar with that?
I am.
That's, sounds to be a little girl's voice.
It does.
And she's saying, Mom, Devier's asleep. I woke up in the middle of the night.
Correct.
Victoria, can we somehow move that up? Because I have the represent on. I don't know why the audio is not playing. May I inquire if the jury heard that?
Yeah, did you guys hear that? Yes. And Mr. Judon, if you want to put the laptop next to the microphone, it may make it louder.
That would make sense, wouldn't it?
Yeah. You don't know.
Mom, I've been waiting for you to come home, and I haven't seen you anywhere. So, if you could, please give me a call. I'm very worried about you. I'm very scared. I don't know if you got in a car accident or any circumstance. And I'm getting very worried. Please call me, please. Everyone knows if I woke up in the middle of the night at 10:40. I've been trying to get everything prepped for school tomorrow. So, the rear's knocked out, today's knocked out. I can't fall asleep. He's been telling me what you got here to everything. You said you were going to get some medicine. And then you never got any. So please give me a call back. I'm very worried.
That was voicemail number 2. Sir?
Yes, that is correct.
And you heard the little girl's voice say, everyone's asleep. I woke up in the middle of the night.
Yes, that did.
Devier's knocked out.
I don't think she said that, but
Okay, well, I'll play it again.
Mom, I've been waiting for you to come home, and I haven't seen you anywhere. So, if you could, please give me a call. I'm very worried about you. I'm very scared. I don't know if you got in a car accident or any circumstance. And I'm getting very worried. Please call me, please. I promise you, I woke up in the middle of the night at 10:40. I've been trying to get everything prepped for school tomorrow. So, the rear's knocked out, today's knocked out. I can't fall asleep. He's been telling me what you got here to everything. You said you were
Did
going
you hear it that time?
I did. Thank you.
Sure.
I've been waiting for you to come home. You never came home. I maybe you don't come home. I just never see you hear them. But I'm getting very worried. Please call me. I'm very worried. You know how you're worried about me sometimes? I'm kind of worried about you scared and everything. I'm really getting worried. I'm like, so, like, are you in a car accident or something? That's not worried. So please give me a call back. I see a car in the neighborhood and it stopped in front of our house. I'm not sure if it's you. If it is, could you call me back?
And that was voicemail number 3.
That is correct.
And then if we back out of that, we go to the report. That would have been, for the record, 11:13 p.m., 11:18 p.m., and 11:21 p.m. in that order, right?
That is correct.
I'll pass the witness.
Oh, is your
Those messages were around 11 p.m. is what you recall.
That's correct.
There's activity on Devyn's phone around 2 a.m.
That's
Correct. On 8/7.
That's correct.
And on one of the voicemails, it talks about a car out front. Is that what you heard?
Yes.
Now, going back to the wash, the state brought up about his work schedule. Do you remember reviewing any messages between him and his boss regarding that morning?
I really wasn't focused on anything that late. It was just over my review of like going through, like, oh, that's kind of weird. I didn't really do a lot of investigation around that because there was a whole lot of stuff, other places that I was focused on.
Anything about him running late?
Not that I recall.
And we saw those artifacts on the phone around 2 a.m. with the Discord and the photo.
Correct.
And we can't.
The photo, yes. I'd have to see the Discord one again to verify that time.
Pull it up. Looks like Discord was 2:31. Is that? Am I? Sorry,
I have
it's
no
not plugged
reason
in.
to dispute
I'm
that.
sorry. I don't know what just happened now. There it is.
2:31 a.m. Discord. That's correct. On 8/7.
Court's indulgence. There are no further questions.
Any follow-up statements? Okay, ladies and gentlemen, jury have any questions for this witness? Okay, everybody's working on a full sheet of paper with your name and your jury number. Counsel could approach. Does the Discord photo at 2:31 a.m. show someone accessed it from the Porcupine home?
There is no indication of where that came from.
I'm sorry, no indication.
No indication of the location of where that came
When you look at the Burla data, did Burla show Devyn going straight into her neighborhood and to her house?
One more time, please, ma'am?
When you look at the Burla data, did the Burla show Devyn going straight into her neighborhood and to her house?
I believe I need further clarification, like what time frame, or if that could be clarified more?
I can read it directly
Okay.
as they. Was there any stops in her neighborhood?
None that stood out to me now.
When using chat applications such as Discord or others, if the phone is set to show notifications, will this create activity records even if the phone is not being used?
Yes, it houses it in a database, which, again, I didn't have access to that database.
Okay. Mr. Horvath, any follow-up based on your question?
Course of diligence.
Okay.
So the main question at 2:04 when the Armada leaves Paladura, it goes to the pharmacy, correct? That's what you reviewed?
Yes, that is correct.
And then it goes straight home.
Yes,
That's it.
that is correct.
No other stops.
Not that I saw, stood up, no.
No further questions.
State any further questions based on your question?
Just briefly, you'd agree with me that the Nissan Burla data is specific to the car, correct?
Yes, that is correct.
Nothing about that or the phones is gonna show whether the defendant got out of her car with a basket, with a head in it, walked over to the neighbor's house and dumped it in the trash, correct?
Potentially, Barilla could pull information about weight distribution and like, you know how if you're in your car and it says, hey, there's something in the back seat, make sure to check it. Potentially that could be there. I didn't see any, only information I got was location data.
So human head weighs about 8 to 10 pounds, we agree?
Sure,
If a doctor testified to that, we can agree.
sure.
Are you saying that the Burla would show an 8-pound differential? Or,
Not really sure. I mean, it's dependent on the car, so I don't know what the setting is on the car, but it's possible.
okay. So you have nothing to suggest that the defendant's car stopped anywhere else?
That's correct.
We've already talked about.
CVS and then,
Yeah.
Correct.
And she can, whatever she did after she got out of the car, you have no evidence of that?
that's correct.
Thank you. Pass it.
Any follow-up, Mr. Horvath?
Just real quick, in cars, seatbelts, some, in the newer cars, this car looks like it's a newer car. Sometimes when someone is less weight, you know, it says buckle the seatbelt or they shouldn't be there. You've seen those mornings, right?
That's correct.
Do we know if this car had this?
I don't know. I was not
Didn't have
provided
a full-
information.
And then just like the car, if you don't have your cell phone on it, you can't track that person. If it's that person's phone, if they're supposed to have it on them.
Say one more time, please.
You can't track a person by their phone if they don't have their phone on them.
That's correct.
No further questions.
Any follow-up, state?
No, thank you.
Do the ladies and gentlemen, do you have any further questions for this witness? Okay, seeing no response, we'll go to you. Thank you very much for your testimony here today.
Thank you, ma'am.
All right, ladies and gentlemen, we are going to take one brief recess for the morning. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its matter, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, listen, any news or media accounts or commentary about this case. You must not do any research, such as consult a dictionary, using the internet, or using reference materials. You must not make any investigation, test the theory of the case, reprint any aspect of the case, or in any other way investigate or learn about the case of your own. You must inform the person anything regarding. We're going to be in recess till 10:40.
All rise for the jury.
Carried.
Please be seated. Your Honor, the jury's all present and accounted for.
We are back on the record at C, 377-239, State Lab versus Devyn Michaels. Again, the record reflects that Ms. Michaels is present our attorney, deputy district attorney on behalf of the state, and both powers stipulated in front of the jury.
Yes, Your Honor. Housekeeping matter, we have stipulated medical records. I'd
Okay.
like to make part of the record.
Okay, what are the exhibit numbers?
Okay. There's
C4 and D4? Okay, C4 and D4 will be admitted pursuant to stipulation. Defense, you may call your witness.
Thank you. The defense calls Dr. Larry Sims.
Do you solemnly swear or affirm the testimony you're about to give in this action will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please be seated. Please state and spell your name for the record, please.
My first name is Larry, spelled L-I-R-Y. My last name is Sims, spelled S-I-M-M-S.
Whenever you're ready, Mr. Trustee.
Thank you. Dr. Sims, if you could tell us a bit about yourself, beginning with your education.
Well, I graduated from high school in 1970. I graduated from college in 1974. I went to medical school at Oklahoma State University and graduated from there in 1978. I did a rotating internship as a physician in Dallas from 78 to 79. And I was a general practitioner for 10 years, 3 years in rural America and 7 years in Detroit. I had about 55,000 patient contacts, delivered about 100 babies. Then I went back into training at Michigan State University in pathology for 4 years. Then I did a 1-year forensic fellowship at Cook County Medical Examiner's Office in Chicago. Stayed on there for some years, and then I came out here and was at the Clark County Coroner's Office for 19 and a half years. I maintain a licensed medical license in Nevada, and I'm board certified in anatomic pathology, clinical pathology, and forensic pathology.
Doctor, so you were a coroner here in Clark County?
Yes,
19 and a half years.
yes.
Would often be called by the state of Nevada in prosecutions of murder cases.
Oh, yeah, I probably testified over 500 times during that period of time.
You were contacted and were ultimately retained by the defense in this case, the state of Nevada versus Devyn Michaels, correct?
Correct, yeah, I was contacted by the Special Public Defender's Office, it's been over a year ago.
Okay, and just for the record's clean, I mean, I'm not part of the Special Defender's Office, nor is Mr. Horvath, but that was who was initially on this case.
That's who initially contacted me.
After being contacted, were you provided with certain materials, specifically an autopsy report and other things of evidentiary concern, photos and the like?
Yes.
To your knowledge, was it the entire file?
Well, what I was provided, which is all the forensic important stuff, yes.
Have you had an opportunity to review the autopsy report prepared by Dr. Stephanie Yagi?
Yes.
And that autopsy report is dated August 8th of 2023.
Correct.
Did you review the pathologic findings in the autopsy report?
Yes.
And what are they?
Well, okay, have you got a copy of the autopsy report? I can go.
Absolutely. May I approach with a copy? State any objection?
Not at all.
So the main two findings is she classified the death as homicidal violence, and then she noted that he had a fatty liver.
And those were the two findings?
Correct.
Now, are there certain standards of practice that are employed by pathologists, specifically coroners?
Yes.
And what are those, and if you could please describe those to the jury?
Well, there's a number of practice standards, but there's a specific published practice standard in relation to using homicidal violence without any specific cause. It was published in 2010, and it has 5 separate criteria that all 5 have to be present before you use a non-specific cause of death, such as homicide by unspecified means or homicidal violence.
And doctor, what are those 5 criteria, and if we could just have you break them down, please?
Well, one of the important ones is that there can't be any other cause of death present. In other words, there can't be any natural disease present. There can't be any toxicologic explanation of death. There can't be any environmental explanation of death, such as drowning or cold. And there has to be an indication that the body was altered in some way. And there's one other criteria. I can look at the paper. I can't remember what it is.
Okay, if I may approach the witness.
And then a specific cause of death can't be brought out of the whole entire data set, which means all the findings that are available.
So from the get-go, we have this pathological examination done, and we have these pathological findings. The first being homicidal violence. And you had discussed these 5 criteria. Let's focus on 2 of them, specifically no atomic cause of death. How was that a concern, and how did this examination and this opinion not follow the standard practice?
Well, there are, in this particular case, that he actually has 2 natural diseases that could cause his death. His heart was enlarged, and he had a fatty liver.
And those are obviously borne out through Dr. Yagi's analysis and review of the body, correct?
Correct.
There's another criteria I'd like to draw your attention to, and that's no toxicologic cause of death. If you could please explain that and the significance in this exam.
Well, there has to be drugs can be present, but they have to be at low enough levels not to cause the death. Is kind of the main thing to take away from that. Or there can be drugs present that are not known to cause death, like a medicinal type of drug.
So in this case and on this examination, there was a toxicology report, correct?
Correct.
And what were the findings of this toxicology report?
Well, the main findings, he had a low level of alcohol below the legal limit for driving. His marijuana level was substantially above the legal limit for driving. And he had quite a bit of alcohol in his stomach, but not really very much in his blood, which indicates just that he had drank a significant amount of alcohol just prior to his death before he died.
Let's break that down just a little bit, and let's start with the alcohol, where you just left off, doctor. Are there different places where these draws are taken in order to arrive at the alcohol content of the body?
Correct. It's very important to, without going into a lot of explanations, to take the blood from a certain region, because that region is more characteristic of the level of whatever drug prior to death. If you take it some other regions, it could actually be higher or lower.
So in this case, was there both a blood draw from perhaps a leg or an ankle and from the stomach?
Yes, they did both of those.
If you could please explain those processes and the findings to the jury.
Well, the blood was taken appropriately, and so I have good confidence in the alcohol level of the blood and the. Have you got a toxicology report, just so
Yes,
I make sure I don't say anything wrong?
I believe, oh, absolutely, and Doctor, I believe it's attached
Part
to
of it is?
the back of the report.
So the alcohol and marijuana was done on peripheral blood, which is the appropriate thing. They also took urine and gastric fluid, and they did take heart blood, and they did measure the GHB level in the heart blood rather than the peripheral blood, which is not a good thing to do. It should have been done on the peripheral blood. Those are the main things.
And focusing in on the alcohol content, you had testified that in the blood, it was not particularly high, correct?
Correct.
But then you made reference to the alcohol in the stomach. If you could please explain the significance of that. Did that denote recent drinking, heavy drinking? What would that indicate?
Yes, it was about 30 times higher in the stomach fluid than in the blood. So he had drank, a couple of, some significant alcohol that had not been absorbed yet into his blood.
Now, if the THC content, it was significantly above the legal limit, correct?
Correct, yeah, the legal limit is 2 and his was 26.
So over 10 times the legal limit.
Correct.
THC. So if an individual were to have ingested alcohol, as we have evidence of, and smoked marijuana, could you opine, was that person intoxicated?
Oh, definitely, yes.
If we had heard testimony that this person had gone to sleep or shouldn't be driving, a family member was concerned about him driving, would that be consistent with the findings of this pathological report?
Yes.
In reference to the GHB and the drawing from the heart, you had said that was of concern. If you could please explain why.
Well, because heart blood is notorious for being inaccurate as far as true level of the antemortem prior to death level. I'm not saying it's completely inaccurate, but it would be better to do that on the peripheral blood, which is what the other toxicology was done on, than the heart blood. But even given that, the DHB level wasn't into any significant toxic range.
Turning your attention back to the findings concerning cause of death, manner of death, and specifically the standards of practice, these 5 criteria. Is it fair to say that homicidal violence is an incorrect designation?
Yes.
What should it have been?
The criteria aren't met, then you classify the death as undetermined.
As we've covered cause of death, manner of death, it states homicide. Is that incorrect?
Correct. Yes, it's not correct, no.
What should it have been?
It should also be undetermined.
So based upon the science, the examination of the body, fair to say that this was an inaccurate pathological conclusion, homicidal violence.
Yes.
Finally, I'd like to address, there's an issue concerning obviously a missing head. Fair to say that that complicates matters.
Oh, definitely.
And how so?
Well, if you have incomplete remains, it's very risky to make conclusions about something that you haven't examined. You don't really know. Worst case scenario is the head turns up and there's no cause of death with that either. So in this particular situation, that would preclude you from scientifically, objectively assigning a cause or manner of death.
Now, obviously, one of the criteria concerns death under suspicious circumstances.
Correct.
And I don't know if you have had an opportunity to review the file, because we haven't discussed it all that much, but obviously we have some fairly suspicious circumstances surrounding this death, correct? And is it fair to say that Dr. Yagi perhaps relied upon that, outside the practice standards, but relied upon that in finding a cause of death and a manner of death?
Probably so.
Okay. I mean, we're humans, we make mistakes, fair to say.
Oh, definitely, sure.
In a strictly scientific sense, okay, doctor, and based upon the data, the empirical data, is it possible that this gentleman died of natural causes?
It's definitely possible. That's why you would classify it as undetermined. Before you come to a conclusion, especially one of homicide, which is going to have significant effects, you want to base it on provability. You want to be able to prove it. And in this particular situation, he actually had, in the body that was examined, he actually had causes of death that could cause his death. And the fact that the head is gone precludes you from making a scientific determination.
And again, we have discussed somewhat in this jury's heard for a week and a half, perhaps substantial, suspicious circumstances, but from merely the science, he could have died.
Correct.
Natural death.
Correct. Now, forensic pathologist, that's the role that we're talking about. That's the role I played. You have to base your conclusions on objective evidence, not just suspicion.
Finally, in reference to the decapitation, you obviously reviewed the photos, you reviewed the examination of the body. It was clear that this body was decapitated.
Correct.
Any opinion was it post-mortem? Does he indicate that this happened after death?
Definitely. It was examined by an anthropologist, or an anthropology team, I guess it was, and they concluded that it was a post-mortem decapitation, which I don't disagree with.
Based upon the circumstances, you reviewed the evidence, fair to say it probably happened close in time of death and decapitation?
That's an excellent question. It might be very, very difficult to say that. There's no doubt that the blood was still liquid, but that would be liquid for a number of hours. So it's more likely that it was, but as far as being able to objectively prove it, you'd have to do a substantial number of kind of uncommon tests to do that.
And in reviewing Dr. Yagi's report, in fact, she enlisted an anthropologist to do further analysis on C2 and C3, correct? The findings of that anthropologist was that the head was severed using two instruments, correct?
Correct.
A handheld knife and a mechanical powered saw.
Correct.
Do you take issue with those findings?
Well, after reviewing all the pictures and looking at them, there was an area in the skin that had, in my experience, the characteristics of a chainsaw. But it was only in an area of the skin, which that would be enough for me to be concerned that was part of what was used.
A chainsaw.
Correct.
So while we have the anthropological findings on the bone, did you view any follow-up evaluation or analysis on the skin that you're referring to?
No.
In reference to this idea concerning the cause, the undetermined cause of death, and we have a post-mortem decapitation and the time of death, we had agreed that it's fairly close in time. You'd made reference to the blood, and there's been several questions last week asked concerning witnesses and this idea of cast-off. Would you anticipate there having been cast-off given the evidence that you reviewed?
Oh, especially if there was a motorized weapon used, yeah, you would expect substantial cast-off also on the people or the person that did it.
So would you expect, based upon your evaluation of the evidence, for that person to be covered with blood?
Well, there would be a lot of blood splatter, yes.
Okay. We had heard testimony concerning, bodies are dissected in the morgue, there's not a great deal of cast off. We're obviously talking about different circumstances here, correct?
Yes, that would be different circumstances, yes.
Here, we're not talking about a refrigerated body.
Correct.
Here, we're not talking about a specialized instrument that may be used, let's say, in a coroner's office to dissect a body.
Yeah, we don't use chainsaws, but, so no, that's a whole different thing. So.
Okay. There had been questions asked concerning the arteries, carotid arteries, and you'll agree with me, the anatomy of the neck is fairly complex in reference to a decapitation.
Yes.
I mean, we have obviously the muscle system, we have the vascular system, we have the spinal cord with all the vertebrae, we've heard are complex and quite strong.
Correct.
We have the thick ligaments, cartilage. Would it be, can you give an opinion as to would it be difficult to effectuate a decapitation?
Oh, yes. Especially if you're just using a handheld knife, would be very, very difficult.
And in this case, we've made reference to a handheld knife and a mechanical powered saw. Again, it's an undertaking.
Correct.
We would expect to see cast off and blood, correct?
Correct.
Would you expect to find cast off and blood at the scene where this had occurred?
Wherever it occurred, yes. Unless somebody cleaned it up or something. But yeah, you would, during using a motorized type thing, you would expect a large amount of blood splatter.
So we're not talking about a morgue, we're talking about perhaps in a bedroom, correct?
Correct. Yeah, I've never even considered a morgue anything near a scene of a crime like that.
So that would be inappropriate to make comparisons to what happens in the morgue as opposed to what happens at perhaps the scene of a crime.
Well, I've never done that. I've never heard about that because it's a completely different environment, and so I don't even. There's not even an analogy there. No.
We could have the court's indulgence just one moment. Thank you very much for your testimony, doctor. I pass the witness.
Yes. How are you, Dr. Sims?
I'm okay. How about yourself?
Good. Good to see you, sir. I'm not going to disagree with you too much. I just want to clarify a couple things. We're in agreement, sounds like, that it's difficult to determine cause of death when the head is missing, correct?
Yes.
We're in agreement that it's a postmortem decapitation.
Yes.
We're in agreement, you weren't at the scene, nobody here was at the scene, well, maybe except one person, right?
That is. Yeah, I definitely was not at the scene. No.
Yeah, so you don't know if someone covered it up while they're doing the sawing with the knife or the saw. We can agree there.
That's a good point, and I was not at the scene, nor did I. I've never visited the scene,
Yeah.
And so no, I don't know that.
Fair enough. And you mentioned cleanup goes without saying. You can't say whether the person may have gotten blood on them, took a shower, any of that.
That's correct.
Use chemicals to clean up or anything like that.
That's correct.
Okay. Are you familiar with the term hesitation marks?
Yes.
What does that mean?
So those are primarily in relation to sharp force injury, and they can occur in somebody trying to kill themselves or when they're going to kill somebody else. And it's a mark where you're considering making a cut and you become afraid, or there's some reason that you don't, and so you leave just a superficial injury.
And you mentioned some of the cuts to the back of John's neck.
Correct.
You're not telling this jury that it was in fact a chainsaw used, correct?
No, I just talked about one area that was that I picked out, seeing the photographs, that was concerning to me.
Sure. But you'd agree there are hesitation marks.
Definitely.
Looks like somebody who went to do it was like, oh my God, I can't believe I'm doing this kind of thing.
Definitely. There were multiple hesitation marks, yes.
And with regard to the tools, that was sent out to a forensic anthropologist, and there's tool mark experts, et cetera, right?
Correct. Yeah, that is a specialized type of analysis, and I thought they did a pretty good job.
Okay, and that was going to be my next question. Are you calling into question Dr. Burns and her associates' work?
No, I read it. They took very good photographs. They made, the proper, in my opinion, the proper descriptive statements. So if that report would have came back to me, I would have adopted the report.
Sure. And it's a report, you didn't prepare a report, I've been told, in this case.
No, I didn't. I was never asked to prepare a memorandum or an email or anything about anything. I was just, the reason I was originally contacted with this from the Special Public Defenders, they were puzzled about the cause of death. They didn't quite understand it. So
We are in agreement that the decapitation is not the cause of death.
that is correct.
You would agree with me, we've had cases together before back in the day. You would agree with me that a single blow to the head with a large blunt object can kill a man.
Yes, they can.
And you've probably seen lots of those cases.
Blunt force injury is a common mechanism of death, yes.
And there is a difference between the terms homicide and murder, correct?
Definitely.
Homicide is a medical legal definition, and you know it better than me, I think it's death at the hands of another.
Correct. It basically talks about a mechanism. Murder is a legal conclusion because there can be justified homicides.
Sure.
Or murder is an unjustified homicide.
Right, gotcha. My point is you're talking about whether or not it's a homicide. You're taking issue with Dr. Yagi's terminology.
Based on the published practice standards, it did not follow that. I wouldn't have came to this conclusion at all.
Okay, fair enough. And I'm not arguing with you about that. I'm just trying to say, you're not saying to this jury that John was not murdered.
I don't know.
Okay. Murder can be proven by other means, not just your narrow medical legal determination.
Oh, definitely it can. The jury can come to whatever conclusion based on all the data.
Yeah, phones, video, even confessions.
Correct?
Murder and homicide, two different things.
Correct.
Pass the witness. Thank you, sir.
Any follow-up, Mr. Justice?
Yes. Suffice it to say that based upon the evidence available, you could not say this person died of a blow to the head, could you?
No.
That would be reckless.
Yes, there would be no evidentiary basis for that, so I wouldn't say that.
Something I'd like to address on my redirect of you is we've heard from other witnesses involved in the investigation of this case that this was the first time that they'd investigated, been involved with a case involving a beheading.
Okay.
Have you had experience with beheadings?
Yes.
Multiple?
As far as in the general term of dismemberment, it's probably around 24 out of my whole career since doing forensic cases starting in 1991.
Thank you. Finally, I've got a follow-up question that I'd like to address, and if you don't have any specialized knowledge concerning this, we completely understand, but there's been some discussion of chloramine, the mixing of bleach and ammonia. It was referred to in the autopsy report concerning smoking body, things like that. First of all, can you give testimony concerning chloramine?
No, I don't. That's a criminalist. A criminalist gives testimony about that. I mean, I've definitely been in cases involved in that, and they've talked to me about it. I mean, I can tell you what they told me, but I have an independent. That's not something that I include in my reports or in my estimations because there's somebody that are better experienced and better knowledgeable than I am.
So you have no opinion as to how long this chloramine may exist? Let's say you put bleach and ammonia together, it's on a body. No time frame, how long that'll be, nothing, can't give any testimony concerning that.
No, I mean, you can tell that it caused discolorations in the skin from a pathologist's point of view, but I don't have any opinion about that, no.
Thank you, doctor. I have no further questions.
Any follow-up statement?
Nope, thank you.
Ladies and gentlemen, the jury have any questions for this witness? Do you write a question on a full sheet of paper with your name and your address? Counsel Burch? handheld knife were described to you as a meat cleaver, would it be better to understand that the head could be removed easier than using a knife?
Yes.
Okay. I'm sorry, Mr. Baxter, any follow-up based on the jury?
But in addition to this knife and again, the findings were of a handheld knife, correct?
Correct.
Would you expect a cut to be different from a handheld knife versus a meat cleaver?
No.
Similar?
Yes.
However, in addition to a blade, based upon the findings, we're to understand that a mechanically powered saw was used.
That is correct. Yeah, whether it was a reciprocating saw or a rotary saw or whatever, they didn't go any further than that. But it was some kind of powered instrument.
Thank you. I have no further questions.
State, any follow-up based on the jury?
No, thank you.
Ladies and gentlemen, any further questions? With the yes, and the right question, please state your paper with your name and your jury number. Okay, Dr. Sims, is it a regular practice for the medical examiner to call in a criminologist when chemicals are used?
It would be, if that is an issue, a recognized issue in the case, it's not some just minor finding, then that is correct, yes.
If alcohol is in the stomach and not absorbed in the bloodstream, does it affect the person's ability to function?
No.
When you talk about natural causes, would you expect to see physical signs of a heart attack or cardiac enzymes?
That's a very excellent question. Because there was no microscopic analysis of the heart, there was no microscopic analysis of the liver to actually fully assess the amount of pathology and whether there was something acute or longer, which should have been done in this particular case.
In terms of the liver, if fatty liver disease progresses, would you expect to see signs of jaundice or bad enzyme levels?
That's also an excellent question. So in his particular case, it had not progressed to cirrhosis as yet, but without getting into a lot of pathology, the storage of fat in the liver disrupts the liver's ability to function, and the function is the main metabolic organ that takes care of all toxins in your body, whether they're drugs or anything else. And so when you lose that, then you allow a higher level of those toxins to be in your bloodstream, which can cause death. And that's how it operates.
Mr. Pastor, did you follow up based on the jury?
Yes, just briefly, in reference to the question the alcohol, based upon your test in the stomach, based upon your evaluation of this person was clearly intoxicated.
Well, the marijuana was really high, and then it also worked with whatever little alcohol was present. Both of them are central nervous system depressants. So there's what's called a synergistic effect.
So we would expect in alcohol in conjunction with the THC, this person was pretty loaded.
It was definitely under the influence of marijuana for sure, yes.
Finally, in reference to this cast-off post-mortem, you'd expect under the circumstances of this case for there have been significant cast-off.
If there was a motorized, there can be cast off even with a handheld knife, depending on how the person is using, but it's going to be very small compared to the cast off from any kind of motorized cutting instrument.
Thank you. I have no further questions.
Any follow-up statements?
No, thank you.
Do the ladies and gentlemen of the jury have any further questions for this witness? Okay, seeing no response, sir, you are excused. Thank you very much for your testimony here today.
Thank you.
Does the defense have any further witnesses they wish to call?
We have no further witnesses that we are going to call. We are going to arrest. However, we do have a housekeeping matter. Did we get those other exhibits? She's looking at them right now. Okay. We'll stipulate the defense rests.
Okay, then what are the exhibit numbers? E4 through N4 are going to be admitted for serious stipulation. The defense will rest at this time. Do you have any rebuttal witnesses?
No, thank you, Your Honor.
All right, ladies and gentlemen of the jury, we have now reached the conclusion of evidence in this case. We have now reached the portion of the case where I'm going to read you the instructions on the law that applies to this case. You guys are the fact finders, so it's very important that you understand what I'm reading to you. So we're going to give you your own packets so you can follow along as I read them to you, just in case I read too fast and you guys, we don't want you to miss anything. Instruction to the jury. Instruction number 1, members of the jury. It is now my duty as judge to instruct you on the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of this court. Instruction number 2. If in these instructions any rules, direction, or ideas repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point of instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Instruction number 3, a third amended indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of her guilt. In this case, it is charged in a third amended indictment that on or about the 7th day of August 2023, the defendant committed the offense of murder with use of a deadly weapon. Count 1, murder with use of a deadly weapon. Did willfully, unlawfully, feloniously, and with malice aforethought kill Jonathan Millette, a human being, with the use of a deadly weapon, to wit, a wooden stick and or other unknown object, by striking the said Jonathan Millette with the said wooden stick or other unknown object, and or through other means, the said killing having been 1, willful, deliberate, premeditated, and or 2, committed during the perpetration or attempted perpetration of a robbery. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case to determine whether or not the defendant is guilty of the offense charged. Instruction number 4. In this case, the defendant is accused in a third amended indictment alleging an open charge of murder. This charge includes and encompasses murder of the first degree and murder of the second degree. The jury must decide if the defendant is guilty of any offense, and if so, of which offense. Instruction number 5. Murder is the unlawful killing of a human being with malice aforethought, whether express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Instruction number 6. Malice aforethought means the intentional doing of a wrongful act without legal cause or excuse, or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise not alone from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed, but may result from an unjustifiable or unlawful motive or purpose to injure another, which proceeds from a heart fatal event on mischief or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes rather an unlawful purpose and design in contradistinction to accident and mischance. Instruction number 7. Express malice is that deliberate intention unlawfully to take away the life of a fellow creature, which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears, or when all the circumstances of the killing show an abandoned and malignant heart. Instruction number 8. The prosecution is not required to present direct evidence of a defendant's state of mind as it existed during the commission of a crime, and the jury may infer the existence of a particular state of mind from the circumstances disclosed by the evidence. Instruction number 9. Murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All 3 elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first-degree murder. Instruction number 10. Willfulness is the intent to kill. There need be no appreciable space of time between formation of the intent to kill and the act of the killing. Instruction number 11. Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. Instruction number 12. A deliberate determination may be arrived at in a short period of time, but in all cases, determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes an intent to kill. Instruction number 13. Premeditation is a design, a determination to kill distinctly formed in the mind by the time of the killing. Instruction number 14. Premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. Instruction number 15. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. Instruction number 16. The true test is not the duration of time, but rather the extent of the deflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. Instruction number 17. There are certain kinds of murder which carry with them conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of a robbery. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree, whether the killing was intentional or unintentional or accidental. This is called the felony murder rule. The intent to perpetrate or attempt to perpetrate a robbery must be proven beyond a reasonable doubt. In order for the felony murder rule to apply under the robbery theory, the intent to take the property must be formed prior to the act constituting the killing. Instruction number 18. Robbery is the unlawful taking of personal property from the person of another in his presence against his will by means of force or violence or fear of injury immediate or future to his person or property, or the personal property of a member of his family, or of anyone in his company at the time of the robbery. Such force or fear must be used to 1. Obtain or retain possession of the property, 2. To prevent or overcome resistance to the taking of the property, or 3. To facilitate escape with the property. In any case, the degree of force is immaterial if used to compel acquiescence to the taking of or escaping with the property. Such taking constitutes robbery whenever it appears that although the taking was fully completed without the knowledge of the person from whom taken, such knowledge was prevented by the use of force or fear. The value of property or money taken is not an element in the crime of robbery, and it is only necessary that the state prove the taking of some property or money. Instruction number 19. Robbery may spread over considerable and varying periods of time. All matters immediately prior to and having direct causal connection with the robbery are deemed so closely connected with it as to be part of the occurrence. Thus, although acts about the property and may have been primarily intended for another purpose, it is enough to support the charge of robbery when a person takes the property by taking advantage of the terrifying situation she created. Instruction number 20. It is unnecessary to prove both violence and intimidation. If the fact be attended with circumstances of threatening word or gesture, as in common experience, and is likely to create an apprehension of danger and induce a man to part with his property for the safety of his person, it is a robbery. It is not necessary to prove actual fear as the law will presume it in such a case. Instruction number 21, while a verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. Instruction number 22, murder of the second degree is murder with malice aforethought but without the admixture of premeditation and deliberation. All murder which is not murder of the first degree is murder of the second degree. Instruction number 23, when it is impossible to commit a particular crime without committing at the same time and by the same conduct another offense of lesser greater degree, the latter is, with respect to the former, a lesser included offense. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, she may, however, be found guilty of any lesser included offense, if the evidence is sufficient to establish her guilt of such lesser offense beyond a reasonable doubt. The offense of murder, which actually charges the defendant with first-degree murder, necessarily includes the lesser offense of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or second degree, you must give the defendant the benefit of that doubt and return a verdict of murder of the second degree. Voluntary manslaughter is a lesser included offense of both first and second degree murder. Thus, you may only return a verdict of voluntary manslaughter if you first rule out both first and second degree murder. Instruction number 24. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought and without deliberation or premeditation. It is the killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. The provocation required for voluntary manslaughter must either consist of a serious and highly provoking injury inflicted upon the person killing, sufficient to excite an irresistible passion in a reasonable person, or an attempt by the person killed to commit a serious personal injury on the person killed. For the sudden violent impulse of passion to be irresistible, resulting in a killing, which is voluntary manslaughter, there must have been an interval between the assault or provocation and the killing sufficient for the voice of reason and humanity to be heard, or if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murder. The law assigns no fixed period of time for such an interval, but leaves its determination to the jury under the facts and circumstances of the case. Instruction number 25. The heat of passion which will reduce a homicide to voluntary manslaughter must be such an irresistible passion as naturally would be aroused in the mind of an ordinarily reasonable person in the same circumstances. A defendant is not permitted to set up his own standard of conduct and to justify or excuse himself because his passions were aroused unless the circumstances in which he was placed and the facts that confronted him were such as also would have aroused the irresistible passion of the ordinarily reasonable man and likewise situated. The basic inquiry is whether or not at the time of the killing the reason of the accused was obscured or disturbed by passion to such an extent as to cause the ordinarily reasonable person of average disposition to act rashly or without deliberation or reflection, and from such passion rather than from judgment. Instruction number 26. You are instructed that if you find the defendant guilty of murder or voluntary manslaughter, you must also determine whether or not a deadly weapon was used in the commission of this crime. If you find beyond a reasonable doubt that a deadly weapon was used in the commission of such an offense, then you shall return the appropriate guilty verdict reflecting the use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. Instruction number 27. A deadly weapon is any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon or device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. Instruction number 28. The state is not required to have recovered the deadly weapon used in an alleged crime or to produce the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. Instruction number 29. To constitute the crime charged, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charge, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Instruction number 30. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charge and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict of not guilty. Instruction number 31. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in this case. However, if the attorney stipulates to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proof. You must not speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Instruction number 32. The credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to have observed the manner in which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. Instruction number 33. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his opinion as to any matter in which he is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if in your judgment the reasons given for it are unsound. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw a reasonable emphasis from the evidence which you feel are justified in the light of common experience. Keep it in mind that such emphasis should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Instruction number 35. In arriving at a verdict in this case as to whether or not the defendant is guilty or not guilty, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. Instruction number 36. You are here to determine whether the state has proven beyond a reasonable doubt the guilt of the defendant from the evidence in the case. You are not called upon to return a verdict as to the guilt or innocence of any other person. So if the evidence in the case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. Instruction number 37. You have seen trial exhibits that have been redacted. Those redactions have occurred either by agreement of the parties or by court order pursuant to Nevada law. You are not to consider the fact that an exhibit has been redacted for any purpose whatsoever. Instruction number 38. It is a constitutional right of a defendant in a criminal trial that she may not be compelled to testify. Thus, the decision as to whether she should testify is left to Ms. Michaels on the advice and counsel of her attorneys. You must not draw any inference of guilt from the fact that she does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Instruction number 39. When you retire to consider your verdict, you must select one of your members to act as a foreperson who will preside over your deliberation and be your spokesman here in court. During your deliberation, you will have all the exhibits which were admitted evidence, these written instructions, the forms of verdict which have been prepared for your convenience. Your verdict must be unanimous. As soon as you have agreed upon the verdict, have it signed and dated by your foreperson and return with it to this room. Instruction number 40. During the course of this trial and your deliberations, you are not to, 1, communicate with anyone in any way regarding this case or its merits, either by phone, text, internet, or other means. Read, watch, listen to news or media accounts or commentary about the case. 3, do any research such as consulting dictionaries, using the internet, or using reference materials. 4, making an investigation, test the theory of the case, recreating the aspect of the case, or in any other way investigate or learn about the case on your own. Instruction number 41, if during your deliberation you should desire to be further informed on any point of law, or hear again portions of the testimony, you must reduce your request to a writing signed by the foreperson. The officer will then return you to court where that information sought will be given to you in the presence of and after notice to the district attorney and the defendant and her counsel. Playbacks of testimony are time-consuming and are not encouraged unless you deem it a necessity. Should you require a playback, you must carefully describe the testimony to be played back so that the court reporter can arrange her notes. Remember, the court is not at liberty to substitute the evidence. Now you listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind it is your duty to be governed in your deliberation by the evidence as you understand it, remember it to be, and by the law given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. All right, ladies and gentlemen, we do not want to break up the closing arguments for you, so we're going to take our lunch recess now, and then when you guys come back, we will have the closing arguments by the parties when you return from the lunch recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, or listen to any news or media accounts or commentary about the case. You must not do any research, such as consultation or use of the internet or use of record materials. You must not make any investigations, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own. You must not express any opinion regarding this case unless comments made to you. Ladies and gentlemen, it's 11:40. We'll be in recess until 1 o'clock.
All rise for the jury.
Alrighty, so is the jury going on? Is she gonna be guilty today? I'm sorry, I was watching a lot of other news and shit just in case they went to more breaks. So now it's time for the Mad Militant News Report. And what this report is, we got some huge storms coming across the country throughout the holidays. Basically, starting I think around the 17th here, and it's going to go all the way through the first. Look like tornado activity, very heavy storms, and this is all across the country. So y'all be careful out there, you know what I'm saying? Get your shopping done, get everything, you know what I'm saying, that you need. Make sure you grab some batteries, flashlights, candles, and all that other stuff just in case. We got people out here over the holidays shooting people for 29 cents a pound turkeys. Now that's crazy, boy. It look like the holidays is getting started off kind of wild here. 29 cents a pound turkey. And they was mad about the total price. Started a fight with the cashier. Then some guy stepped in to get the customer out of the cashier's face, and they decided to take it outside. Got holes all up in the food line windows and all kind of shit. All right, cool. I know I heard her dropping the witch call, but I was tied into something else trying to listen to. They made this case very boring with all those extra breaks. Yeah. Yeah. Damn headphones loud. Well, other news over in Phoenix, Arizona, that is. It looked like they're doing things to start a new beginning and crack down on prostitution. They hammer it down. They don't round it up about 50 prostitutes already, and it's like, but all this other stuff going on, that should be the least of which call. But I understand why they doing it, man. The motherfuckers need money. I mean, they can go get a real job, but we don't know their stories. Yeah, yesterday I brought y'all breaking news about Laney College over there in Oakland, California, with the sports director that got shot. Right now, he's still in critical condition, and the shooter is still on the loose. And evidently, this was a big guy as far as a sports coach. Man, this dude got like 17 titles in a row. Goddamn, over there in Oakland through the 80s and 90s. That's a bad dude. And it also looked like Cardi B is about to have her kid, if that matters to anybody. You know what I'm saying? Truthfully, I don't like the motherfucker. But she is about to drop her baby from a different guy that ain't her husband. Are they even still married? I try not to keep up with that celebrity shit. They corny and phony as hell. Majority of them. Oh shucks now. Well, we got a Cardi fan up in the house. Why you like her so much? Melissa? Are you aware that she don't give a damn about you? As far as a black woman. Now, if you are another nationality or something like that, then you don't need to be offended. But she really don't care about the people who really support her the most. I'm just saying. Look how she get up on social media and disrespect that daggone which go. I don't give a damn what they going through. You put this man on Front Street like that, and then you go out there and get knocked up by somebody else. Oh hell. I understand he might be dirty too, but he ain't the one coming out here airing out the garbage. She doing the same thing a lot of those content creators do that do those that come up here and put their whole relationship thing on social media and shit. She just another one of them. She looking for validation from the sisterhood of some fuck shit that she probably don't done. Not saying that that's all of them, but majority of them, the longer you listen, the more you realize they full of shit. Sometimes you can see what they saying and yeah, things might line up. But most of the time when you listen long enough, they full of shit. Or they lying about something, over exaggerating about something. I understand that he might be a serial cheater, but he's not the one out here blabbering his life all over social media. That is totally disrespectful. No matter who do it, that is disrespectful. What about prostitution? I know they're cracking out on prostitution in Phoenix. It's called Operation New Beginning. I guess it's a real bad thing out there that they got going on. Everybody's complaining about it. I think most of the time when you got situations like that, we need to look deeper into the city or what's going on in the city. Because if you got a large number and it's hot like that out there on these blocks, the community got to be lacking something. Because I don't think people are just going to pick this up as a career move. You know what I'm saying? What's going on out here that's making them go that way? What darn apples? Yeah, that is true too. It can go both ways. Yeah, it goes both ways with them. I can care less. Uh, I just don't like her. Period. She's a culture vulture, and usually I don't give that. I don't just hand that title on anybody. You know what I'm saying? I don't give it to Eminem or anybody like that. But her right there is like, you're disrespectful to black folks, but you're getting rich off of something that we created. Now, if you talk to New Yorkers and stuff like that, they'll probably tell you, well, the Puerto Ricans and all them was at the start of hip hop and all that stuff too. All them motherfuckers did was dance. As far as what I remember, yeah, they were some pretty good break dancers. But as far as the sound of hip hop and you know what I'm saying, the root of it, even though they was right outside, right out there with them, I don't see no Puerto Rican cool hurt or nothing like that. You know what I'm saying, in the history of New York hip hop. So no Puerto Rican Grandmaster Flash. It would be alright if she wasn't so disrespectful online. You don't hear him calling her all kind of bees and stuff, but he's all kind of niggas and all kind of stuff. And it's like, yeah, I'm gonna leave it to the ladies. The ladies allow this woman to get away with that shit, no matter what that man is doing. All I can do is really just be upset about it. Stop buying her albums. Take some money out of her damn pocket for doing that shit. Something. That's like one of the two females I'm actually pulling out of my library is Cardi B and that other chick, that Meg Thee Stallion. I want both of them up out of my library. I don't want to hear no more of their music. These women are trash. I would rather listen to Sexy Red. And I can't name one song of hers. She remind me of the female Fat Joe. Like both of them just culture vultures. They brought nothing into the art. He ran around talking about, I'm crack. I'm Joey Crack. Just proud as hell to just be Joey Crack. And she just a nasty ass woman. You know what I'm saying? Teaching our young women got there going all kind of shit. And let's not forget that she used to drug men to get them robbed. Let's not forget that. There's a lot with this woman. That's why I don't understand the support. If it was anybody else, they'd be locked down on that shit. If it was a man goddamn spiking women's drinks and stealing pussy and shit, well, they would hate that man to death. But it's okay for her to goddamn go and drug men and goddamn get them robbed and set up and shit. Stealing their money. The game ain't fair, man. The game ain't fair. Happy birthday, little bit. I ain't mean to beat up on your home girl and stuff on your birthday. You know what I'm saying? But the report did just come out and stuff. She was on tour and stuff, and she was about to have the baby. So Tory Lanez, I believe I read that yesterday. Tory Lanez, his what you call it, his appeal or something. You know what I'm saying? Didn't go through. He's still locked up. That's the shit that got me mad at Megan. Now the report saying something totally different than what the people were actually out here saying. How did they get this way? You lying motherfucker. You got this man locked up for nothing. When it looked like you could just step on him. How much of a danger he is to you? Maybe he did shoot you in the foot because your ass so damn big. Yeah, I don't know. It's possible. But as far as what the report said, it looked like your friend was one that got there going you shared a problem with. Yo, big dog, you over there feeling better, man? That better be the real guy got there going to walk around with that damn logo there. See, let me check you out, man. ID check. This account has nothing on it. It looked like it was made today. I'm gonna have to do you like Google. I'm gonna need a test question. Hmm. Or just shoot me a text. I'm waiting for him to text me to make sure it is him before I start shooting up in this sucker. That means you walking around here with a stolen logo. I kind of take that personal. I think the chat might be behind a little bit. I'm still waiting for a text message. All right, squad. He got 2 minutes. If he don't respond to my text right then, get ready to fire. Let's see who gets him first. Oh, fuck that shit. So evidently we got an imposter state gang member running around the damn streets here. I think we need to find out who this motherfucker is, because right now they walking around with my shit on their goddamn profile. And they using goddamn Gabe's name, goddamn. So goddamn open season on this whole ass nigga goddamn thinking that shit cool. Nah. I just sent Gabe a text like 3 minutes ago. Gabe should be sick in the bed. I mean, so got the email right. I mean, they might as well make a new account now, man, because your date and all that stuff, man, you just fucked up right now. Yeah, there you go. Even if you change the name. Word, I got y'all. Yeah, I checked that out because it was like something wasn't right. You know what I'm saying? Because he haven't even sent me a text all morning. He just gonna pop up in the chat when I already know. I already know what time it is. That's stupid. You know what I'm saying? I mean, that's one of my main homies. Got there, go on. I'm gonna know what time it is. Got there. He's not just gonna drop out the bushes at this moment. Now, if it is him, then I'll correct it. But I know I just sent him a text and he didn't respond back. And usually he responds back immediately. Oh, it is him. Well, it took you long enough to say something. I mean, I was talking all kind of shit. You know what I'm saying? And you still didn't come out. So you know I don't play those games. I got to stand on my top security badge, man. You know we don't allow no perpetrators coming around on our shit. I mean, Tanya, it took him long enough to respond. You know what I'm saying? I mean, damn, how long was that, man? I was talking junk for a minute. Got there going, and yeah, I just looked over at it. You just said it about damn 35 seconds ago. Unless the unless y'all's playback is a couple of minutes behind here. No, because I was just talking to Melissa and them. It was on time. Man, you know we don't play no games, Gabe. My finger always itching for a block. Sometimes I feel like playing around a little bit before I block them. You know what I'm saying? So, man, it looked like you got a bad storm in your area today. They said potent. They don't never use potent goddamn when it comes to weather. I mean, I am, man, and I have calmed down a lot, man. You know what I'm saying? Because there is a lot of people I just don't know, and if you say something slick, you might get got. You know what I'm saying? But I got to know who's really who, because you know what I'm saying. I just can't just be shooting the club down and shit. You know what I'm saying? I know that. I told everybody that they sent you all. They sent you all the good wells and the pray hands and all that. I think it was like 2 days ago. Like I said, that's between y'all. I ain't getting into that shit no more. That shit is old and played out. If you haven't sunk that damn battleship yet, then goddamn, that's on you. But if I was that turned up about it, I would have goddamn did some damage. You know what I'm saying? I'm just saying. I can't do it for you. I, I could throw the first punch, but I gotta know that you coming behind to finish up the business. You know what I'm saying? Or something. Yeah. I think she might be in the chat. Did anybody see the aurora borealis the other night go across the sky? I think it was like 2 nights ago. So it might be still a little bit left out there as far as what you call it, more in the northern. Because I think I told y'all the wrong area. I thought it was going to hit the South Pole, but it actually hit the North Pole, and it lit up the sky. It was a lot of red night skies out there, sucker. Pink and purple and all kind of stuff. I know I need to find something. I need to find somebody who put it on video so I can move it over to the Quiet Storm. I already got one, but I want to see some more up to date, more live as far as try to remix that shit. I think the top selling shoe this Christmas might be the Caitlin Clarks. It seems like nobody else's numbers are moving. Aja Wilson shoe ain't selling. They're going on that other chick that look like a giraffe. What's her damn name? Yeah, I forgot her name that damn quick. She called herself a star. But yeah, as far as I guess the men buying them too, man, because I'm seeing them in the NBA players wearing them and all kind of stuff, man. Everybody getting the Caitlin Clarks, man. She's supposed to equal out the Jordan as far as the sales and numbers. She got a pretty big jump so far. I'm not even sure how much her shoes are running, but I know they everywhere. They even got them as football cleats. I'm seeing the football players wearing them. So they supporting this female athlete, which I did too, man. I was an Indiana Fever fan all season for the first year of watching the WNBA after 26 years. You know what I'm saying? I didn't see her play much. I seen her play a little bit last season. She can ball. The hate she getting ain't right though, because none of those other chicks did anything to draw the attention to that league the way she just did. So some people get it, jump on board, and start advertising themselves, making their own money. Other people just sitting back and complaining, want handouts. I was here longer. I did more. And it be motherfuckers with no championships that be saying dumb shit. That's the shit they be tripping. Yeah, I think they keep a majority of the team together from what I'm hearing. If you see any of the players in the small videos, the shorts and stuff, I think those are the ones who stand, because anybody else they're not allowing to be part of those kind of events. It's like the events you see them doing and stuff. So everybody else is going to be scrambling trying to put their team together after all this free agency and stuff, and they're going to keep the same pieces. Automatic championship. So for any sports betting people, I would stay with Indiana. One whole minute away from the finals. It wasn't even supposed to be that far. They were finishing halfway through the season, man. 7 injuries, 6 replacements in one season. Same team you started off with ain't the same team that ended. And they still took the world champions to the 1 minute left in overtime without their star players. I was telling everybody when it happened, man, they're gonna make a movie off this damn season right here. This shit was a miracle. Even though they lost, this was a miracle season. I'm glad I was in the right spot at the right time to see it. Ohio State Buckeyes #1, but the, I think Iowa is the Hawkeyes, right? Yeah, Iowa looks real strong. Did you see what they did to them girls the other night? Man, it was like 120-33. I'm gonna start sharing where they watching the games at, man. They go, man. It's insane. It's like they blew them girls out. I would have stopped playing. I would have went back to the locker room with a fake injury. It was nowhere in the world I was gonna finish that. 120 something to 33 or 34, some shit. I think one quarter they scored like 4 points. That's bad. Or the other team is just that daggone good. Oh no, I haven't got back into college football just yet. I'm watching more of the basketball, men's and women's. You know what I'm saying? Because it's like football is a wash. In the NFL, it ain't the college fault. It's the NFL's fault. It's washed up. The NBA is washed up too, but I have more hope in that because people like LeBron James and all them are on their way out. They destroyed the league. They destroyed the league from 2003, 2004 to now. So, and then Kaepernick killed the NFL back in 2017. And I was with the brother when he took the knee. I was like, yeah. But when he didn't stand on business, you know what I'm saying, man, it threw me away from the whole game, man. You used a political moment in the middle of sports, which should never be done. And then you don't follow all the way through. When the whole world was watching at that point, you had the world's attention. Yeah, the NBA just started a couple of weeks ago. And college, I think they're about 3 or 4, some teams about maybe 3 games in, 4 games in. Well, the men are okay, but right now I think everybody's paying attention to the up and coming women. Because like that one person, Caitlin Clark, just changed the whole dynamic of how they looking at the game and the new people that's going to be coming up to get rid of this old guard stuff as far as bullshit basketball we were seeing in women's sports. That basketball they was playing, man. I go back and watch old highlights. It was like they was getting away with this. They not making no money. The NBA is holding down all y'all salary, and you don't even go out there to try. It just looked like a free check. WWE is losing me right now, unless they make a change real quick. And that guy need to be fired. No matter how brutal it was always still a family show. No matter how tough it got, it was always a family show. This is some bullshit right now. It's like you can't get a family to tune into that crap, man. They numbers suck. I don't even think they cleared 1 million on Monday night. Maybe 1.2. They might have got 1.2 million watching. That's bad numbers, man. For wrestling. Wrestling used to go toe for toe, got daggone with Monday Night Football. We used to be flipping back and forth, back and forth, back and forth. Now there ain't no point to even watch even one of them shits. Oh, my fault. Ebooks Gabe over here in Truth Chat. I just seen that. Got too many daggone chats open here. The owl don't miss nothing. Everybody loved it back in the days, man. Through the '90s, well, the late '90s. I skipped out a little bit on the early '90s. Late '90s was the shit. Late '80s was good, but come up to 2000s and stuff, it probably halfway through. I think I took about 15 years off almost. I haven't seen no news on 3 Eye Atlas. I guess it's still behind the sun there. We're waiting for it to re-expose itself. I think it got about another 15 days just behind the sun to where it's visible again, so we can really see what this thing is. Because I think we want to be at a closer range for our telescopes, which is strange. We should have telescopes that be able to see anything with all this information they be giving us, trying to give us about the stars and shit. It's like now they're making a big fuss about we seeing the backside of the moon. Man, you should have seen the backside of the moon 50, 60 years ago. What you talking about? I mean, yeah, I can't find this crime that I ran across yesterday, so I can lock it into my playlist. YouTube make me sick. Oh gosh, this is a dumb fool right here, boy. I know I got to save this one. And she's black, but at least this is a crime show, so this is a real crime. We got daggone, but we remember what I said, man. We got to watch a lot of these shits, man. A lot of this AI is fucking up shit. It look oversaturated, man, with just violent black folks, and majority of them be women. It's like, where did all this come from all of a sudden? Now we all know we got some crazy sisters out there, but this is a little bit too much. It look like everybody's going crazy. And they be willing to fight cops, boy, dudes, and they just know when to give up. Like, man, all right, fuck it. Y'all got me. Chicks, boy, they be ready to knuckle and buck, boy, with these damn cops. No, I'm for real. You know what I'm saying? I mean, they doing some outrageous things like this one here. Keep it. This one says Dollar Tree manager caught stealing $5,700 cash in her first week of the job. Right? I'm thinking, damn, this is a white chick. As soon as I click on the video, it's a black face one. They got daggone. The ones that I collected yesterday, you wouldn't even believe, man. It's like the cases that we watching ain't shit compared to the shit that's really popping up. And I'm starting to think, is this shit even true? Is this AI playing mind games with us or something, man? It's like, and I'm looking for all demographics. It's hard to find a lot of men crimes right now. as far as men just doing stupid shit, cops pull up, you know what I'm saying? Traffic stop. It's hard to find a lot of those shits, man. And all you seeing is black women. No bullshit. A lot of them be shoplifters, boy. That shit be crazy. They be trying to walk out the store with no bags, man, just caught full of shit. Now, a lot of these shorts I don't believe, but when it comes down to the actual cop channels or camera channels, they're more believable because you can actually see everything going on and stuff. You know? AI will be a problem because another thing I have heard is that they're going to use AI to frame people. We got to watch the information that we putting out here on these apps and all kind of stuff. They taking that shit. Even if you put a personal picture of yourself in a cloud or something, you know what I'm saying? You don't know who can go through these clouds and stuff, get your facial features and everything, lock that shit in. Who knows? In about 200-300 years, you might be still walking around this motherfucker. Because what I'm living forever, I'm starting to think is AI. You're giving all your information to this thing. You know what I'm saying? On a lot of these apps, they creating things for you. They following your rhythm. They follow everything that you're doing, and they recording this. Or they're going to be robots of you running around in the next 200-300 years and shit. Your identity, your personality, all kind of shit. That's how we got to think about this. Like I said, a lot of this was already pre-written. They go to church every Sunday and learn it. You know what I'm saying? But you got to start asking yourself, who is the God that gave that these words are speaking of in the book? Since we know the source of how it was handed down, the sources of how it was handed down over time, and in the book it tells you, thou shalt not know the beginning or ending of God's work. So how are we gonna have a Genesis and a Revelation? We shouldn't know neither one of those unless this shit is a part of a playbook. I'm just saying. I could be wrong. Not to offend no religious people, but we just got to open our eyes more. I was there one time too. I mean, they the only ones telling you that if you believe in this, you'll live forever and all this. You know what I'm saying? But if they are actually playing the power of God this whole time that we can see, how do we know that this wasn't a setup just to keep you under control till it was time for them to make their move on what generation they was going to do it on? When I reopened the Real Mad channel, I'm going to start exploring more into that. Start showing things that people don't know, haven't seen, and things like that. So, because I don't want y'all to think that I'm just high and I'm just talking out my ass. But there's a lot of stuff out here that they haven't told us. A lot of stuff we for some reason it's hard to accept. You know what I'm saying? Because we haven't heard this before, something like that, and it makes it easy for them if we just stay stupid. I got the definition for faith here in my notes. Because what I learned how to do
You know what? You
is
know
plan
what,
for battle.
man? I was gonna do my
Huh?
real time. I said I was gonna do my body cam videos tonight, but I'm gonna do my that these religion, well, not, I'm not gonna actually talk. I'm gonna listen to conversations between religious people and the atheists, and like it's really scary how people spend reality to believe a goddamn book. It's really, really scary. But then in some instances, they'll be like, nah, that ain't right. That's not right. That shouldn't happen that way. But then they'll still be like, but this God's plan. You're like, wait, what? So you agree it's wrong, but you still rock with it? Not saying you gotta leave, but God, dog, that doesn't make you pause. So yeah, I think that's what I'm gonna do tonight.
I
What's
mean,
going on,
it made me pause. It made me look at things with a bigger mind. You know what I'm saying? Because just because you know something, that don't mean that you know it all. You know what I'm saying? We don't look at our lineage. We don't look at nothing containing to this book. We don't look at the mathematics. We don't look at the science in the book. We don't look at the astronomy in the book. We don't look at none of that. We just go off of what the words in the story is trying to tell you. When all of this stuff is mixed all up. All these people live.
There's some good shit. There's some good shit in the Bible that you can take, but I can take some shit out the Bible that's good for everyday life, but I don't connect it to divine being.
Yeah,
it's some good shit in Proverbs, but I don't attribute it to God.
Hey, that book is telling me that anybody can actually have a verse in that book. You know what I'm saying?
This is my question, man. God created the world, but he couldn't write his own goddamn book. He could do everything, create a book. Another one, the Tower of Babel was destroyed because humans was trying to get close to God, but we got airplanes and spaceships and missiles and shit that he allowed them creations to be made, but Tower of Babel, nah. They just want to be close to God. They didn't do nothing wrong. They want to be closer to him to serve him. And then he said, and people say God is not the author of confusion. Well, when he destroyed the Tower of Babel, he split the people up and gave them all different tongues so they could be confused. It says that in the Bible. So they could never come together and do that shit again.
It's a lot of things that can be. I mean, it ain't confusion if you have enough pieces. It's confusion if you just stick just to that source of information. You know what I'm saying? But once you expand and get the background stories of a lot of this stuff that you can actually go find, you know what I'm saying? A lot of these things are still historically on the planet. That outdates a lot of this stuff that's on the planet. You know what I'm saying? It's so much stuff that we got to look outside of the book for. You know what I'm saying? To make that make more sense. You know what I'm saying? Because just because somebody say that they atheist, I mean, that's a weak move of trying not to find out what that person knows or what made him really atheist without being judgmental or anything. You need the knowledge without being judgmental. Because a lot of judgmental stuff blocks stuff that should be getting to you that could improve your life. You know what I'm saying? Off the information that you already have. Like I said, I had to close the book. And then when I reopened it, I understood it a whole lot better. You know what I'm saying? I had to go get all the missing pieces. I had to go find myself. If he is within you, why are you constantly in a book and not searching within yourself? The Last Dragon, the movie showed you that. He was looking for the master. He always had the master within him. Boom shakalaka. That boy ran all around New York City looking for the master. Master with him the whole time. Every time he turned around, he only see one set of footprints, but the master's with him at all times. How did I get into religion? I can go on for months. But back to other news. Houston, we have a problem. NCAA banned 6 players for rigging games as illegal gambling. Oh, I didn't see that story come out 3 days ago.
Y'all think y'all got somebody else told you. You don't know. It's just like everybody. I seen a post the other day and I was like, damn it, I've been saying it forever. How come don't nobody say hell just gained the demon when nigga die? Y'all know y'all ain't shit. Y'all still be like this nigga
Well,
don't.
you crackling up real
Instead of
bad.
being real. This the what shit. All right. I still cracking up. Everything finna drop.
Yeah, you eating crackers over there. Yeah, back to that definition of faith. Can't find my notes. Oh, but I should know it, man, because I wrote it in my notes. Faith is believing in unverifiable thoughts. We can't verify none of this stuff that we're reading in this book. They made it that way. You know what I'm saying? Because actually, you know what I'm saying, the things that they writing in the book, to me, don't seem right for what you can actually see on Earth. If all the writings are in the Nile Valley, as far as Egypt, Cairo, and a lot of these temples, the Valley of the Kings, all these writings are in those spots. Why are we looking at Israel or any of these other places when all the writings are down in the South? You know what I'm saying?
Egypt wasn't the first civilization, so there's that.
I know, I know that we was reconstructing something that happened 6,000 years before, but then there's a lot more missing than just. I mean, man, boy, you should see what I don't found, boy. That me and Gabe going deep. I mean, we deep. Yeah, they're going. This is some shit, man. Got that, man. Yo,
What I had said before I had shut down. I said, how come people don't ever say hell just gained another demon when they folk die? They know they folk wasn't shit, and they still be like, he in heaven. No, the fuck he ain't. If y'all believe that book. Tyrone was a motherfucking menace to society. Nobody will ever say that nigga gone to hell.
Yeah, we got to start breaking down the what do they call it, the roots of the words that they're giving us. You know what I'm saying? Get down to the roots of what these words really mean, like belief. The word lie, like you lying, is in the middle of the word belief. You know what I'm saying?
Or the word religion, which means to bind. Religion literally is translated into bind. But nah, I ain't got that type time. I play shit and just keep it moving. I ain't got that time. Now 10 years ago, I had to sit there and argue with motherfuckers all day. I ain't got time for this shit no more.
Oh man, they would have hated me 10 years ago. I had to learn how to really come off to where I'm being heard. I'm gonna put it that way. Because when you do start really receiving the information, you do feel an obligation to start smacking as many people awake as possible when you start finding shit. Like, what the hell are you talking about? Have you seen this? Man, shut the fuck up. You see this shit? You know what I'm saying? So it's like first time I seen Noah's Ark on the wall and shit, and then it had nothing to do with a flood. That shocked the shit out of me. And his name wasn't Noah, it was Khufu. I put it in one of my videos. I need to go ahead
Hey,
and
bro,
unhide my
did you
channel.
know penguins left the man? Did you know penguins left the North Pole to get on the ark? They went all the way to Africa to get on the ark. That was a trick.
Kangaroos came from Australia too to get on the grizzly bears, black bears, everything swam across oceans and stuff just to get on this one ark to be saved. It don't make sense. But that's how they wrote it down when actually it's wrote in the real way in stone in the oldest form that we can find at this point in certain areas of the country. With our faces goddamn walking like Egyptians on the wall. Richard Pryor tried to wake us up. Nobody wanted to listen. They thought he was joking. You know what I'm saying? That was a funny episode when you go back and watch that shit.
Fuck the Egyptians too.
We found, yeah, they was that's what we can call them is Egyptians. We don't. I can't even really tell you their real name at this point. I'm pretty sure I'm gonna come across it eventually. You know what I'm saying? But they just a reconstruction of something that we didn't think we had over 300,000 years before that. We've been here a whole lot longer than what they say we've been. They don't allow us to go to certain places on this planet for a reason. I don't even think the ice age or Antarctica was frozen more than 1,000 years ago. That's what I'm starting to see. They saying this place down in the south, goddamn, been frozen for thousands of years. No, I think it's been frozen for a couple hundred. We got maps in green. We got places in the north they ain't telling us about. They don't allow planes or nothing to go that far. Restricted airspace. You know what I'm saying? They saying there's pyramids at the top of the North Pole with a big ass black pyramid sitting there. We'll never see it because we can't go that far. You know what I'm saying? They don't allow you to do that. Whole cultures of people that we never heard of that was only here about 500-600 years ago. Why they erased out our history, I don't know. When they ran the whole world and their structures are here to still prove it. Because we can't reduplicate even the things that they did 1,000 years ago. Or back in the 1800s. we look stupid compared to the people back then, and they had horse and carriages, supposedly.
I go Judge Hatchet. All right, I gotta go pick up the youngin. I shall return.
the jury's all present and accounted for.
We are back on the record of C 377239, State of Nevada versus Devyn Michaels. May the record reflect that Ms. Michaels is present with her attorney, Deputy District Attorneys on behalf of the state, and both parties stipulate to the presence of our jury.
Yes, Your Honor.
Yes, Your Honor.
All right. Ladies and gentlemen, we have now reached the portion of trial where closing arguments will be given. Since the state has the burden of proof, the state will get to begin and close the closing argument. State, are you prepared to give your closing argument?
Yes, Your Honor.
All right, whenever you're ready.
The truth is the truth. It shouldn't change. And the truth is, the walls were closing in on Devyn Michaels and the fantasy that she had put together. And what was her response when her children were taken away? Jonathan had custody, and this was in danger. She did the unfathomable. She murdered Jonathan Millett. The crime charged in this case is murder with use of a deadly weapon. You heard from the judge. She did read that to you folks prior to our break. So what it is willful, unlawful, felonious, and with malice aforethought, the defendant killed Jonathan Millett, a human being, with use of a deadly weapon, be it a wooden stick and/or an unknown object, by striking the said Jonathan Millett with the said wooden stick and/or other unknown object, and/or through other unknown means. The said killing having been 1, willful, deliberate, and premeditated, and/or 2nd, committed during the perpetration or attempted perpetration of a robbery. Let's start with the easy one, the deadly weapon. You heard from the defendant that she hit Jonathan Millett with a stick, and he died. So this is clearly showing that that stick that she described to you is a deadly weapon because it resulted in the death of Jonathan Millett. Now I want to point out something very important that's in your instructions, and it's not something to gloss over. The state is not required to have recovered the deadly weapon used in the crime in this case. So keep that in the back of your mind that we are not required to do that. However, we have the confession from the defendant that that is what she used. So that being said, you'll have your verdict form when you go back to deliberate. So I think it's helpful to sort of walk through that. So based on knowing that there was a deadly weapon used beyond a reasonable doubt, we're able then to eliminate guilty of first degree without, use of a deadly weapon, and also guilty of second-degree murder, and guilty of voluntary manslaughter. So all that we are left are those charges with use of a deadly weapon. Let's talk about murder. Your instructions tell you that murder is the unlawful killing of a human being with malice aforethought. Whether express or implied, the unlawful killing may be effected by any of the various means by which death may be occasioned. So let's talk about malice aforethought. What does that mean? That is the intentional doing of a wrongful act. So I don't think anyone is going to get up here and say that this was not a brutal first-degree murder. Knowing that, defendant's actions were not voluntary manslaughter. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought, without deliberation or premeditation. It is a killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. That is not what we have in this case. The defendant said in her statement to the police, told the police, that she was giving Jonathan a back massage while he was laying face down on his bed. She was next to him. She got up off the bed, made the conscious decision to then walk over to that fireplace that we all saw, grab what she described as a candlestick, an object, right? Walks over, makes a conscious decision to then walk over, goes to the bed, and while Jonathan is still face down, with his head facing away from her, as she told us, she took that stick and bashed the victim in the head. He had no clue that this was coming. conscious decisions every step of the way. His body goes limp. This is not voluntary manslaughter. The instruction also tells you if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murder. The defendant did mention that the victim, Jonathan Willett, had rubbed on her leg. And then she kind of just shooed it off. It was like, okay. And then, after that, he seemed happy, right? His face was turned away, he thought he was getting more of a massage. But instead, the defendant made those conscious decisions that I just went over and bashed him in the head. This is not voluntary manslaughter. So that being said, when you go back to deliberate, you'll have this form again. We've already crossed off the ones that don't apply, so let's cross off the other one. Voluntary manslaughter with use of deadly weapon. Because no one's going to get up here with reasonableness and say that this was voluntary manslaughter. So then what are we left with? First degree murder. You were instructed that murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. What are those three elements? Willfulness, deliberation, and premeditation. And I do have a graphic photo here, so I just want to warn everyone, including in the gallery, that there will be a graphic photo. This is first degree murder. What is willfulness? Willfulness is the intent to kill. There needs be no appreciable space of time between formation of the intent to kill and the act of killing. What is deliberation? Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. This is very important, and I am going to spend some time on this. A deliberate determination may be arrived at in a short period of time. The best way to illustrate this is the stoplight example. So all of us drive to work, we're on our way to work, and there's a stoplight. And sometimes that stoplight turns yellow. And when it's yellow, you're making some conscious decisions at that point, right? Either you're taking the decision to press on the brakes, but during that you're deciding, well, is someone going to rear end me, right? If I just stop on my brakes, right? Is my coffee that I just bought from Starbucks going to fly all over the car, then I'm not going to have coffee at work if I slam on my brakes? Is my purse going to fly off the seat, and I'm already running late for work, so how am I going to have time to put all the items back in my purse so I can walk into work? If I press on the brakes, I'm going to then potentially be late for work. And I've already been written up a couple of times, so this may be the time I'm fired. All of this is going on in your head when you're faced with that yellow light. You're also thinking, well, I obviously can't press on my brakes, right? So I'm going to have to blow through this light. But what are you thinking about when you're going, making the decision to run that yellow light that's about to turn red? You're hoping there's no cop, right? You're hoping that a motorcycle doesn't come out from nowhere and you hurt someone. You hope there's no bicyclist that's just somehow hoping that you're going to stop at the red light because they see that it's yellow. All of these are conscious decisions that you're weighing, and that is all deliberation in a short period of time. We do it every day. Again, it need not be for a day, an hour, or even a minute, this premeditation, this decision making. It may be as instantaneous as successive thoughts of the mind. The stoplight example. No matter how rapidly the act follows the premeditation, it is premeditated. That is what happened in this case. When the defendant made each conscious decision ending Jonathan Willette's life. We also have another theory of first-degree murder. That's called felony murder. There are certain kinds of murder which carry with them conclusive evidence of malice aforethought. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree. So what is a robbery? You are instructed that robbery is the unlawful taking of personal property from the person of another, or in his presence against his will, by means of force or violence or fear of injury, immediate or future to his person or property, or the person or person or property of a member of his family. Such force or fear must be used to 1. Obtain or retain possession of the property, 2. To prevent or overcome resistance to the taking of the property, or 3. To facilitate escape with the property. We heard a lot of evidence over the past 2 weeks, which is why I'm slowly going through this today. We have evidence that the defendant took multiple items of Jonathan's belongings. Social security card, a wallet, his only set of car keys. Why did she want those things? How was she going to enroll the girls at school without having Jonathan's documentation? This all goes into her motive. The defendant obtained Jonathan's property by means of force or violence, i.e., she killed him, and took his wallet, his only set of keys, and his social security card. This is another easy one. That being said, you'll have your verdict form. And between both theories of murder, we are confident that you'll be able to check that first box and at this point eliminate the second-degree murder. But that being said, any way you look at this case, this is first-degree murder. And this is important to note, because when you go back there, you're doing an important thing. But what is also important is that while a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. What do all those words mean? That means when you go back there and you're carefully weighing the evidence in this case, if 6 of you decide that the state has proven beyond reasonable doubt the felony murder theory, and 6 of you decide that it's the premeditated deliberate, that doesn't matter. The verdict would be guilty of first-degree murder. You need not be unanimous on the theory of first-degree murder. So there's been a lot of talk over the past 2 weeks about Devyn, and we're not shying away from this. You saw him testify on the witness stand. There is overwhelming evidence beyond what he told you that Devyn did not murder his father. Let's go through that. We'll start with Devyn's testimony under oath. He tells you that he saw his father, Jonathan Willett, at that Porcupine Rim address, the house that he and Devyn shared, briefly on August 6th. You'll recall that he saw his dad in the garage and just went right back inside. They never had a discussion. And he was home at the Porcupine Rim address on August 6th. He told you that he was helping the girls, his sisters, Devyn's daughters, with homework. The defendant, Devyn, tells him that she's going to help John move some things. He goes on about his night. He stays at the house, he watches a movie with the girls, he puts them to sleep. This is what he's telling us. He goes to sleep around 10 p.m. He woke up, he recalls around 2 a.m. to see Devyn getting in bed, which they shared at that time, and he just went back to sleep. He woke up at 6 a.m. the next morning on August 7th. He gets dressed, he goes to work. Even if you don't want to take his word for it, which we believe you should, we also have other evidence to corroborate what Devyn told you. This is a text message that Devyn sent to the defendant, Devyn Michaels, where he texted her, "See you when you get back. I'm going to sleep. Girls are in the living room." corroborating that he put the girls to sleep, and he was going to sleep as well. This was on August 6th, 2023, at 10:36 p.m. We also have video surveillance to corroborate this. No video surveillance shows Devyn's vehicles in Paladura's neighborhood, Paladura being the murder house neighborhood. No vehicles belonging to Devyn are seen. And we spent a lot of time going through that video surveillance on that lengthier day of trial, showing you that there is no indication that Devyn's vehicles are in that neighborhood on the night of the murder. There's no video surveillance showing Devyn's vehicles entering or exiting Porcupine Rim neighborhood, the neighborhood he lives in with Devyn. Remember that fixed camera? There was no indication that his vehicles left that evening, or entered, for that matter. Devyn's vehicle was in the same position overnight. You recall there was sort of that catty corner home that had that footage showing the daytime and the nighttime, and the van, Devyn's van, remaining in the same position, to a T. There's also no video surveillance showing Devyn jumping a back wall to get in another vehicle. There is no evidence of that. What we do have is Devyn leaving in his work van at 7:31 a.m. on August 7th, because that's what happened. We also have the CDR mapping, which also rules Devyn out, beyond his work. If you recall, there was that Detective Good testified pretty in depth. He had color-coded the different phones so that you could see with ease which phones were popping up at which times. You recall Devyn's was green. We see green popping up at that Porcupine Rim Street, which is his home, throughout the night, and more importantly, during the time period of the murder, which we'll talk about later, because we are able to narrow that down. At no point do we see Devyn at the murder house the night of the murder, and even more importantly, during the murder. Again, I explained this, I just want to show it. This is that footage of the nighttime. We see, if you recall, up in that top right-hand corner, we see the victim's truck, Jonathan Willette's truck. We also see right next to it, Devyn's work van. This is the night of August 6th. This is the next morning of August 7th. There's that same work van, Devyn's work van, in the same position. Nighttime, daytime, nighttime, daytime. Never changing. Physics also ruled Devyn out. A lot of discussion about how he jumped a back wall, he took the road that's one house over that, not the road, but the little dirt path, right, to get all the way across town. 7.5 hours? No. That's not common sense. I also think it's important to highlight Devyn and the defendant's relationship, Devyn's relationship. Devyn is a master manipulator, and that is shown through the evidence. This is a woman in her late 30s that decided to begin a sexual relationship with her 19-year-old stepson, who had just lost his virginity. I'm not going to get up here and say that the 19-year-old teenage boy, this wasn't his dream to be with Devyn Michaels, who was an older, more sexually experienced woman. But what I am going to say is that the defendant is the one running the show here. This was her fantasy, and he went along with it. For a while, though. Because remember, he tried to move away to California on multiple occasions, and somehow she was able to spin her web and bring him back. The most glaring portion being when she uses a supposed pregnancy against Devyn to bring him back to Las Vegas. When she threatened him, I will have this baby, and tell everyone whose baby it is if you don't move back to Las Vegas. So what does young Devyn do? He moves back to Las Vegas. He doesn't want a kid at his young age, and even complicate his relationship with his family that doesn't know about their relationship or their sexual engagements. There's also messages that show that Devyn was in charge of this relationship. He tried to get out multiple times. So now that we've talked about this could not be Devyn, let's talk about who's on trial today. Devyn Michaels, the defendant, and how there is overwhelming evidence that she committed first-degree murder. I'm going to go over a roadmap of all the different evidence that you heard in the past 2 weeks and sum it up as much as I can. We'll start with Yoko and Yoshida's testimony, Devyn's inconsistent statements, so her own words, the scene, the DNA, the burlap, which we heard about today again, CDR mapping, video surveillance, the phone contents, and we'll also talk about the custody case and those witnesses we heard yesterday. I think it's very important to start with the timeline because, as Mr. Giordani said, this one's a wild ride and we have to buckle up. So let me start with the timeline here. The timeline starts August 6th of 2023. Devyn, John, the girls, they're all shopping for the girls' first day of school. At 8 p.m., Devyn arrives at the murder house in her vehicle, and Yoko confirms this. At 8:42 p.m., Devyn, the defendant, and John drive to Devyn's home. At 9:40 p.m., Devyn and John drive back toward the murder home. 10:04 p.m., Devyn and John they get to Chevron. They're there for a few minutes, as we saw, and then return back to the Paladura neighborhood at 10:12 p.m. And that's even confirmed by Yoko saying that she saw Devyn and John, and that's when John began to prepare a meal for himself. At 11 p.m., a person places something in the Nissan Armada, Devyn's Nissan Armada, moves the Armada in front of the murder house. And what's notable about that, and I think it's important to highlight, is it went from being in front of the camera to being out of the camera, but more importantly, closer to the house, right in front of the driveway, and nose to nose with Jonathan's truck, which we see was in the same position the next day based on the surveillance, as well as the testimony from the officers in this case. We then turn to August 7th, 2023. At 1 a.m., Yoko runs into Devyn for about 15 minutes or so. At 2:04 a.m., Devyn leaves the murder home in her Nissan Armada. At 2:39, she's at that CVS drive-thru that we saw the surveillance video for. And then at 8:40 a.m., there is that 911 call from Jonathan's mother when she discovers her son dead. We can then safely say on this timeline that the murder that Devyn committed occurred between 10:12 p.m. and 2:04 a.m. So knowing this time frame, we're able to look at the corroborating evidence. Let's start with Yoshida's testimony. The day before the murder on August 6th, he sees Devyn at the murder house. And more importantly, he also saw her vehicle at Paladura. We heard from Yoko. Again, around 8 p.m., Devyn arrives at Paladura in her Nissan Armada. Devyn and John then leave in John's truck. Around 10 p.m., Devyn and John return to Paladura. Yoko sees them. After seeing them, she goes upstairs. At 1 a.m., she goes back downstairs. She runs into Devyn, and what did she describe to you? Devyn looks surprised. Why? Importantly, Yoko also says that the light was on in John's room. Of course, you also heard that the way the bed was situated, you would have to walk into the room, down, and go around to actually see the bed. But regardless, she sees that the light is on in the room. Devyn tells her that John started drinking and he went to bed. Yoko told you that she didn't hear anything from John's room. The light was on. Didn't really think anything of it. And that she and Devyn talked and washed dishes for about 15 minutes. Because that's when Devyn told her that Jonathan, the next morning, was going to meet her with the girls, and they were going to go ahead and go enroll the girls at school and take them to school. She confirmed to you that there were only 4 people at the home. Yoko, Yoshida, Devyn, and the victim, Jonathan. At 1:15, she goes upstairs. She goes to sleep after having that conversation with Devyn. Around 2 a.m., she wakes to the dogs barking in the backyard. And if you'll remember, that was abnormal. The dogs, when John was asleep or at night in general, were not in the backyard. So why were they in the backyard barking? She also heard a thud. She then goes back to sleep. At 8 a.m., she goes downstairs, sees John's truck is outside, which is a little weird because Devyn had told her that the plan was for him to already be gone by that time in the morning to go enroll the girls. So her antennas were up a little bit. She calls him, calls John, he doesn't pick up. Prepares her coffee, goes back upstairs. She calls him again, no answer. So now her senses are heightened even more. So she goes back downstairs. She looks around John's room, couldn't see him, because again, the bed is sort of around that corner, as you saw in the photos. She then goes upstairs again. After going upstairs, again, feeling even more heightened concern, she goes back downstairs. And it's at this point she goes deeper into John's lower room, a makeshift bedroom. She sees the doggy door is down, and the dogs are still outside, abnormal. She saw inside garage door was half open, the one leading into the garage, abnormal. The big garage door was open as well, as you all saw in the photos. It had an opening there, abnormal. So then she investigates more. She goes to his bed, and she sees John wrapped in a blanket. She opens the blanket, and she saw feet. She then goes around to the other side of the bed and sees the amount of blood that's on the other side. Goes upstairs, tells Yoshida, they call 911. Devyn also made several inconsistent statements. The truth is the truth, it shouldn't change. What were those inconsistent statements? The first one, Jonathan's engagement ring. If you recall in interview 1, Devyn tells the officers, we threw his engagement ring in the trash last night. Okay. Interview 2, threw away John's engagement ring. We kind of made a joke of it, 2 coins, threw it in the trash type thing. We saw pictures of the trash, of multiple trashes in the Paladura address. Not just one, but multiple. 1, 2, 3, 4, 5. None of them containing a ring that were searched by officers. Ladies and gentlemen, there was no ring that was thrown in the trash. Inconsistency 2. Her marriage to Devyn. We learned from interview number 2 that this was a marriage of convenience, not intimacy, which we know is not true based on other evidence in the case. Interview number 3. Her marriage to Devyn is just on paper. Rings aren't significant. Me and Dev haven't been intimate in years. That's not true. Inconsistency 3. The gun safe. In interview number 1, Devyn tells officers, "We took the guns last night, but we didn't bring ammunition because there's no safe at my home for them." Ladies and gentlemen, we saw pictures of a safe. There was a gun safe in the home. There's a close-up of it there. And there's guns and ammunition. Gun safe in the home. No safe. Inconsistency 4, Jonathan's wallet. In interview number 2, she tells officers, John lost his wallet yesterday. He leaves stuff around a lot. Minimizing. Then we have interview number 3, which is after the search warrant of Porcupine Rim, where they start to confront her with the fact that there's Jonathan's items in there, more specifically his wallet. She tells them, at first, nothing of John's is in my house. John's wallet wasn't at his house, so do you know where it is? No, sir. I have all of his old driver's licenses. The license you found is an old one. We know that's not true. I tucked the wallet away in bags. I knew, but how would she know that the wallet was wrapped in bags in her underwear drawer? She wasn't confronted with that. Nothing of John's in my house. There was. His only set of car keys. His current driver's license. His wallet. And what was found inside her purse? Jonathan Willette's social security card. Why would she have those things? But nothing of John's at her house. Again, the license you found is an old one. And if we look here close up, it expired November 7th of 2025. The murder happened August 7th of 2023. This was his active driver's license. His old one? I tucked his wallet away in bags. Remember, ladies and gentlemen, this wasn't one bag. This was 8 bags, and you heard in the interview with Detective Weinoff that were tied over and over and over and over again. Not just one bag. What was she trying to hide? Also, how would she know? Inconsistency 5. Where was John? In interview 1, she tells officers that John was in the garage, awake, smoking when she left. He was smoking when Yoko came down. But remember, Yoko said Devyn told her John was sleeping off his alcohol. So which one is true? She says she said goodbye to him, pushed out a box under the garage, went out the front door. Then the next interview, last thing she did with John was pop his back. He went to smoke. She talked to Yoko. She finished loading. He told her what to take, and that was it. All inconsistent. And not the same story. Inconsistency 6. John's bloody phone found at Devyn's home. There's a lot of discussion about this during the trial because it's important. And it shows that Devyn committed the murder. And why? First of all, she told us in interview number 3. He told me he cut his hand. Okay? He said he was moving a table and one of the parts fell and took a chunk of his hand. She offers this to police. I didn't see it, but I do know he mentioned bleeding on his hand. Very descriptive. Then interview number 3. He must have been smoking and set his phone down. Again, no notifications are found on John's phone, as if someone manipulated it. Because as we know, John was called and texted multiple times, especially when people were trying to find him. Why would he have no notifications on his home screen? That's because the phone wasn't left by John. We know that his blood was on the phone. And we know that it arrived after the murder based on those CVRs. Based on that raw data, we know when John's phone made it to Devyn's residence. And that's when she took it there because, as you know, it traveled with her after she committed the murder back to her home. This is also an important one. She tells detectives that it was dark in the room and she couldn't see when she committed the murder. In interview 4, we finally get her confession. She hit him. And that's when we get the details. But she tells us that she couldn't really see what she grabbed off the fireplace because it was dark, but she could see him breathing. She tells the detectives, because they're a little confused by that statement, because she can't describe the object in her very hand, but she's able to see Jonathan breathing. She tells him, well, your eyes can adjust. And remember, Yoko said the light was on in John's room when she came downstairs. It wasn't off. It's also important to note that he was wearing boxers. He had his boxer briefs on, she tells the police. And we know that's not true. The boxers were found at the foot next to the side of the bed, as shown right here. She also can't really account for the time after seeing Yoko at 1 a.m. And this one's really important. In interview number 4, she initially tells detectives, well, I wasn't there for an hour after Yoko came down. That's not true. But then she's confronted that no, there is evidence that you were in fact there until 2:04 in the morning. So detectives trying to solve this case with the family is asking, what were you doing? What were you doing in that time frame? She remembers every detail before. She remembers every detail after. You heard the interview. But she doesn't remember this time frame. Why? Because she did it. She was decapitating Jonathan. I can't remember. I remember talking to Yoko, getting my stuff, leaving, going to the pharmacy, and going home. But she doesn't remember the time frame that she was decapitating Jonathan. Why? She's told this has got to be eating you up. And this is why videos are so important. This is her response.
This has got to be eating you up. This has got to be eating you up.
She's nodding.
This has got to be eating you up.
This is eating her up.
This has got to be eating you up.
Ladies and gentlemen, she admitted to the murder. She said in her interview, when she confessed, that she took that object, the stick, the wooden stick, and bashed Jonathan in the head. That is the murder. But there was a head missing, and that was important to the detectives to give closure to the family. So what about the decapitation?
Well, it's, you have to have something for the outer report, that's where it's being murdered, that you were in the house. That's it. That's the only time you don't remember.
I didn't know I was there that long.
It doesn't matter if you don't.
That's what I'm saying, I don't remember being there that long, I didn't know I left.
Okay, so is it possible you did it, you don't remember?
Yes, sir, it is very possible.
Okay.
Yes, sir. It's very possible. The scene does not lie. Defendant can lie, but the scene can't. So what's the hard evidence as well, in addition to her statements that are inconsistent, other than the confession? As we know, John was found on this bed, and there was blanketing. And we also noticed that there were two blood spots specifically on that sheet that he was wrapped in. One on one side and one on the other, as you can see in that right-hand photo. She rolled him to the edge of the bed to complete the decapitation after she had realized she murdered him by getting him, as evidenced by the two blood spots that we see there. In that last interview as well, there was a drawing, there was a diagram, there was a sort of a back and forth a little bit with the defense talking about that the detective was the one drawing, but I will leave it up to you to sort of see how that was going down. Devyn drew that line there, and the detective told her multiple times, correct me if I'm wrong, is this where you were, where the X is? Yes, that's where I was. She drew him in the exact position she left him in. There's some truth. The DNA can't lie. We heard that Jonathan's cell phone was found at Devyn's house during that search warrant of the Porcupine Run residence. And we heard from CSA Nicole Merriam, who testified twice, that she swabbed that blood spot right there on the phone, and the testing revealed presumptive positive for blood. It also revealed Jonathan's blood. It's also important to note that Jonathan's blood was found in the driveway of the residence. We have that marker A, which you can see there, the blood spots with the cone. And we also have marker B, which was that Jonathan's bed frame, where they saw those droplets of blood. All Jonathan's blood. It also is interesting where these blood spots are, because they're in the driveway in the same exact place Devyn would have walked to go back to her vehicle to drive home, as we know occurred at 2:04 in the morning. Devyn's DNA is on that knot of the plastic bag containing the wallet and John's only car keys. They also tested inside and outside of the wallet, including all the pocket openings. So the inside of the wallet also contained Devyn's DNA. This wasn't Jonathan dropping it in a bag. Why would Devyn's DNA be inside the wallet? Devyn and John's DNA are on his Social Security card swab. Not shocking that Jonathan's DNA is on his Social Security swab, or Social Security card, I should say. But remember, this is Devyn's bag. You see her wearing it in the surveillance video with the chevron. She also described it to police during one of her interviews. And what's found inside is that Social Security card belonging to Jonathan Millett. And not only is it found, but it's found with the defendant's DNA on it. She handled it. She wanted to enroll the girls at school and knew that she needed documentation because the father of the children was dead. We also heard from the coroner, Dr. Yagi. The cause of death, homicidal violence. The manner of death, homicide. The internal exam, and this is important, decapitation occurred post-mortem. Jonathan was decapitated by the defendant after she bashed him with the stick and killed him. Based on the science. No one's disputing that. Not even Dr. Sims today. This is also important. No bleeding injuries on John's hands were found. None. She did discuss slippage, which she explained what that was, where, after death, the skin tends to shed a bit in different areas. But again, no bleeding injuries on John's hands. Then we had testimony from Dr. Burns, who passed around those cool exhibits. Cass, I should say. And she explained that there were 2 implements used to decapitate the victim. As you can see in the picture there, this is her annotated version showing that there were 2 implements that were in fact used. A hand-powered serrated or non-serrated knife was the first. Then a mechanically powered saw, because it's very difficult to cut through human bone. Not only did Dr. Yagi and Dr. Sims agree today, but also Dr. Burns told you that the impacts that she saw on the neck were consistent with post-mortem dismemberment. Jonathan's head was decapitated after he was murdered. There's a lot of discussion during trial about whether it's possible for a woman to do this. I think it's important to note, as Dr. Burns highlighted, a mechanical saw is made for anyone. Women can do anything, especially ones that have a clear motive. Moving on to the burla. Where was Devyn's vehicle during all of this? Her Nissan Armada shows she's at Paladura during the time of the murder. We have at 11:05 p.m., there's that short activation that we saw on the burla, which I'll go ahead and play for you. And it is not very long. It's at 11:05 p.m. on that August 6th, 2023, which is corroborated by the video surveillance where we see her vehicle moving up right in front of the driveway of Paladura, nose to nose with Jonathan. Then we have 2:04 a.m. This is when Devyn's Nissan Armada leaves. And we saw that in the burla. She goes from the Paladura address, she goes to CVS, then she returns home to the Porcupine Rim address. I won't play this all for you, you'll have this back in evidence. You've seen it during the trial. We also have that call detail record mapping. Where was everyone's phones during all of this? More importantly, where was Devyn's phone during this? And we had Detective Good testify that the defendant's phone was at the murder scene when the murder was occurring. And what's also interesting to note, which you kind of have to get close to see, that there's sort of this blue dot that is now traveling with Devyn's red device all the way back. And this was at 2:04 in the morning. So that's how we know that the victim's phone was taken by Devyn back to her home, because we have that Google geofence highlighted by that blue dot there of Jonathan's phone, showing when it actually got to Porcupine Rim, and that's when Devyn got there. We also heard phone content evidence, which demonstrates Devyn's intent in this case. I worry as much as you probably won't believe. I miss us. I'm glad you appreciate what we once had. We will have it all again, Jonathan says. I want our family back. We gotta do as great as we can for the girls to have a good life. The walls were closing in. We have the video surveillance that was played for you in depth during trial. And there's some important notes from that. We saw how much video surveillance was canvassed in that Paladura neighborhood. There was a point where the detective even said he couldn't pinpoint the address that I needed him to because of all these contacts here. Then we have that next door residence to the murder house, that 2696 Paladura Drive. Again, next door. And this is that video I talked about earlier where we do see the Nissan activated and we see it move in front of the driveway of the murder home, 2698 Paladura. We also see in this vantage point of the video when Devyn and the victims returned home from that trip from Chevron. When they were coming from Porcupine Rim, stopped at the Chevron, got some items, then came back, and we actually saw those shadows of two figures, which would be Devyn and Jonathan, getting out of his truck to go inside of the Paladura residence. This camera gives us that as well. And again, 11:05 p.m., we get that activation, and we see that the Nissan Armada is moved up closer to the residence. Why would she want to move it closer to the residence? She's concealing her crime. Then at 2:04 a.m., we also get from this residence that the Nissan Armada leaves, putting sort of a bookend on the timing of the murder. We then have the video surveillance from the Chevron. We've also called it the Terrible Herbs. And in there, I talked a little bit about this. We have that they're there at 10:10. That's Jonathan's truck pulled by a trailer. They then leave at 10:11 p.m. And we know that Yoko, as well as the video surveillance from the Paladura neighborhood, they're arriving into that neighborhood around 10:12 p.m., all corroborating, giving us our time frame. We have the video from the CVS pharmacy, the drive-thru, 2:28 a.m. on August 7th of 2023. This is after the murder, where she's at CVS. Again, giving us a time frame. There's no one in that vehicle but Devyn. You can see with your eyes. We then have the 6621 Gray Juniper surveillance video camera from Devyn's neighborhood. This is that one that was fixed where you could see the only entrance and exit of the Porcupine Rim neighborhood, and it was constantly running. We were able to see different things from that. Remember, it was 3 minutes slow to real time, but accurate. At 8:57 p.m., we have John's truck entering the neighborhood. And this is on August 6th. Then at 9:29 p.m., John's truck leaving the neighborhood, further corroborating the timeline. Then importantly, at 2:39 a.m. on August 7th, after the murder, we see Devyn's Armada and Devyn returning back to her residence. At no point was Devyn or Devier's work truck or that sedan seen entering or exiting. Very important. We don't see his work truck or any of his vehicles leaving until 7:31 a.m. on August 7th. So now let's talk about Devyn's motive and intent, which is very important to consider. We heard from individuals that knew about the child custody case during this trial. And they told you that Jonathan had been given full primary physical custody of the two girls, Tamaya and Jamea. And this happened on October 27th of 2022. So at the time of the murder, Jonathan technically still had full physical custody of the girls. He had something he could hold over Devyn's head. The walls were closing in on her. We also heard from Elizabeth Lemons Woods, who also had worked on the child custody case and sort of the placement of the girls after Devyn was arrested. She meets with Devyn on August 17th of 2023. She wants to tell the defendant, hey, heads up, I just want to notify you, the girls are being placed somewhere else because you're not there, and their father is no longer around. And what Elizabeth Lemons Woods testified to is that defendant then started giving her more information, more than the scope of what the original conversation was supposed to be about. And what I think is notable is that Elizabeth says that throughout the conversation, Devyn appeared that she was trying to cry. Why would you try to cry? Devyn said during the same conversation, she had to do it. She had to do it. Now, ladies and gentlemen, it's very important, and you're in fact instructed on this, to use your everyday common sense and judgment as reasonable men and women. Do not check your life experience and what you know to be true at the door. Bring that with you when you deliberate. The evidence in this case is overwhelming. It's hard, and Mr. Giordani hit the nail on the head when he said, buckle up, this is a wild ride. This is unfathomable, but this is what happened. We are confident as the state that having all of this evidence in front of you, that you are going to go back to that jury room, and you are going to check guilty of first-degree murder with the use of a deadly weapon, because the defendant committed first-degree murder under both theories: premeditation, deliberation, and also felony murder. Thank you.
All right, ladies and gentlemen, we need a moment to set up the technology for the defense's closing argument. We're going to take a brief recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, listen to news, or media accounts or commentary about the case. You must not do any research, such as consulting dictionaries, using the internet, or using reference materials. You must not make any investigation, case, or any other way investigate or run on the case on your own. You must inform or correct anything regarding this case or the fines made to you. Ladies and gentlemen, it's 2 o'clock. We'll be in recess till 2:15.
All rise for the jury. All rise for the jury. Please be seated. Your Honor, the jury is all present and accounted for.
We are gonna go back on the record and see 377239 State Development versus Devyn Michael. May the record reflect that Ms. Michael is present with her attorneys, deputy district attorneys on behalf of the state, do both parties speaking in the presence of our jury.
Yes, sir.
Yes, Your Honor.
Okay, Mr. Justice, are you prepared for your closing argument?
Yes, Your Honor, thank
Whenever you're ready.
Thank you. This case is entitled The State of Nevada versus Devyn. Proof beyond a reasonable doubt is the highest standard in the American justice system. It shows an adoption of a belief that we took from the old common law from England, that it's better to let 10 guilty men go free than to wrongfully convict an innocent person. I would also submit to you that it shows a belief and an understanding from the founding fathers that very few people have the resources, the opportunity, or the ability to prove their innocence. You've seen that through the course of this trial. You have officers come in, collect evidence, and officers are people. I'm not going to stand before you and say this officer's a bad person. We talked about it through jury selection. But officers make mistakes. People are subject to biases, to confirmation bias, where they reach a conclusion first and then kind of work backwards. And I would submit to you that that is what happened in this case. And our founding fathers understood that. And that's why they placed the burden upon the state, and the state alone, to prove its case, each and every element of its case, beyond a reasonable doubt. I'd like to talk a few minutes about the jury instructions. We had a few technical difficulties, but you all have the same packet. I'd like to discuss just a few of these instructions. I'm not going to tell you which boxes to check. You're smart. You paid attention, very close attention throughout the entirety of this trial. You are the sole judges of the facts. You alone will decide what will happen to Devyn Michaels. Instruction number 3 talks about murder with use of a deadly weapon, and that's what the state wants you to convict her of, first degree with use. But the pleading document is telling. Instruction 3, it states, murder with use of a deadly weapon, did willfully and lawfully, feloniously, with malice aforethought, kill Jonathan Millett, a human being, with use of a deadly weapon, to wit, a wooden stick, and or other unknown object, by striking the said Jonathan Millett with said wooden stick, and or other unknown object, and or through other unknown means. And then it lays out the mental state. It has to be deliberate, premeditated, or, of all things, committed during the perpetration or attempted perpetration of a robbery. The following instructions in this packet lay out, after you've assumed that Devyn has killed somebody, her mental states. Instructions 6 through 16 talk about all the different mental states required. That's after you've determined that this person did the killing. There's even a number of instructions concerning robbery. It's instructions 17 through 20. You see, in the state of Nevada, we have what's called this felony murder rule. It's a shortcut. It's maybe basically getting to the shortest distance between 2 points to convict her of first-degree murder. There are, however, other instructions that I would like to spend a little more time on. And again, you are the sole judges of facts. You will review these instructions. But unlike us, who had this case for some time, this case is new to you. You were introduced to this case when we all met and began talking at the beginning of last week. There is an instruction concerning expert testimony, instruction 33. Please look at that. There's a common sense instruction. And I'm going to flip to that. It's kind of telling. Both parties generally point to this idea of common sense. Again, shows the wisdom. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. As I go through my comments, and trust me, I'm going to leave things out. It's inherent in the process. Please use your common sense. You've taken good notes and you've paid attention. Please review the exhibits and don't take my word or that of the state of Nevada. Reach your own conclusions. Review the evidence. There is an instruction that I think is of paramount importance in this case, and it's instruction 32. It concerns the credibility or the believability of a witness should be determined by his manner upon the stand, his relationships to the parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. I read this instruction to you with Devyn in mind. We started this case talking about motivations. Motivations dictate actions. Devyn is not on trial. This case is not going to be well. Did we prove our case against Devyn better than they proved their case against Devyn? Devyn is the only person that's on trial. We have gone through the evidence in good faith, and I'm going to discuss that a little bit with you today in my summation, that there is evidence to believe that Devyn committed this crime. But you don't have to believe that to acquit my client. But I would submit to you that you should take that into consideration. The ultimate determination that you will make as the sole judgment of the facts is whether the state has proven this case beyond a reasonable doubt. Through the course of this case, and as you know, when we talked about it, we wouldn't have to ask a single question, present a single line of testimony. If the state fails to prove their case, she's entitled to a verdict of not guilty. But as this evidence has unfolded, I would urge you to see that perhaps the detectives in this case, the Henderson Police Department, were basically trying to choose the shortest distance between 2 points. Hey, we knew, and we all know, and we're not making issue that she was with him on the night in question. It's easy to reach a judgment like they did. She's guilty. But you, as jurors, must consider all of the evidence. Because unlike when you read in the paper, so-and-so's caught, and you think, yeah, he's guilty, she's guilty, you determine whether a person is guilty, not the police and not the state of Nevada. I would urge you to read the reasonable doubt instruction. A defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged and that the defendant is the person who committed the offense. And again, this is why we have addressed what the evidence reasonably shows concerning Devyn. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. And what more weighty affair of life do you have than to sit on this jury on this type of charge? If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict, not guilty. Since this is a charge of murder, I'd like to begin my comments, and I won't be long. I mean, we've been here a long time, but this is important. Let's begin at the autopsy. We had Dr. Sims, who was the lead coroner here in Clark County for 19 and a half years. You heard his testimony. It wasn't much of a cross because he didn't say much to be disagreed with. We did, however, hear from Dr. Yagi. Do you recall the question that was posed to her? Would you agree with me that a decapitation is difficult to effectuate? Remember her answer? I don't know, I've never done one. We heard from Dr. Sims that yes, it would be difficult. It takes a lot. It's involved. Dr. Yagi missed the tattoos. It was in the report. We had Oriental John. That kind of goes to the weight that you should give her testimony and the thoroughness of her examination of the body. The state's relying upon Dr. Yagi's statement, her testimony that there was no injury on the hand. You got to consider the source. Dr. Sims testified that the cause of death cannot be determined without evidence of injury, and he was talking about standard practices. Obviously, these are very suspicious circumstances. In fact, if John was murdered, it's very reasonable to assume, common sense would dictate, that the person that killed him decapitated him. And through the course of this evidence, they have not shown a scintilla of evidence that she was involved with a decapitation. She didn't do it. Determination of homicidal violence cannot be used when in large part that fatty liver or drugs and alcohol are present. He was talking basically about the industry standards, what experts in this field collectively agreed upon. And we saw a variation in this case from Dr. Yagi. In this case, we did have a combination of all three. You heard the testimony about 20 times the level of THC, alcohol in the body. 0.02 was the alcohol in the blood, but Dr. Sims testified that that, in conjunction with this high level of THC, would cause a person to be intoxicated. That's important in this case because you will hear testimony concerning her concern, Devyn's concern, about not letting him drive. As you recall, we went through all those texts beginning back in 2018 concerning Yoko's concern. And again, I don't want to speak ill of the dead, and it was no showing of disrespect towards her, but it was an ongoing concern that she had. She didn't want her son driving drunk, and that concern was shared by Devyn. She had his key. She took the key to the house. That's not evidence that she committed a murder. This is extremely important, and there's been a great deal of issue made concerning this video evidence. As you recall, through the course of Devyn's testimony, I read it to you at the beginning of the trial and read it to him, where basically we had a detective, it was the 12th of September, telling him, you're under the radar. We're here to clear you. I mean, when you look at the radar, when you look at this net that was cast, it has so many holes in it. The state would have you believe that both homes were under 24-hour surveillance. It's just not true. The evidence, the other detectives showed that. The state expects you to accept the representations made by Detective Lippisch regarding the true time of the videos from this residence, and I want to start there. This concerns the state's timeline, which I would tell you flies in the face of common sense, but it's important to take into account how this evidence was gathered. You recall the list of times or the videos that were shown? He supposedly didn't, it was on a neighbor's cell phone. We saw no logs. We saw no indication of the veracity or the accuracy of those times. The state's basing this idea that she's pulling up in front of the Palladura residence and is somehow moving her car at 11:04 to avoid detection. You have to take this detective at his word. And again, I'm not necessarily saying he's lying, but he did a sloppy job of collecting that evidence. And this is the video evidence that I'm referring to. Remember, there was no embedded data here. We don't have time. He would have you believe that the vehicle is moved at 11:04. We don't know what time this is occurring. We do know that the vehicle perhaps was moved from the Burla, but we don't know the sequence of events. As you recall, and you will have the evidence, there was various blue lines showing triangles, and we heard that through the positioning of the GPS, you have movement, even if a vehicle is in one place. We don't have specific times, and we really don't know the order of how things occurred. We would urge you to believe and to consider that common sense would dictate that this was when Devyn left the residence at 2:04. There's going to be a close-up here. You'll have a computer screen. Zoom in on it. There you see the interior of the vehicle. You see Devyn getting in. You see a bag on the passenger seat. And she leaves. Please pay close attention. And again, not that I'm trying to tell you to, but we've had this case for much longer time than you have. Look at the video evidence from 6505 Taylor Creek. Detective Lippisch testified several times that he could only speak to items that he can't restore, but he was happy to testify concerning other detectives who went unnamed that collected this evidence. It's clear from the testimony of a forensic examiner, O'Brien, whose credentials and whose testimony went unchallenged that we presented to you today. He testified that one of the three videos was compiled from a series of screenshots, which the Ring camera is set to capture by default in the absence of video activity. Where are the other screenshots? They only gave us 3. I'm not going to stand here and point the finger and say that this was done in bad faith. It was done out of sloppiness. Why weren't subpoenas issued? Why don't we get the complete record? This woman is on trial for murder. We heard nothing concerning them going to the third-party providers, Ring, Google, other parties. No, they're relying upon the cooperation of neighbors who are living their own lives and who very well may be indifferent to the gravity of this situation. Didn't give us the full picture, and that was the video that had constant, I mean, you got a good scene into or a good view of the residence. It's incomplete. We just have these three. And again, this is at the new residence where it's been referred to. Porcupine here, we've got the truck. You know, there's been an argument made that Devyn had to have been in the home the whole time. Based on what? Because the entrance to the neighborhood with the continuous camera doesn't show a vehicle. There's other ways to leave that residence. There's a walkway next to one house away. There's over the fence. This is something that's been discarded by the state, but again, I would submit to you that it goes to what Devyn is thinking. It goes to her innocence. She starts trying to contact Jonathan on the morning of the 7th, starting about 4 a.m. She'd left him. She'd left him at the residence. The plan was that they were going to take the girls to school that morning, and we have evidence, and you've heard uncontradicted evidence that that's what she did. The message she leaves him is concerning the girls' school supplies. She's letting him know that their daughter was sick, because we know that she's at that pharmacy, and it's a 24-hour pharmacy at 2:28 a.m. That's what went on. She hadn't killed him and decapitated him. She was worried about getting her daughters to school that morning. She sends messages of concern when he doesn't respond. The state claims, and again, this is where common sense comes into question, the state claims that Devyn was answering Jonathan's phone from the house the morning of 8/7/2023. You heard the argument concerning the notifications. We did hear from Detective Skinner that they didn't put it on airplane mode. Those notifications wouldn't have shown up. That evidence, like so many other pieces of evidence, were mishandled. But the state's going to have you believe that she purposely took the phone from Paladera to Porcupine Rim and leave it out on the driveway, and at the same time be calling it and answering it and leaving it on the driveway. That flies in the face of common sense. She took it and left it there, and then is answering it and calling it to provide some sort of an alibi. She's lucky that in this very slipshod investigation that she has as much evidence that she does to present to you that she didn't commit this crime. Crime scene, the footprints. There are footprints in the backyard. And we have, and I'll show you the photos, we marked them and had them admitted. We have this, the Henderson Police Department documenting these footprints, but then trying to basically throw shade on that, saying, well, they could have been there for some time. They weren't important. When you look at the photo, you can see that they're fresh. They wanted to argue that they're male or female. They didn't do any follow-up. There was no footprint comparisons to anybody's shoes in this case, much less Devyn's. You recall Yoko's testimony, there were 4 dogs in the backyard. If that footprint had been there for very long, common sense would dictate that the dogs would have walked through it. They would have been sullied. They weren't. They were fresh. Again, they were not analyzed or tested. And there it is. And Detective Ozawa just kind of discounted that and said, well, we don't know how long they were there, but apparently no one really looked at Yoko's testimony and Yoko's statements. 4 dogs were out there for most of the night. This was a big point of contention. And again, these aren't red herrings. These go right to the very heart of the case. There was no blood cast off in the bedroom. In spite of evidence, uncontroverted evidence, the mechanical powered saw was being used to decapitate Jonathan. You recall Coroner Yagi went so far as to try and compare a beheading by a mechanical tool there at a crime scene, and Dr. Sims took issue with this. She tried to compare that. These crime scene analysts tried to compare that to the dismemberment of a body under controlled conditions by specialized tools in the morgue. Bodies that have been refrigerated, but nonetheless, she testified that they still wear protective goggles and aprons to protect themselves from this cast-off. Luminol, we heard no testimony whatsoever that luminol was used by the crime scene analysts. That would show indications of blood or attempts to wipe it up. Nothing. What's clear, and it was kind of laborious at the beginning of this trial, was Yoko's testimony, because her testimony was so crucial to the timing of this case. There were some difficulties with the interpreter. However, I'd submit to you, she speaks pretty good English. It was important to memorialize what she told officers the morning of in the 40-minute conversation, as well as what she testified to the grand jury. She testified that she saw Devyn at 1 a.m. and Devyn didn't have any blood on her. If you follow the state's timeline, sometime around then, and it's unclear, she's involved in this murder and decapitation. She stated that no gloves were worn by Devyn when she met her at 1 a.m. And you recall the testimony concerning the dishes and the alcohol bottles. And there were some issues concerning Jonathan's level of drinking. 15 minutes. She testified that the light was on. That brings to question the veracity and the reliability of the statements through her multiple interviews that Devyn made to the detectives. There was no blood visible on Devyn's shirt at the CVS drive-thru pharmacy, and thank God that she stopped there. Because again, we have real time. We have real evidence that shows that she didn't commit this crime, and not some detective's opinion. There's another issue concerning this, the mixture of ammonia, bleach, the stench. Remember that? We heard that the first responders, that they said that the smell got worse the longer they were there. If we're to believe the state's timeline, this is smoking for 9 hours. That flies in the face of common sense. Ammonia evaporates quickly, and again, your common experiences. The state never, and one of you posed a question to Dr. Sims. Again, it's the state and the state alone that bears this burden. Where was the expert to talk about that? That was important. This case was out of the ordinary. It's clearly gruesome, but because it's gruesome doesn't make that woman guilty. It isn't evidence that she committed this crime. Here we are, 2:27 in the 24-hour pharmacy, and you'll have this. Look at her. She's sipping her water. Apparently this is after she's murdered a man and decapitated him. She's reaching out of the vehicle. No marks, no blood, nothing. And Sims testified that this would have been messy. So she's just decapitated, she's murdered and decapitated Jonathan, and she's making sure that she picks up her daughter's medications on her way home. There was a very good question that was asked concerning, was there any stops? There wasn't. Her vehicle didn't go to any isolated areas, to any trash bins. There's been times when I've gone through moves and I've gone behind the bonds and dumped trash out in their dumpsters. There's no evidence of that because it didn't happen. The state will have you believe that there's this bucket of blood that's the reciprocal of all this blood that's squirting out when she's sawing his head off. What did she do with that? Yes, she did. The car didn't go anywhere. She went home. There's no rags. There's nothing in that vehicle. We do know that they recovered, and this is based in part of the video that we saw from the terrible herps. Again, I don't want to point fingers, but her life is on the line. They didn't do their job. There was no direction of what to get and when to get it. We heard from Detective Lippisch that he got that video evidencing her clothes around the 11th of August. That warrant was served on the 7th. And we didn't hear much about what they picked up on the 15th. They made a big deal about the shoes, the swoosh, but we showed you evidence in the photographs, and it's in evidence of the black shoes with the white soles. I mean, she gets arrested on the 15th. Game over. It's done. According to Yoko, and this is important, and I read the statement to her because it was so dispositive. She said Jonathan's room was a mess. And there's this kind of a feigning of not understanding, and I said, "Ma'am, these are your own words." And I read her own words to her. During her initial interview, she stated that there were 2 chairs flipped upside down. That's evidence of a struggle. But then we don't see that on the body cam. What happened? We don't have that in any diagrams of the crime scene. But when she spoke to police and thank goodness it was recorded, she talked about 2 chairs being flipped upside down. And obviously her memory would have been far better at that time than it would be now. But again, there were some questions by the state. You were traumatized, things were terrible. I'm sure it was. But the veracity of the statements and the accuracy of the statements shine through. She was trying to help law enforcement and give them clues concerning who committed this murder. There's no reference made in Devyn's statements about chairs, about a struggle. Jonathan was killed after she left. What's kind of weird is that there were 2 belts tied together on the ground near the bed. There's been no explanation by the state, and we can't give you one, but something's going on in here. Crime scene GPS. Devyn's car is trackable. We know that she didn't stop. She was there that night, and that's why she was charged. Her phone is trackable, clearly. No deviation is made to some remote location. She went to the pharmacy and went home. There's no anomalous stops, and this was brought up by you. She gets the medication and gets home because her girls have school early the next morning. The timing, and this is obviously where timing is very, very important. We do know when they leave the terrible herps. You see 22:11. We know that when they got home, they spoke to Yoko. We don't know how long they spoke, but do you recall Yoko's testimony? Her words were, it was a very good day. She'd known for months that they were getting together. They were trying to unite the family. And you know what? No union is perfect. Hey, we all know that. There are ups and downs, but she and Jonathan had a union. The state in their first closing, they're going to get a second one, try and paint her as this devious, manipulative, conniving temptress. But think about that, the flip side, a 19-year-old. When we talk about motive, What drives a person to murder? Is it not passion of a young man? His first love? His first love that's coming to an end when dad's coming in and moving him, the dad that he said was never there for him. You know, it's kind of an archetype. You know, the father that's killed by his son. I mean, it's in, I believe it's Isaiah 38:18. We've got these Greek stories of it, Oedipus. I mean, there's various variations of that, but it's an archetype. Saturn. It's known, and it's as old as the human condition. Fathers are sometimes killed by their sons, and that's why we wanted to underscore, and we spent a great deal of time in our opening statement, because we didn't know where it was going to go with Devyn, but we knew that they'd had a relationship that had been kept clandestine. Devyn covered for Devyn, and Devyn covered for Devyn. This is important. I would submit to you that this is a more accurate and a more reasonable timeline. Yoko was awake. 10:58. There's a 44-second call to Devyn from her phone. You recall, we get the text, and you want to talk about an alibi-type text, putting the girls to sleep. It's 10:36. I'm going to bed. That has been refuted by facts. He testified here that, well, maybe he woke up at 2. That was the first time. Previously, he had testified before a grand jury that he got home, put the girls to bed, went to sleep, woke up, Devyn was there. That is a lie. Why would he lie? What motivation would he have to lie? He's a fairly smart young man. I mean, he was kind of catatonic here, understandably so, in the witness chair. But again, we need to look at motivations, because motivations, they author actions. At any rate, and we knew the night before that Devyn had been there late with Jonathan. But after we were to believe that he's asleep at 10:36, we've got a 44-second call from Devyn's phone to Devyn. 8 minutes pass. 11:05, we get that 10-second burla in the Nissan Armada. It may have been moved. You're to determine that, because I'll tell you, we really don't know. The evidence is not reliable. Whether it pulled up and stopped, or what we saw there was Devyn leaving, we don't know. States to provide that to you, the timeline. They haven't done that due to this slipping through the cracks in the slipshod investigative work. Now, an hour and 55 minutes pass. Yoko is awake. There's no suspicious noises or activities. And we have a 15-minute timeline. Because you recall, Yoko's into time. She corrected me. She looks at the clock. They talked for 15 minutes. And it was kind of like pulling teeth. She admitted about the dishes and the alcohol. They talked for 15 minutes. We're to believe that, and again, this goes to Devyn's statement and reliability after she's subjected to interview after interview. Yoko says the lights are on. The state would have you believe, apparently, that Jonathan's dead. She struck him in the head, and he's dead. Meanwhile, she has this 15-minute communication. Again, no blood, gloves, chemical smell, any of that on Devyn. At 1:15, Yoko goes back upstairs. And you recall yesterday, that was kind of rebutted Lena's testimony. They kept hitting her with that hour and 4 minutes. That's why you don't talk to the police. That's why you have a right to remain silent. One thing that we have learned is don't talk to the cops, especially if you're the target, because they're going to take what you say and they're going to twist it. Yoko was equivocal in her testimony when she testified before us. This time, and she's just testified once before a grand jury, she's equivocal. She was awake the whole time. She looked at YouTube. She went to sleep. It's equivocal. But at 2 a.m., for the first time here, she says she hears the bang. And I think we had the prosecutor bang his hand. She'd never talked about that before. but still, may have happened. 2:04, Devyn's leaving. Maybe it was the door closing. We don't know. That's her testimony. But you have to evaluate her testimony. But again, this is really kind of shedding light on this timeline. She previously testified that she heard dogs at 3 a.m. She brought it up 3 times during her police interview. Apparently she felt it was noteworthy, and she testified to that September 14th before the grand jury. Yeah, the dogs are barking. It's 3 a.m. Someone's put the dogs outside. The facts, taken as a whole, and not this little piece here and this little piece there, show that this murder, and you know, it's silly to say a murder didn't occur, obviously it did. It happened after Devyn left. The facts, taken as a whole, bear that out. Again, you've heard, and it's uncontroverted, Devyn leaves at 2:04. You know, what's of note is that presumably Yoko went to sleep after she went upstairs. Part of her testimony previously is that she was awake during this whole time. Where's the testimony of a mechanical powered saw? It happened. It's more reasonable to believe that that happened after 3 a.m. We don't know when it happened. She didn't do it. The dogs were outside barking. Somebody's in that house. Somebody has killed Jonathan and somebody is cutting his head off. Again, what kind of passion does that take? Not an on-again, off-again relationship that Devyn had with him. It's a person that's enraged, you know. Well, watch the TV, the police stories. They talk about stabbings are personal versus a shooting. What's it going to take to cut a head off? And what kind of anger and what kind of resentment is that going to cause to for someone to do that? You know, there's been a great deal of argument made and points attempted to be scored that Devyn did that because she'd do anything to get her kids. It was uncontroverted that regardless of what was going on with the family workers, she had those girls from May 27th on. She had them all summer. And when we talk about motivations, we know that Jonathan was moving in. There was talk of marriage. And you know, they want you to believe that the rings weren't there. Look at this investigation. Look at the photographs of the trash cans. I believe one was Exhibit 68. We have no evidence and nothing to show that they emptied that. And no, why would they take a picture or preserve a ring? They didn't preserve anything else in those trash cans. It's easy for them to come in years later and say, I didn't see a ring, there was no notations, and they'd go through hundreds of crime scenes. When they were there, you know, when Miss Wilson was there, they were looking for weapons. They were looking for evidence of a murder. They weren't looking for rings, and they're asking you to convict her on this shoddy police work and have you believe that Devyn's lying about these rings when there is no indication that they were looking for rings. This is the state's only evidence that she committed this murder and this decapitation. Because you got to put them together. Common sense would dictate whoever did one did the other. The interviews of Devyn Michaels. I'm going to focus on the third interview.
And then, have you guys ever had a sexual relationship?
Yeah, we had.
Okay. But it's not there now?
No, I can't even have sex now.
This is important. This isn't something that Devyn is making up. You have her medical records. The time, 12/5/22, vaginal hysterectomy. She's had surgery. She's not having sex. She's telling the detectives the truth.
station or CSA, they're gonna thoroughly look for everything in that vehicle? I couldn't tell you. If he was bleeding from when he was doing the thing, he helped load up the truck, so if he was bleeding, it might be. Or your Armada? My Armada. Okay. Like, he was putting the things in the car, like anything that he had. There's gonna be obvious areas where blood doesn't belong even if you're loading. So I'm just asking you directly, because if you find any DNA evidence in that vehicle, obviously we wanna make sure. Asked you if there would be a reason. No, the only thing I knew he said was his hand that he hit on the table. That's the only time he ever said he was bleeding, and he said it got a pretty good gash. Okay, but you didn't see that? No, I did not, so I can't really speak on it. But he was still loading everything up, so I don't think it was really bothering him that much.
This is the inside of the Armada. For the testimony from Ozawa that it appeared the vehicle had just been washed, that's been disproven. The burla shows that that didn't happen. The location coordinates show that that didn't happen. Look at the inside of this vehicle. I know my partner, Mr. Horvath, had asked Detective Spangler, well, you know, was it very clean inside? And I think he made a reference to teenage kids, something along those lines. This isn't well kept. I've seen much worse, but it's not well kept. The important point is we're to believe that there's buckets of blood in here. There's bloody rags. There's a head, a murder weapon, a saw. There's nothing in there. They sealed this vehicle and they took it off. If you're to believe that she murdered and decapitated Jonathan, you're to believe, common sense would dictate that there's going to be some indicia of a crime in here. Taking buckets of blood because they weren't at that residence. This made reference, and again, nobody understood the significance at the time. You know, Miss Miriam didn't, but there's the table that she talked about. It was a moving day. Injuries do happen. You know, we're to believe, again, Dr. Yagi's, the reliability of her testimony. She said there was no bleeding injuries. Well, we've got an injury right there. Whether it's bleeding or not, we don't know. But that's sign of an injury. And remember, this is the same doctor, the same coroner that said John didn't have tattoos on his arms. A big point was made about the telephone. And we're to believe that Devyn is so sophisticated and so cool and so cunning and so informed that she can murder this guy, decapitate him, not leave any evidence, and then drop his phone in her driveway. You know, a more reasonable explanation, it's tired. She's got girls that are going to school in the morning. She's been carrying things, it's late. She obviously brought the phone. Whether it was knowing or not, we don't know. It appeared that it had fallen on the side, and she tries to give an explanation. You recall about the cigarette butts? She didn't know the phone was there. That's why she was calling the phone, following up with Jonathan. She knew he wasn't dead because she didn't kill him. Another thing, there was a big point of contention. Sometimes little things can have very large implications. Remember the issue about the blood on the screen? Papakostas, the DNA expert, testified that she couldn't confirm that it was blood. There was a presumptive test, but the confirmatory test, and some of you are far more knowledgeable than I am, it was not. She couldn't confirm that it was blood. So then the state recalls crime scene analyst Miriam to apparently discredit their DNA expert in reference to the blood. And this is the entity that's charged with proving this case beyond a reasonable doubt. They're calling a crime scene analyst on a presumptive test to discredit the DNA expert who gave testimony, uncontroverted testimony, concerning the lack of a confirmation for this blood. We know that John's DNA is on the phone. I would submit that it is somewhat significant in determining whether the state's proven his case. Devyn's isn't. It was handled. Maybe there weren't epithelial cells left from Devyn. Clearly, Devyn took the phone, knowing or not, and I would submit to you that given the circumstances and the chaos of a move, She didn't know she had the phone. It's not evidence that she killed him. Just like the key, it's not evidence that she killed him, or the wallet. She's going to go through all this work to leave this, this crime scene spotless or clean and not leave anything behind, no blood, nothing in her car. Yet she's going to drop the phone and then make calls to it. This is what the state is relying upon, this interview. And you recall the tenor of this interview? Please don't just look at one part or another. Listen to the whole thing. The power dynamic. You've got two large men. You've got a woman who they had said, we Mirandized you earlier today. You have to ask yourself what went on. What happened before this interview?
John? That was John over there when you last saw him? Yeah, but he had his boxers on. Okay, he had his boxers on. I don't know, he had his boxers on. His boxers were black boxer briefs. He had boxer briefs on. That's what I'm talking about. The shit's getting real. Keep looking at that. Take another look at this.
This was into the interview, and it was a fairly lengthy interview. She'd had multiple interviews before. We heard in this interview that they had told her previously, that day, about the decapitation. So there's more going on. She knew. You know, it's at 1601, and it's interesting that the state showed you the exhibit, the one that she supposedly wrote. When you look at the original exhibit, it says handwritten by Devyn Michaels. It wasn't. She drew a line, and that's significant. It was Detective Christopher that wrote that. And again, this is in the crises, in the crucible of a very confrontational interview. She didn't author that. And I'm assuming that Mr. Giordani is going to stand up when I sit down, because he gets the last word, and he's going to say that somehow, how could she have known that? She hadn't been shown the photos. This gentleman had seen the photos, and he filled in those details. As she's sitting there, having been arrested previous to this interview, and facing the horror of being accused of a crime, a murder, that she didn't commit. Here's the boxers. Why lie? Why lie? When she left, he was wearing those boxer shorts. She was consistent in that. Why choose that hill to die on? She was telling the truth.
Have you had moments in the past where you have been stuff where this happened?
Yes, there's things in my past where I cannot remember. And yes, I have talked to my doctor about it. Yes, they're trying to figure out what's going on with me. Yes.
Okay, you don't have to tell me if you don't want to, but what is wrong with you that you say that
I
you're trying to
don't
get
know.
out of?
They're testing me now. I'm supposed, I think yesterday, for whatever reason, my brain tingled and then I blacked out. And I literally have it on documentation from the doctor, and they're trying to figure out what's going on with me.
This interview was on August 15th of 2023. This condition that she's talking about, it's documented 6/7/2023. New patient established her patient she feels like tingling, vibrating in the back of head, comes and goes, denies headache, has dizziness. This isn't some ploy. I mean, she's in this high pressure, confrontational interview, and she's trying to give as truthful information as possible. She's had some problems. This isn't some defense where, oh, she blacked out and didn't know what she did. She didn't commit this crime. She didn't commit this decapitation. She's had some issues that she's been trying to address. And again, she's being truthful to these detectives. It's confirmed.
Absolutely. You're going to that and everything. You can have the audacity to give it closure. Shame on you. That's terrible. Get out of here! Also, there's anger now.
She's pushing back. She's been interviewed over and over again. She's telling him, I've told you I haven't done this. What we're dealing with now is a woman that's denying that she committed this murder. You know, it'll be up for you to determine whether she hit him in the head when he was grabbing her leg. She was consistent that he was alive. He was breathing. There's no evidence that she hit him in the head. And again, given this, we know that when people are confronted, they'll try and give something to appease the other party, this power dynamic. She was trying to give. In this interview, you'll read, they threaten. What you do here is going to determine what happens with you and your daughters. She gives a little, but then snaps back and says, I didn't do this. And she's expecting, through all these interviews, for them to pick this up and do their job. But they'd already made their minds up. You heard from Lanai yesterday. In their minds, she was guilty. That's it. And we're dealing with this investigation that you heard from Sean O'Brien, 3%. We're dealing with 3% of the information that was available on those devices. But still, in that 3%, we've been piecing together what really happened. We do know, and it's clear, incomplete Celebrite reader files. Critical database files are missing from the phones. Now, years later, we're trying to piece together a defense to defend a woman that didn't commit this murder. There's artifacts which would indicate a need for further investigation. And Sean O'Brien testified that generally, as he's been a forensic analyst, he's been involved in law enforcement. There's supposed to be this back and forth. Hey, get us this. You know, as this investigation develops, we need more information. There was no indication that that occurred in this case. She's at the house. She's the low-hanging fruit. She's guilty. The end. All investigation stops. Image of Devyn and Devier. And again, we would like to have more, but we can show you this image. Now, all the images that are available on a cell phone, I think I probably have 4,000. You know, it's going to be the state's position, well, this is just randomly popping up. Devyn had said that he was asleep, or Devier had said that he was asleep at this time. He testified under oath. He lied under oath. Look. There's a Discord chat application, 231. This is telling. You know, the state can play 3 phone calls from the girls who are adorable. Those were all after 11 o'clock. We have no proof where Devier is. But we have 2 indications of 2 artifacts at 2:12 a.m. and 2:31 a.m. that he's up and he is engaged. There's a deliberately deleted file. This is the image, 2:12:38 a.m. This is after there's been 3 calls from the home phone that night to Devyn. 3 of them were the girls. What about the other 8? But of all images, at 2:12:38 a.m., this is being looked at on Devier's phone. Game box. Again, and this is important, this was not preserved, this was overlooked. There's photos. He was a gamer. They had issues. Gamers are on their game platforms and they talk to other people. We have a Discord file. There's a remnant of that. He's using that at 2:31 a.m. in the morning. He's up. He didn't drive his car over there, and again, I can't tell you for certain if he committed this murder. But he could have easily gotten out of that house, and he's not going to walk. He's going to talk to a fellow gamer. We now know that he's up, and he's lied. He's lied under oath. What does he have to lose? I mean, he was able to avoid the motives through the course of this investigation concerning getting kicked out of his house and losing his wife, who he, based upon all the photos, and we didn't have to go through those, you saw them, he was in love with her. But we do, in this 3% that's available to us, we can show you that he was up. Not one indication, but two. And given the nature of that photograph, the multiple phone calls that were made earlier, and now we have this discord, we have a remnant that he's on and at, it's not too hard to imagine that he went there. Those are the facts. And the timelines, you recall the detectives that for the Henderson Police Department that testified, they set out timelines, but they didn't do a more in-depth analysis. And this is what our analysis, with only 3%, we were able to show he was awake. This was deleted, it's there. I'm not saying that was that night, but that's something that should be taken into account, headed there now. He's there in this area, and you'll have the exhibit. He's next to a remote area. Don't know if he had a job there or not. This is the morning after 8/7/10/25. You know, when detectives interviewed him, he'd said, hey, I've been drinking. We don't know if he'd been drinking all night. We don't. He's a drinker. He's in a remote area where, and obviously there's been no testimony, there's been no investigation in those wash areas. We know he was over there. We know he was up. We know that he was looking at a picture of him and Devyn. You know, it's, you see on the crime TV shows about motive, means, and opportunity. He had all three. He had the motive. He had the means. He didn't walk there, but he was talking to somebody. Clearly, he had the opportunity given the timeline, but again, I'm not going to stand before you and say he did it. We don't know. She didn't. These were texts that were between him and his father. You have nothing to tell me, WTH, or TF, I thought you were my seed. If what I can know, I can't fuck with you. Boy, that's true. Devil shit. It was clear, and he tried to smooth things over through the course of his testimony, but Devyn did not like his dad. He had an affair with his dad's girlfriend. You know, these things don't reflect too good on her, okay? They reflect poorly on Devyn. But Devyn's not here for good moral character. You can despise the choices that she made, but you can't convict her for murder, for a murder that she didn't commit. This is their home. The home that he's being kicked out of. Again, there's the walkway down the side. There's a way to get out the back. There's no cameras that were pulled on Rebecca. We don't know. The police did a slipshod investigation. We can't show you him walking away. They didn't collect the evidence, but the motive would point to Devyn. This gun, there was an issue made concerning that. That gun was looked at the afternoon of, I'm sorry, that's another gun. There's guns in his possession. We don't know if that person was shot or not. Jonathan was. The swords, again, we're not trying to throw these things out, aha, but this just shows a conscious indifference on the part of law enforcement in collecting evidence that could exculpate her. Their minds were made up. She was guilty. There's so much evidence here that you can go through and look. Again, thank you for your patience. Thank you for your attentiveness. You know, this is the last chance that we'll have to speak. There's going to be things that I have overlooked, things that I missed. Don't hold them against her. Hold it against me. You remember the movie 12 Angry Men? The jury went through and exonerated that young man. I'm going to ask you to do that, to look at the facts. You may not be comfortable with a verdict of not guilty. She's done some bad things. She didn't commit this murder. She didn't kill him and cut his head off, because those two things are combined. Common sense would dictate that they are. She's not guilty of this charge. Thank you.
I think, are you prepared to give your rebuttal argument? Ladies and gentlemen, because the state has the burden of proof, they are allowed to open and close the closing argument.
Let's talk about reality. I want to commend my colleagues over here who represented Ms. Michaels first, because they've done an exceptional job. And Ms. Michaels is entitled to a fair trial, like we talked about in jury selection. They've done a good job of coming through and poking as many holes as they can in the evidence, and I commend them on it. But make absolutely no mistake, that woman is guilty as sin. That family deserves justice. Those girls deserve justice. Do not take this lightly just because a real polished defense attorney gets up here and spins a yarn for you. Do not take this lightly. Those people deserve justice. If I were to tell you that a defendant confessed to a crime, described how she did it, everything she said matches the crime scene, except for the part where she minimizes or potentially blacks out the aftermath, you would say, well, that's pretty damn obvious. And some of you were probably sitting there when we played that confession the other day, yesterday maybe it was, or the day before, and go, why didn't you guys play this 2 weeks ago? We could have kind of sped this process up. Maybe you're thinking that. Because we have to show you that the cops did their job and she is overwhelmingly guilty. We wouldn't be doing justice to that family right there if we just played that confession and walked. And we didn't. We put 2 weeks worth of evidence up here to show you Devyn sure didn't do it, and she did. There is no reasonable doubt in this case whatsoever. And I want to address kind of an elephant in the room. You know, Mr. Draskevich just got up here at the very end and he told you those two things, common sense dictates those two things go together. And I kind of agree with that, right? The person who killed him, probably decapitated. But make no mistake, she's not on trial for decapitation. She's on trial for murder. She told you she did the murder. Now, she minimized it. She told the detectives that she hit him over the head and he was still breathing. Of course she did. But she admitted to the act that caused his death. Are we really, as reasonable men and women, going to believe this was a fatty liver or a marijuana overdose? Are you kidding me? That guy was murdered, and then his head was chopped off. And here's the elephant in the room. I don't care if you for some reason believe Devyn somehow snuck out of his home like a ninja, crossed town, and cleaned up the job. I don't care. She's not charged with decapitation. Look at the pleading document. She's charged with killing John. That is it. That is your job. Did she kill him or not? And the answer is absolutely yes. I need to show you a couple instructions because they're important. Bear with me. I know you're probably tired because we all are. But this is too important to just gloss over. This is the beyond reasonable doubt instruction. Mr. Draskevich addressed it. I want to tie this into another instruction. Doubt to be reasonable must be actual, not mere possibility or speculation. Instruction 31, direct versus circumstantial evidence. The top part is really important. I'm going to address that in a minute, but this one down here that's underlined is also important. You must not speculate to be true any insinuations suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. So everything Mr. Draskevich said through the course of this trial was a question, right? It was a question. That ain't evidence. So you tell me what piece of evidence, what single piece of evidence suggests Devyn did this? Not one. Not a one. And when you start accusing an innocent guy of murder, Devyn, you got to think about this for a second. That young man was taken advantage of. And like Miss Griffith said, it's not like he wasn't enjoying it and liking it and into it. No doubt. Mr. Draskovich in his opening statements suggested that Miss Michaels has a history in the adult film industry. Did you ever hear me ask that? No. Did you ever hear me or her mention that? No. Because Mr. Draskovich is right. She's not on trial for having a past. Doesn't matter. The only reason that does matter is because it dictates that relationship with Devyn a little bit, colors it. She is an experienced woman, much older than Devyn. He's a young knucklehead, and I would submit to you that when you heard from him, no disrespect, but that guy's not a criminal mastermind. He's not somebody who snuck out the back of the house, evaded all cameras, left his phone behind because he was thinking ahead to what he was going to do, somehow made it all the way across town, even though he didn't have his phone to contact anyone. There's no Uber notifications or pickups or anything suggested. There's no calls, no texts, nothing after 11 o'clock. So who did he contact and when? There's no evidence that Devyn was involved in this. None. There's actually evidence to clearly refute it. You heard those voicemails, and we can agree those little girls they're precious, they're adorable. Those voicemails eliminate this alternative suspect, which I will refer to as a scapegoat, because that's what's happening to him. He's being scapegoated, and it's not right. Those little girls said on those voicemails what Devyn was doing. He was knocked out, probably passed out, if we're being honest. And you didn't hear any other voicemails afterwards. You saw more calls from the landline. If Devyn had got up and snuck out, because we know the one little girl is awake and panicking and like scared, and where's mommy? She should have been home a long time ago. Where's mommy? Wouldn't there be another voicemail where they're calling going, Devyn left us? Like, really, Mom, where are you? Of course there would. Of course there would be. And there isn't. That's because Devyn was home. And you know that because he texted and he said, I'm going to sleep. He's no criminal mastermind. His phone is at home. There's no evidence his vehicle's left. There is zero evidence that Devyn is involved in any way. Zero. And so Mr. Draskovich brought up a good point with the instruction that Miss Michaels is the only one on trial. That's instruction number 36. I want you to think about this for a second before you let a guilty person walk. Okay? Think about this. Imagine if I were to stand in front of a bunch of jurors and try to prove Devyn's guilt. Imagine that. That's not what we're doing here. That's not what this is about, but imagine that for a second. Can you think of a single piece of evidence I could, with a straight face, present to a jury and say Devyn did this? A single piece? Other than speculation and really good questions by a really polished defense attorney? There is not a piece of evidence. I would be laughed out of the courtroom if I tried to prosecute Devyn for this homicide. Because he didn't do it. He had no reason to do it. Go look at the text messages between him and his dad. We included a bunch of them. Did he worship the guy? No. Did he hate him? Who cares? He didn't kill him. There's no evidence to suggest it. He says throughout the text messages to his dad, hey, what's up? You'll see it. There's like years of it. There's 2 years of it. And then those texts that Mr. Draskovich just showed you with the devil shit, I would submit that's a reasonable thing when you learn that your son is having sex with your ex or is married to her. That's reasonable. But then, they left out a text that's right after that, where dad is reaching out to Devyn like months later saying, hey. This wasn't some big, rift, homicidal relationship between dad and son. Now, when you're thinking about motive like that, you've got to think about this defendant. She told you in that interview with Detective Lynott and Christopher why she did it. She said it clear as day. I didn't think he was really going to move in. The walls were closing in on her, and she made a real horrible decision. A real bad decision. She said that she very specifically got up. He was down on the bed getting a massage. Got up because she was a little pissed off, I think were her words. Maybe don't quote me on that. Something like that. Walked across the room, grabbed this heavy blunt object, bashed him over the head, and he went limp. That's a confession to homicide. Okay. On top of that, she told a DFS worker, when you're thinking about motive, in the context of losing her children and homicide, specifically, which she brought up, she said she had to do it. She had to do it because that's how she felt. And I'm going to answer, or try to answer, a couple of unanswered questions for you. We all get this evidence before trial. You know, we're all obviously somewhat prepared. I'm not like tooting our horns, but we're prepared. We know the evidence when we come into this case. There were clearly going to be unanswered questions in this case, right? There's a missing head. There's a missing murder weapon. There's missing implements, no doubt. But think big picture, forest from the trees. Think about reality, right? Criminals ditch murder weapons all the time. Criminals try to cover up what they've done all the time. Just because she ditched the head and therefore the doctors can't confidently say what injury did it, does that mean she gets a reward? Like, does she get to benefit from the actions she took to cover up? Of course not. Does that mean we can't convict her of murder? Of course not. And that is why I asked Dr. Sims those questions earlier. I didn't challenge his credentials. Like, I've dealt with him on cases before, as you probably noticed, and he's a smart enough guy. He's very educated. But he's not disputing that a blunt blow could kill a man, right? He is saying exactly what Dr. Yagi said, the decapitation is post-mortem. And you know what he didn't say, which should be very notable for you? That there were other bleeding injuries on the body, including the hand, right? Because there weren't. He didn't say that because there weren't any bleeding injuries to the body except for up here. And that's how we know she did it. That droplet of blood, you can go back and forth about the DNA analyst not confirming it's blood. Well, DNA analysts actually look at DNA profiles. And DNA is in every single cell of your body, including your blood. And so no, a DNA analyst is not going to come in here and say, John's blood was on the phone. She's going to say, John's DNA was on the phone because she's a DNA analyst. That's what that is. John's droplet of blood being on that phone convicts the defendant even without her confession. Set those, two confessions actually, because she told the DFS worker she had to do it. But set those aside for a minute. There are no bleeding injuries on his body, except for up here. The phone left at 2:04 with a droplet of blood on it. That means the murder happened before 2:04. It had to. Nothing else would make sense. Nothing else would make sense. She, the defendant, traveled with that phone. Okay. So then you got this other big glaring unanswered question. Why, how could someone be capable of doing that? That question, I can't answer. Okay. This is reality. It happened. I would submit to you that there is a chance that what she said about that hour and 4 minutes is true. Maybe our psychology major could talk about this. But I would submit to you that she may have been genuinely telling those detectives the truth that she didn't remember chopping John's head off. Because this is beyond anyone's wildest dreams. Violent beyond all imagination. And there is a good chance she blocked it out. That doesn't mean that she walks out the door because she says she can't remember. It convicts her. There is no way she didn't do this. The evidence is absolutely overwhelming. And I need to address a few points because I just can't leave them unsaid, so please bear with me. Mr. Draskovic called into question Devier's testimony, and I want to bring this back for a minute. I think Devier is pretty well excluded, but he walked into this courtroom, and I want you to remember that I asked him the question, did we bring you back? We didn't have to arrest you or anything. He came back willingly. He flew here, right? He brought his girlfriend, a little more age appropriate now. I guess he's learned his lesson, but walked in the courtroom willingly with that big old camera and all you strange faces to him. And he sat on this witness stand. He swore an oath to tell the truth. He got up here. He testified. He looked at his wife. He looked at all of you. He looked at me. He looked at the marshal with the gun and the badge. And he testified to the best of his ability. Now, I am not and will not endorse his character. I don't know the guy. I've met him a couple times because he's a witness. But you got to see him tell you the most intimate details of his life. And I asked him straight up for a reason, and I did this early in the trial because we just learned he's the defense. Put him up early, and I asked him, did you kill your dad? And he said no. Now, I know he's a stranger to you, and you can't just accept his word, but you've got to consider the circumstances and what it took for him to do that, to put himself in front of the world, and testify about all this. Willingly. He came back. We flew him back from California, and he came in here and he answered questions from a very skilled defense attorney for however long he was on the stand. Think back to that. Did that kid strike you as someone who snuck out of his home, plotted this big old thing, and killed his dad and then somehow covered it up? Or did he strike you as someone who got himself in a bad spot, his words, tried to fill some shoes he had no business filling, and made a series of mistakes in relationships? His testimony from the stand has to be considered in context. And it's all corroborated. Now, I would submit to you that if he came up here and he said every word consistent, precise with everything he said over the last 2 years, then you might rightfully be a little suspicious. Like, oh, what is he studying for this? He had some inconsistencies. We don't shy away from that. He's not perfect. I asked him a question. I think the word I used was tumultuous, and he's like, what does that mean, sir? I don't know what that means. He's not a criminal mastermind. No disrespect to Devier, but he's not a criminal mastermind. He's a scapegoat. Don't let that happen. Need to address our pleading document. Mr. Draskovic brought this up, so I just have to address it. So you heard in the beyond a reasonable doubt instruction, it says the state must prove every element of the offense beyond a reasonable doubt. This is a legal pleading in Nevada. We are permitted to use unknown means and manner of death and unknown deadly weapon. This goes back to what I was saying earlier and what Ms. Griffith said about the deadly weapon instruction, where it says the state is not required to recover the deadly weapon used and present it in trial. There's a reason for that, because like I said earlier, this happens all the time. We don't reward criminals who are smart enough to get rid of the weapon. In addition, we don't reward criminals who are smart enough to get rid of the head after they've crushed it. That's why we are legally permitted to do this. Unknown object, unknown cause. Only question is it murder? Is it not? Did she do it? That's it. And it's absolutely first-degree murder. Mr. Draskevich brought up the robbery instruction, or the robbery pleading felony murder stuff. So I need to address that as well. Instruction 18. So, when you first heard the charge read by the clerk, I'm sure you're like, what do you mean by robbery? This doesn't really, it doesn't really make sense. This doesn't really seem like a robbery, but bear with me a second. Taking property by means of force is a crime. The motive and reason behind it is separate. So yes, she took his wallet, his keys, and his social. We're not saying she took that for its value, right? It's not like the traditional robbery. The evidence says she took that for a reason, and it all comes down to one thing, and that's the girls. She took the Social Security card because she knew she had John out of the way, and she was going to make some changes and live the life that she wanted to live. So it is, by law, a robbery what she did. She killed someone, took their property, but we're not saying that she took the property to take the property. She took it because she wanted the girls and she wanted John out of her life. Instruction 29 is the motive instruction, or we call it the motive instruction. Motive is not an element of the offense or the crime charged. We're not ever required to prove motive, but you're permitted to use it to color kind of the facts of the case and determine whether there was a motive that could lead you to convicting on the crime. I've addressed motive a little bit. I just want to kind of wrap up that idea with this. John and Yoko and his side, they had a very different understanding of the moving situation than the defendant. Okay. She didn't want it to happen. Go look at the text, especially the ones that Miss Griffith showed in her closing. John is continually saying, I miss my girls, I want you girls back, we need to put this family back together for the sake of the girls. And go look at the defendant's responses. Those ones that Miss Griffith showed. One was, I'm glad you appreciate what we had, or how it was back then. And then that last text she put up where John is saying, we need to do this, we need to have them under the same roof, she doesn't respond. So go look at those when you're thinking about motive and tie it in with the last statement, the confession. There is no doubt that both sides have been aware of this potential for a move. What I would suggest to you the evidence says is that she didn't want John moving in, and John did. John wanted that. And it didn't become real until that night. And you know that because of the conversations with Devyn. He's still there. He's literally still living there. So if he was going to be moving out for John to move in, why isn't he moved out already? That's because no one expected John to try to make the move that night. And that's when the wall started closing in on her. She's thinking in her head, I want my girls back. I want my girls. That's it. This guy can't move into my house. That's not what I want. She wanted him out of the way. And she did what most reasonable people wouldn't do. She made the decision to take a blunt object and bash him in the head and kill him. I want to address a few things with the defense expert. Mr. Draskovich showed a couple of cameras and a couple of texts or activity, 212 and 230. One's a Discord, one's a photograph. Remember what their own expert said. That wasn't active activity. That could have been background activity. It could have been active. He can't say that. So whether Devier woke up and activated his phone at 212 or 230, well, that just tells you he's still at home. And if it's just background activity, then who cares? Either way, it's not good for the defendant because it rules out Devier. He's either with his phone or it's a nothing burger. Mr. Draskovich talked about the boxer shorts being off, and I already mentioned this. The defendant may very well have blocked out what she did after she killed him. And whether she took the boxers off or not doesn't really matter. It's probably very likely that he was naked when they were having this massage situation, but the boxers being on scene have no real import in this case. Mr. Draskovich talked about the CVS pickup, and I got to address that. So he said, and he showed you the video, there's no blood on the defendant in that drive-thru. Now, we all watched it together. I don't see any blood from here up from what you can see. But do not forget, that shirt was never recovered. Neither were the shoes. Now, I'm not arguing to you or suggesting that I know what the defendant was wearing when she decapitated him. She could have been naked. She could have put John's shirt on. She could have changed her clothes, a number of things. But what I am telling you is that white shirt, from here up, maybe no blood on it, but it's never recovered. So we don't know if there's actual blood on it. Mr. Draskovich asked you a question, and I need to provide an answer. He said, is that a woman picking up this medication for her girls that's just done this, has the wherewithal to have just done this and go pick up medication? Yes. Yeah. That's reality. You heard the voicemails. The little girl was saying, you were going to get my medication. I'm not saying that the defendant is a bad mother. I will not say that. That ain't right. She took her children's father away. That's a bad thing she did. But did she care about her girls? Obviously. She stopped to get medication? Obviously. That doesn't exonerate her in any possible way. And neither does the post-homicide messages she sent to the victim's phone in the early morning hours. There is two very real explanations for those messages. Number one, you already know the extremes she went to cover up what she did to his head. She took it. That's extreme. She poured chemicals. She took a bunch of stuff from the scene, probably a towel too that was on top of him when she did the chopping. It's not outside the realm of possibility that she sent a text and made it look like she thought he was alive. That's certainly not unreasonable. The other explanation, as I've intimated to and pretty much said directly, is that she doesn't remember the real bad stuff, and legitimately in her mind, he was still alive after she hit him. Because from then on, she blocked it out. So take those text messages for what they are. They're either she's alibying herself or covering up, or she genuinely doesn't remember the wet work. That's what that is. I have to mention the timing of the big confession, not the one to the DFS person, but the big confession. If this is all, there's no evidence to say this, but according to Mr. Draskovich, this is the defendant covering up for Devier. If that is true, why does she confess after she's arrested? She's already been arrested. Devier's gotten away with it. Why does she confess after? Unless it's what happened. Mr. Draskovich showed a couple of videos, the small movement off screen. Remember the 2696 video? He showed the small movement off screen, and I believe he said, I'm sure it was just misspeaking, but I want to make sure it's clear, that that was the 204 movement. That was not. That, according to the detective, that was the 11 p.m. movement when it goes off screen. And we know that for a fact because the burla shows that exact movement at 11, or it's 11 or 11:04, I can't remember. The 204 footage on that video is when you can't see the car, it's already out of frame, but you can see the lights turn on and it leaves. And then that is also consistent with the burla, so just needed to clarify that. Want to briefly address the girls. So you didn't hear from them in this trial. You can probably imagine why we wouldn't want to put them through anything more than what they've been through. I would just ask you to, that's my decision. I live with that decision to not call them. But I would submit to you that you heard everything you needed to hear from the girls in those voicemails. Devier was home. Devier was asleep. That's it. Need to briefly address this DNA stuff. So Mr. Draskovich made a point about the swords, the shower earlier in the trial, not an argument, but no blood being in the Nissan Armada and the footprints. And I just want to take this to its logical conclusion. So say we swab the swords and any one of the three's DNA is on it. What question does that answer for you that hasn't already been answered? If Devier's DNA is on it, it's, well, he's handled the swords before. If the defendant's DNA is on the sword, it's, well, she lives in the home, of course her DNA is on the sword. If John's DNA is on the sword, it's, well, yeah, those are his swords and they were just moved from his house in the move, right? That doesn't answer an actual question in the case. DNA being in the shower. The defendant's been to the home many times. Have we found her DNA in the shower? What is that going to change for you? Absolutely nothing. No blood in the Nissan Armada. There is so much evidence of her covering up her acts at the crime scene. It should not be shocking to you that she could have wiped up some blood if there was any in the Nissan Armada. We know from the patterning at the scene, and you look at it for yourself, the blood on the ground, there is something she used to collect that head. There is a very straight, clear line on the border of that blood that suggests that something caught that head. And whatever that was, she took it with her. And when the defense says there's no stops along the way, we agree. But what they can't say, no one can say, is what she did when she got home. And you may remember that many times, different witnesses talked about it being trash day. It is not very hard to walk over 2 homes or 3 homes and dump a bag or basket or whatever it is in a trash can. And, I got to address the investigation. Now, the detectives are all learning this stuff as the investigation goes along. They didn't have the burla and all that stuff when they go to Porcupine Rim on August 7th. Should they, because of they did know there was a head missing, should they have checked every trash can in the neighborhood? Yeah, probably. But they didn't. Okay. That doesn't mean that she didn't dump the head in the trash can. And that doesn't mean that this investigation gets the case thrown out or the defendant acquitted. These detectives actually did a
pretty darn good job of follow-up investigation. When they suggested that she was the convenient, shortest distance between two lines, I disagree with that. Because remember, they found all that stuff in her home on August 7th. All that stuff, highly suspicious, blood on the phone. Did they arrest her then? No. Could they have? Yep. They didn't. They went and did mountains of follow-up investigation. All of that confirmed the suspicions. And then she confesses after she's arrested. It's too important to miss anything, so bear with me. I know it's getting late. Almost. Instruction number 35 is important. In arriving at a verdict in this case as to whether the defendant is guilty or not, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. I want you to take that to heart. There's a phrase that's commonly thrown around in this courthouse. It goes, admit what you can't deny, deny what you can't admit. I'll say it again. Admit what you can't deny, deny what you can't admit. I want you to think big picture, forest from the trees, just one more time. When there is a confession and DNA and mountains of phone evidence and video surveillance, what could the defense possibly do? She's covering up. The only thing that these very skilled defense attorneys could say in this case. We, luckily, have a mountain of evidence to disprove that. Admit what you can't deny, deny what you can't admit. They were painted into a corner. I commend them on their job, but what they did is they blamed an innocent person for a homicide he didn't commit. And I don't want you to blame the defendant, Ms. Michaels. I don't want you to judge her based on whatever her past. No one's asking you to do that. I also don't want you to take into account whether she's a good person or a bad person. She seems like she has some good qualities about her. Seems like she's trying, to be a good mom. You must not make this decision based on sympathy or a popularity contest. Mr. Draskovich, very likable. We're not here to do a popularity contest. This is real stuff. Okay? Real stuff. Do not think about whether you think she deserves a little leniency or redemption or this is a one-off. She lost it. None of that matters for you. That matters for the judge, Judge Jones, who in her wisdom will sentence the defendant, not you. That is not your calculus. Your job is simple. Did the defendant do it or not? That's it. Please remember your oath to follow the law. It's my understanding the judge is going to let you stay a little bit after to deliberate tonight. I'm sure you might get instruction on that, but please don't take this lightly. This is important to more people than just the defendant. She is guilty beyond a reasonable doubt. Guilty of homicide. Thank you for your time and attention these 2 weeks. We really appreciate it.
All right. I'm now going to ask the clerk to swear in the office service to take charge of the jury and the alternate jurors?
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God. Yes.
All right, ladies and gentlemen of the jury, as you know, a criminal jury is composed of 12 members, and there are 14 of you who are here. That is because 2 of you will serve as our alternate jurors. This means you are not discharged from your service as a juror. Your service may still be needed if one of the other jurors is no longer able to participate in deliberations. In this case, our alternate jurors are juror number 13, Ms. Fitzpatrick, and jurors 1. May the record reflect we are outside the presence of our jury. Do you guys have any further matters outside?
Man, I told you part of the defensive strategy was to say the husband did it. If you can prove that the husband did it or cast any doubt that the husband did it, then you gotta acquit her. He pulled it out his ass at the end.
Yeah, I heard him. Tough case. So how long you think they're going to take on this?
On says she think they coming back in an hour or less. I feel like every time we say that, that'd be 3 and 4 hours. Are there any lesser charges in this that they can consider? Or is it just straight up and down first degree?
I believe all I heard was first degree. And I think the chat went to sleep. Or they went to happy hour or something. It's Friday.
And we have been here 7 hours.
Candy said nothing less than first degree. Ooh-wee.
The prosecution pointed out that she confessed in the interrogation room was exactly why you don't speak without a lawyer, so they can have nothing to play at court.
And see you keep it cute.
Man, I done did a street interview and everything, and they still ain't came back. My bad, man. Man, you dropped? Oh,
I don't think
nope,
so.
man, you didn't drop. I took you down. My bad. Well, damn. These motherfuckers still ain't got fun. Well, so much for saying they gonna be back in an hour. And we gotta realize it's in Vegas, so it's just 5:52 there. So they probably gonna go for a couple more hours. Why the hell, man? Keep mad. I'm about to
Nope.
email you, but I saw you email everybody. The first one that you sent, can you put the background black so I could use it on my green screen? You got the clear background. I need one black so that it'll show up on my hold on, let me see how this motherfucker look. Let me see. Let me see how it looks. Cause I got it. Oh, it's already black. Never mind.
Yeah, if you
Well, I
using a
got the
green
screen.
screen, anything that you put with a green background automatically stick to your green screen. If you know how to use your chroma key, that controls the green
I've
screen.
downloaded some shit. I didn't downloaded some clear backgrounds before, and that motherfucker it showed up weird. Hold on, let's see. Where's
Which call
red screen?
use the Paint 3D. Got a that's what I use to make all this. It's free on your which call. That got an automatic transparent.
Okay, I see it. Okay, never mind. You don't have to make anything. Okay, that's pretty cool. Okay, because when I downloaded it, the background was clear. But okay, I see it. I see it. It's
Which
black.
call and if you could switch the color on your chromo, any background that you got, just put it on the color of what that
Man,
background is, and it automatically pull it out.
man, I just be cutting these. I just cut the computer on. I don't know how to do all this shit.
Oh shit! Oh,
I
I've been
just cut
learning
it
a lot over
on.
the last year.
I guess eventually, when I get yours truly her computer back, I guess I do OBS. But my computer, I'm still stealing her computer. Yeah, I said it.
I don't know if you heard about it, but Red Lobster got some new seafood.
Red Lobster. Hey, so how about my 17-year-old called me sir the other day? I was like, bro, don't do that. You got me feeling old. He was like, nigga, you are old. I was like, well, fuck you too then. The hell? I ain't that goddamn old, nigga. Your mama older than me. The fuck? Man, I had just did a interview with my partner PIFYO right quick. Did a little shit talking. How long have they? How long? What's the estimate? How long you think they've been gone? They've been out deliberating.
Oh, shit, it's been a minute.
It's been at least. I know it's been over an hour for sure.
Hold on, I'll be right back. Don't let keep it cute beat me up badly. Just think I'm a juror.
Why in the fuck do I? Grayson must have cut my other phone. I'm like, why the fuck do I hear myself talking? Grayson. Grayson. Now she act like she can't hear. She was just trying to be all in my interview. Now she act like she can't hear. That's fine. I go get it when I have to give her. Can you bring me my phone, please?
Yes, sir.
There you go. What, Grayson?
Then what's wrong with you?
What you mean? What's wrong with me? What's wrong with you?
You are recording my voice into that phone. I know that.
I'm not recording your voice.
Yes, you are.
I'm not recording.
Cause you said
I'm live. I'm live. I'm not recording your voice. I'm live, and so you heard. I'm watching the live on that phone, and so that's why you can hear me talking.
Cause they said, cause I heard my name and I started coming from the phone. But you actually called my name for real, and then literal said, and then I said yes.
Yeah, that's why I was coming from the phone because I was calling your name for real.
Stop doing that stuff.
Stop doing what?
We go up the top of moment. Yeah, go get it. Whoa, I'm hiding now, shining like a boy big. See, I can't wait. We go up the top. Whoa, I'm that high. I'll be shining. Boy, baby.
You done? You don't have, it's a microphone. You ain't got to get into it. It's fine. It will hear your voice from where you at. When you get too close, to get loud. You scare people.
Hello.
So you ain't got to get close. So you can say hello from where you at.
Hello.
They can hear you.
It's a data. Sophie, so is a
say truth. Oh, I know I'm old, but dang, is it? He ain't have to say it like that. The kids is rude. I know I'm old.
I just think you in my eye. My child and a few it's ugly. Ding 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 ding. Not even when you find it, that is so. If you want to go in my face, I don't see you right. I'm a soda pop. I don't soda pop.
How you just gonna put all the songs in one? You doing a mashup?
Yeah, I done, run, we run the town. Going down, 100 dog how done. We can be free, yeah, free.
This was
We can fix it.
Grayson was looking for you.
On the pathway, No. In the pathway,
You ain't gonna say hey the truth?
Oh, hey, truth. On the pathway,
She too busy looking at herself on this screen.
I'm looking at her right now.
Get out of here. It's a bad song. I'll be your child. Can we with that? I'm gonna come and get in there.
In the choir.
Get out.
Can you come a mic just a little bit higher?
Here you go.
Sing it, girl. Sing it. That's my jam.
Give me your desire. If that could be a dog, you a child. I call you live when you could look at check. I can you come. Meow. I need to be your child.
Yes.
And the last song.
What's the last
Yeah,
song?
it's about your shoes. Yeah. Yeah, you had to
do. Soda pop.
Yeah, my soda pop. And don't want you to need me yet. I need you to feel me. Yeah, I see call my bottle. It's that with a T on my thing, but okay. Ding, yeah. What I need is a and we'll see, boy, yeah. Look with that one word like that. Big with power one like that. Going down, I don't know what I You got one day when you in my arms, I hold you to die. To die, to enjoy that tonight. She got down, gang, tonight. They were tired, me. When I need you to need. Day do you see me so weak?
Fresh chick,
My
Miley
soda
soda
pop
pop.
pop. You're all I can think of. Every drop I drink of. You're my soda pop. My soda pop. Pull me down so high. Pull me up, I won't. You're my soda pop. My soda pop.
Yeah.
And next, not but you
You don't gotta get that close to the mic. It picks you up. That's what microphones do. You ain't gotta cut the mic a little bit higher.
Trey, these folks been on for 2 hours now. What's going on?
Well, it's just 6 o'clock in Vegas, so they got time.
They been on since 4. What time we said it was, baby? 4 or 4?
Hey, did you
No, it ain't been. They ain't.
I want 4 hours.
No, they ain't been out 4 hours. They have not been out 4 hours. Yeah, but so it's been 2.
Yeah, it's been 2 hours.
But it's still 6 o'clock there, so I'm sure the judge will probably at least go to 7:30 if they ain't got one.
Shouldn't take that long. Shouldn't take that long at all.
That's what we always say that.
This is ridiculous.
I think the prosecution did a good job creating reason without saying, because he pretty much just went on and said the husband did it. The son killed him. That's what he said.
You mean the defense?
Yeah, the defense.
I think that's what they were gonna do.
Yeah, as long as it looks plausible that somebody did other than her, they should have quit. That's what reasonable doubt is.
It didn't help that the son had like he was a little slow and couldn't answer questions. He couldn't talk loud. He just he wasn't a good witness, Trey.
I mean, that is his wife, so they could have concocted this scheme together. He don't want her to go to jail, and they're not gonna charge him.
I mean, hey.
They already cleared him, so what the defense says in court don't mean shit. They cleared him. There was no evidence showing.
You know that was their first thought that they did it together. That was the first thing they thought when they had.
So there actually was a good defense to try to make it seem like he had motive. He definitely had motive to do it. And he hammered it down like. Go ahead.
Who's your ex-boyfriend's son? He got to move out so the ex-boyfriend can move back in. See, this is some Vegas type shit.
Your husband had to move out so your baby could move in.
Absolutely.
Which was his daddy.
Absolutely.
Yeah, their relationship had to be strained. Oh, bro, you fucking my baby mama? Your stepmama.
Mm-hmm.
Will Ostrich, it's a trial going on. That's what's happening. And we waiting on the jury to come back. We on verdict watch. It's medicine time. No, I gotta give you a medicine. What you mean? No.
Nope.
Let me up, sister.
Nope.
Let me up.
Nope. Okay.
Who you say? Who?
You wrote your letter to Santa?
Nope.
We don't believe in Santa over here. The white man ain't getting credit for my damn gifts.
We're going up.
She's still just as happy when she opened them damn presents.
I'm gonna be looking at them like, bang.
If we just break it down, Santa Claus be breaking it in here, people dumb. Nobody know this.
You do tooth fairy,
What happened?
but you won't do Santa.
I actually don't. I tell her, she still just say the tooth fairy, but she know I put that money on her pillow.
No, you did not. You're lying, Daddy. You're lying to kid, Daddy.
We gonna stop these here children.
Daddy, you're the one you're not the tooth fairy. You're the loop fairy. Why?
I wish I would wake up to see a fat white man in a red suit in my house. I'm shooting him.
What's that? I don't know his name. It goes Santa Claus is a black man.
What the hell did you do? I ain't never heard that song. So that must have been. They must have played that on.
Helicopter.
Y'all ever heard Santa Claus is the black man song? I ain't never heard that.
Keep it cute. That girl is a song called Santa Claus is a black man.
I ain't never heard. Well, keep it cute. She grew up on the 45s too, so she probably know it.
Huh?
That just like the Cool Jerk or something. I don't know who sang Santa Claus a black man. Chuck Berry.
1, 2, 3.
That's the Sammy Davis Jr. classic, ain't it?
Let me see. I'm gonna go. I can't remember who sang.
Chubby Checker.
2, 3, 4, 5. No.
You act like you don't know the music, but you be knowing all the artists.
Yeah.
But all the reason I know this is because you know them commercials used to come on and they would have all the old hits on them. And they would say the CDs.
Kim and Teddy sang it. And Teddy VANN. Santa Claus is the black man. That's a song, right?
Never heard. Keep It Q said she loves Santa Claus is a black man.
X. What that mean?
I think that junk came on what's them little sonophones or whatever they used to call it, the first radio?
You heard it.
Not even a 45. I ain't never heard this shit.
Your mama used to play them songs first.
Probably did. She old as hell too. Mama born in 55. She probably do know it.
Daddy, you want me to sing K-pop?
Your mama how old?
She was born in 55. She's 70. On the dot.
Oh, okay.
She about to be 71.
Daddy.
I was gonna say, what?
And my daddy's 75. He an old nigga. He an old slave nigga too.
Daddy, something.
No, he said his mama was born in 55. Mama was 55. I'm gonna say she started young as hell.
Open your mouth. Open your mouth.
No.
Like you have 2 teeth right here.
No, it's just one. It's
No,
just push back.
no, like
It's just one. It's just push back.
the other one pushed right and the other one didn't
No,
push.
we have catfish fry.
Oh, 2 here. I see 2.
All righty.
What you cook, Trey?
Nachos.
Tom.
That sounds good, but you late. Taco Tuesday was 3 days ago.
I ain't say nothing about no damn tacos. I said nachos.
You said taco. He said nacho, not taco.
You late.
I guess.
You lazy.
French fry or wheat or fried something. What's it? No, fried fish fry.
I'm too cute to get burnt by grease.
You're not cute at all.
Bye. You look like me, so if I'm ugly, what they say about you?
You're ugly. I'm pretty.
But you look like me, so if I'm ugly, what does that say about you? You're a reflection of me.
Me is pretty. You are ugly.
It's not me, it's pretty. It's I am pretty.
I am pretty.
Yeah.
You're not pretty.
Okay, I'm handsome.
No, you're nothing. You're just ugly. Think of my live show. My daddy's not going to be in it because he's ugly. This is our live show. We're going to be singing songs for everybody in this whole planet. Let's do it. I'm done hiding now. Like a
We're going up, up, up. It's up my army. Gonna be golden. She a hater. She stopped me. She cut the mic off.
Because they don't want to hear you singing. They don't want to hear, I done lied. They're your boys. Yeah. Now we're gonna be a guinea. I'm done hiding. I'll be hiding. I come That's it. But we're gonna have a lot more to do. My daddy don't interrupt it again, like he did last time. But we're gonna finish your homework tomorrow. No. So you turn it in Monday. No. Oh, give me your backpack. Let me see if they got y'all Spirit Week stuff laid out. These kids, like they wear uniforms, but they let them out of uniform so much, you might as well not have them. Can I get back on? No. What? That's what I be talking about. The lady had us send all them folders to school. Why her folder look like this? And we had to send 10 of them motherfuckers in. She see this regular ass folder every day when she put her conduct in it. Hey, look here. Tell Miss Mouse to change your folder. Okay. Yay, it's Friday. And the school done got cheap. Normally they print out a paper and tell us what they can wear each day. She done wrote it inside the folder. Oh, you got another E. E. Spirit Week. Shady Monday. I don't know what the hell that is. Shade to me. We gotta wear shade. We gotta wear a hoodie. I don't know what. Are you sure about that? I don't know what we're gonna. I don't know what Shady Monday is. And Tuesday is Twin Day. What twin are you supposed to dress up like? Zoe me and Zoe gonna dress up together. What is Zoe wearing? Oh, she was gonna wear K-pop Demon Hunter for me. You ain't got no K-pop Demon Hunter stuff. Oh yeah, I don't. I don't think she got none either. She should. Wednesday is Tacky Day, which I do not agree. I hate seeing the kids tacky. Thursday is Thankful Thursday. Like this Spirit Week is stupid. What the hell is Thankful Thursday? You dumb then. And then Friday is Game Day, so I know that's Sports Day. What do we want to do for Sports Day? Wear one of your sports outfits. Nope. And then after that, I think y'all out of school after that. What's Friday? Nope. Friday is the 19th? Nope. No, yeah. Friday is y'all last day, and then y'all out for Thanksgiving break. Yeah, are we gonna go to a new grade? No, you don't go to a new grade until like April, May, maybe. Okay. Shady Monday. I have no idea what Shady Monday is. All right. That's signed. Yay, it's Friday. See her little cute backpack. Where'd it go? Hello, kitty. The motherfuckers told us they needed clear backpacks, and then when I got her the clear backpack and sent to the school, none of the other kids had clear backpacks. What the hell is this? Oh, shit, just be making stuff. All right, trial. Yeah, this bullshit.
Okay, boys, back to the news. Let's get back to the news. I'm seeing a daggone. I'm seeing a title over here that's haunting my eyes right now. Seems like a OnlyFans model got caught violating a dog. Should she go to jail? That's some nasty shit. See what I can get off of this real quick. This shit's like, damn. I hope it's a crime. What's going on, Danielle? Renee, welcome in, welcome in. We're sitting here waiting on the verdict here. They taking forever. Like we've been going at this, going on 9 hours and 7 minutes. And she's still not guilty yet. Matter of fact, I'm gonna just go ahead and drop this on my wall. I just see the oh shit, it's real video. This is a real crime shit. There you go. Yeah, I'm gonna go ahead and drop that on my wall.
Oh, y'all, for the nasty people, Too Strong is doing a sexual Jeopardy or something. It's something to do with sex, but it's Jeopardy. She had a test run earlier. I think she's supposed to be coming back tonight.
Oh, shucky ducky. Yeah, she need to be locked up for a long time. That mean you out here fucking dogs. What? So she's a mother of two, posting bestiality on Snapchat. They red flagged her account and they called the police. This is in Florida, Port St. Lucie. What's something wrong with this chick? Oh, whoa, 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 whoa. Holy moly, boy, the plot thickens on this one, boy. Evidently, the account that sent the bestiality earlier this year had a video up there with a minor. So evidently, this is a real sick person here. By the way, I just posted that on my wall. It's under Sandra Faye. Got that on one of her videos here. I don't know where she found this crap at. I didn't see this come across my timeline. Oh, my bad. The child video was back in 2022, and they took their account down after that. And I guess it reappeared with this bestiality up here. What a freak. Okay, it looked like so far it looked like she is trying to check out this video, like the things I was saying earlier, the AI thing. I guess she's trying to figure out if this is a real video. If this is a fake video, boy, damn, they getting good. I gotta catch up. The narrator on this video talking too damn much. Let's hear the cam recording the voices.
Man, what do you think about what do you think about Kirk Franklin pretty much condoning well he said he doesn't know why the church has homophobia. And the simple answer to that is maybe because God calls it an abomination. Maybe that's why the church is kind of against it, even though they've lightened their stance, which is crazy because how you if you believe that book, how you just gonna come up with your own thing and say it's cool when the book clearly defines it.
Uh, I'm thinking he's making that statement because he has some kind of information like I got of that is the root of the church. I don't, they being hypocritical, saying, you know what I'm saying, the gays shouldn't be in there when they allow a gay man put his name on the front of the book, first of all. And then homosexuality goes back even further than that with the Roman army that in their crusades that pushed this crap on us. It was more homosexual activity going on at that point while they made these crusades. You know what I'm saying? So I don't know.
There's
He might be on
instances,
something.
but not that there's instances of homosexuality in the Bible. Remember when the angels went to go visit Lot, and the townsmen wanted to rape the angels. The townsmen wanted to rape the angels, and Lot was like, "No, don't touch the angels. Take my daughters instead." I'm just saying.
Matter of fact, the symbol of the cross is actually homosexual. And I'm not saying that to offend nobody. But if you know the
The cross
original
is a
origins
dagger.
of
It's a
no,
dagger.
actually it's something else because you got to look at what the Africans had as far as the ankh. If they chiseled off the top part, which is representing the woman's womb, and the piece below that was representing the phallus, you know what I'm saying? The pieces on the side was representing the I believe the ovaries. You know what I'm saying? It was all the ankh represents life. When the Europeans came in, they chiseled off the top part, which was the woman's womb. You know what I'm saying? And they added another stem on it, which now you have two phalluses going to meet at the intersection of that cross. Most people don't know that history. You know what I'm saying? And this is real stuff. This stuff is written down. You can go find this stuff by their words from their time. You know what I'm saying? But so homosexuality is a big part of this new structure of religion, going all the way back to Roman shit. That's why some of the times you hear me say that the book is basically prejudice against women, but the women really don't see that though, because they don't have the history, or the real history of a lot of the creation of that book. It wasn't always a book, but once they put it in book, whoever put it in the book had control of what was going in the book and stuff like that. So Kurt Franklin trying to store some shit. These folks ain't trying to hear that. They gonna look at him as a devil. First he came in and changed the gospel music with doing hip hop all with the music, boy, just being a devil. Now he trying to bring in the homosexuals. Tell you the truth, I ain't never liked none of his music. Oh, so basically, this woman is saying she got kicked off of Snapchat or Snapchat or whatever that shit is. I ain't got that shit. Goddamn, she got kicked off of there for breastfeeding her son on camera.
I got more white people triggered.
Damn, I'm
He
hungry.
tried. Nah, he tried to come back. I don't think I'm gonna be able to find the comment now because I just left it. Fuck. Yeah, it's gone. Watching Love and Hip Hop Miami. That boy, that mean these white people really have no answer. They have no answer when I point out what they do, and then when I just break it down and be like, wait, are you saying white people don't commit crimes and do stupid stuff, yet they get locked up every day? So, like, can you focus on white crime first and then talk about us? And then he said, we cause more chaos. And I'm like, well, if it's more white people in jail than black people, wouldn't that mean y'all are causing more chaos? Because if you just simply do the numbers of how many white people are in jail versus black people, they outweigh us, but they don't ever want to look at that. It's easy to look at somebody outside yourself, but no, partner, you got to get white people to stop committing crimes and doing stupid stuff, and then maybe everybody else will follow suit. They had a show called Jackass that ran over 20 years of white boys just doing stupid shit.
Man, I remember that
They
crazy
didn't
clip.
they didn't have
I
white
ain't watch it.
fatigue over that. They ain't got white fatigue over incest. They ain't got white fatigue over school shootings. They don't have that. They won't be tired of everybody else. I just keep telling them to do something then. Get off your ass and go hang a nigga and see how that goes. Go burn a cross in somebody's yard and tell me how that works for you.
What the hell is JFabby? JFabby. I guess it's some kind of social media app.
I don't fucking know. I fuck these hoes after I shows big dicks. We slang free, bro. Do your thing. Biz, jets, hummers, bits, roll, legs, move, sick. Man, Ray J came out here and said he wants to do a versus with Mario. Ray J, we only know one wish by you. You have to have 20 songs, sir. We can only name one wish. Versus how? What other song does Ray J have to be able to do a versus? Okay,
Man,
sexy. Okay, he
that,
got sexy can I. Ray J, I know sexy can I and one wish. That's two. What else is he gonna perform?
unless he wrote a lot of songs that we don't know about.
No, he didn't. Ray J didn't even write one. He didn't even write one wish. His hit songs he didn't write.
I don't know. I don't like him or the group. That generational group of guys, man. Them dudes are weird. Him, Bow Wow, all them dudes are weird, man.
Hey! You leave Bow Wow alone. That was our childhood rap, there, sir.
Did you see how they was acting that day on Versus? Man,
Bow Wow was
this,
on Snoop Dogg's first album. He said, "I want to be a motherfucking gangster." He was like 6. You leave him alone.
I know that was back then, man. Yeah, he had a thing, but as he got older, it's something weird with them guys, man.
Bow Wow,
Listen,
yippee yo, yippee
Marcus
yay.
Houston and
Where's
all
my
them, man.
dogs at? Holly at me saying, "Bow Wow, yippee yo, yippee yay." Come on now, leave Bow Wow alone.
They had a little too feminine. I ain't gonna lie. Dude asked Omarion a question in an interview. Bow Wow jumps up and ready to fight because he don't like the question. That was the gayest thing I ever seen. Let that man just say that. And that it looked weird. It's like they living backwards. It's like they was living like adults back in the days, but now it's like they catching up to their childhood by how they act on video sometimes.
They ain't came out and asked no questions or nothing. I guess that could be a good thing. They don't need to ask any questions. Bow Wow.
I think she needs therapy and counseling.
Yes, absolutely.
So that she can transition back. Because you can hear how she.
Oh shit, Zach Ryder and came back to the. See, they lied and said that the LA Knights opponent was gonna be Joe Hendry. It was Zach Ryder. They done brought Matt Cardona back. Woo. Okay. WWE having a lot of old people back.
Man,
I still don't understand why they
man,
had
Triple H about to get fired, man.
He ain't going nowhere.
I don't understand that either. The whole universe mad about that right now. Triple H about to get fired.
He ain't going nowhere.
I don't know about this, man. Everybody, when you punch this up and see how many angry people are in the universe, they gonna get him up out of it.
No, that just makes that makes the ratings go up because people watch just to hate.
Which call no, the ratings have went down. They just had barely over 1 million people watching on Monday night.
Bruh,
Barely 1 million.
Triple H ain't going nowhere. As long as people tune in and type and give engagement to hate on him, that's good for the product. Bad
Where's his
publicity is just as
storylines
good
at? This crap is boring. MoneyBoy, this crap is boring.
Well, I haven't been keeping up with all of it, but I mean it's typical WWE.
It's bad. Ever since that Royal Rumble, like that Royal Rumble last February, from then to now, man, they lost so many viewers. It's bad. We watching the same people every week doing the same matches. Nobody's growing. They're not using everybody.
That's what we did during the Attitude Era. How many times did we see Triple H versus The Rock versus Mankind versus Stone Cold? It is what it is. That's the formula to wrestling. But guess what?
Not on the weekly shows though. You get that every once in a while.
You still, bruh, we saw The Rock and Mankind fight each other damn near every week. And Triple H was thrown in there too. And you still tune in to watch. No matter how bad you say it is, you have not cut it off because you know what's going on.
I don't know though, man. I don't know about this, man. It's bad.
I'm waiting on Brock Lesnar to pop back up.
He should be done. Nobody.
He's gonna be at War Games.
Yeah, he beat the hell out of John Cena and walked off, and it's like, why even come back? Is that? I guess that's how you gonna send John Cena away. So it's like, like nothing changed. I'm gonna just beat you up
Maybe
like
that's
I did
gonna be his
always.
last opponent. Maybe that's who's going to be his last opponent, so he can get redemption. Because you know they
That
still
don't.
got a lot. They still got a lot of mystery people to be in their tournament. So maybe he's going to be John Cena's last opponent. We haven't seen everybody fight in the tournament yet. Okay, Judge Hatchet, what we got?
Oh, shucky ducky.
All rise for the jury.
Let me turn this freak off.
Wait, bring a seat. Please be seated, Your Honor. The jury's all present and accounted for.
Back on the record, C 377239, State of Nevada versus Devyn Michaels. In the record reflect that Ms. Michaels is present with her attorneys. Deputy District Attorneys, on behalf of the state, we both parties stipulate to the presence of our jury.
Yes, Your Honor.
All right, ladies and gentlemen of the jury, has the jury selected a fourth person? Okay. And Mr. Gilbert, Mr. Foreperson, has the jury reached a verdict?
Yes.
If you could pass the verdict form to the marshal. All right, the clerk will now read the verdict into the record.
District Court, Clark County, Nevada. State of Nevada plaintiff versus Devyn Jade Michaels, aka Devyn Willett, aka Nikki Fairchild, aka Tracy Baker, aka Tracy Nicole Tavares, defendant. Case number C-23-377-239-1, Department 10. Verdict. We, the jury, in the above entitled case, find the defendant, Devyn Jade Michaels, as follows. Count 1, murder with use of a deadly weapon. Guilty of first-degree murder with use of a deadly weapon. Dated this 14th day of November, 2025, signed Aaron Gilded. Ladies and gentlemen of the jury, is this your verdict as read? So say you one, so say you all?
Yes.
Does either side desire to have the jury polled?
No, Your Honor.
All right. Ladies and gentlemen of the jury, I want to thank you very much for the time and attention that you paid to this matter. The right
She going to jail!
It's a right that's guaranteed in the Constitution, but it's a right that we cannot provide without our citizens like you being willing to sit and serve your civic duty as jurors. I do appreciate the time that you gave this matter, so on behalf of the court and the parties, I want to thank you for the time and attention. I know that this was a lot that we asked you to do, so if you guys could follow the marshal to the back, and I will come back and formally excuse you from jury duty.
All rise for the jury.
Guilty! That nigga guilty! Is she crying? Bitch, you should have took the deal. You should have took the 10 to 15, the 7 to 15.
Division of probation set down for sentencing on
January 8th at 9 a.m.
That's one of them loud fools over there by the camera.
Thank you. And I'm gonna go back and talk to the jury and the lead.
Got a weeping Wanda over there.
See you guys, I'll come back and make that. It's late, I'm gonna not really ask you to go.
Thank you.
Boy, she lost some weight.
All right, y'all. That's all we got. To the next episode. This channel. Big boy. We out.
January 8th sentence. Right.
I don't care about the sentence. Oh no. Wrong button. Wrong button. I was about to just straight up leave the studio and not end the damn live. That's crazy. Wrong button.
Peace.
Low key, niggas hating, but they don't want no beef. State gang, true sippers, bitch, I bet we gon' eat.